여러분 안녕하십니까?
Good morning.
2021 국제 특허법원 콘퍼런스에 오신 것을
Welcome
진심으로
to
환영합니다.
2021 International
저는
Court
오늘 개회식의
Conference.
사회를 맡은
Today
특허법원의
I
정의용
will be the
판사입니다.
moderator. I am
국제
Judge
특허법원
Chong
콘퍼런스는
Hee-yong.
올해로 제7회를 맞이하였습니다.
This is the 7th
이렇게 뜻깊은
IIP
행사의
Court
사회를 맡게 되어
Conference.
무척
It is an
영광입니다.
honor
그럼
to be the
지금부터
moderator for such an
2021 국제
meaningful
특허법원
event.
콘퍼런스의 개회식을
So now we
시작하겠습니다.
will begin the opening ceremony.
2021 국제 특허법원 콘퍼런스는 코트,
The
IP and
conference
하모나이제이션이라는 주제로 세계
is
IP
held under the
전문
topic of
법관들과
court IP
전문가들이
and
경험을
harmonization,
공유하고
and we are
상호
joined
이해를
by
촉진하기 위해
experts and judges from around the world to
아쉽게도
share
작년에 이어
experiences
올해
and
역시
insights.
코로나 상황이
Unfortunately,
지속되고 있어
as we did
완전한
last year,
대면적
we
학술
are
교류
still
행사의
going
형태는
through the
이루어지지
COVID
못했습니다만
pandemic, and
지금 이
we are
자리는
holding a
여기 계신
virtual
현장
conference, but
참가자분들
still,
외에도 전 세계
here
10개국 법관 및 IP
on
전문가들이
site we
온라인
have
생방송 또는 사전
IP
동영상으로
experts
자리를 함께
from
하고
around the
계시며
world
국내의
joining
많은 온라인
from
참가자들이 본
the
행사를 지켜보고
online
계십니다.
platform.
시간 관계상 일일이
Due to time
소개해드리지 못하는 점
constraints,
양해
please
부탁드립니다.
understand that I cannot introduce each and
이어서
every one of the
2021
participants
국제
in
특허법원
detail.
콘퍼런스의 홍보 영상 시청이
So we will
있겠습니다.
watch a video for the promotion of this conference.
올해 컨퍼런스의
The
주제인
meaning of
Court
court IP and harmonization, which is the subject of this year's conference, and the past, present, and future of the patent court were well captured in the promotion video. I currently work for the patent court, so it made me very proud and I was very moved watching the promotion video.
그러면 제7회 국제
So
특허법원
now I would
컨퍼런스의
like
첫
to
문을 열어주실
introduce,
특허법원
the
이승영 법원장님의 개회사가
speaker for the
있겠습니다.
opening
큰
remarks,
박수로
Lee Seung-young, the Chief Judge
모시겠습니다.
of the Patent Court. Please give him a round of applause.
안녕하십니까?
Greetings, everyone.
저는 대한민국 특허법원장
I am
이승영입니다.
Sung-young Lee, the Chief Judge of the Executive Court
2021년도
of Korea.
국제 특허법원 컨퍼런스에 참여하시는
I'd like to
여러분을
extend my warm
진심으로
welcome
환영합니다.
to all of you attending the
올해로
2021
제7회를
International
맞이한
IP Court Conference.
국제 특허법원
This year marks the
컨퍼런스는
7th anniversary of the International IP Court Conference.
처음 개최된 이래
Since its inauguration
세계
in
특허 소송의 주요
2015,
쟁점에
the
대한
conference
실무를
has
논의하기
brought
위하여
together renowned
여러
IP
나라의
court judges and experts from
IP
around the
담당
world to discuss
법관과
in depth
전문가들을
key
초청하여
issues and practical
각
affairs
주제에 대한
relating to
심도
IP
깊은
litigation.
토론을 이끌어내는
And
IP
now,
분야의
the conference is recognized as the world's leading forum for international academic exchanges in the IP sector.
작년에 이어 올해에도 코로나19의
There is no doubt that the global COVID-19 pandemic posed daunting challenges to all of us last year and yet again this year, preventing many countries from engaging in active in-person interactions. Yet, we have all come together here using various means, including a virtual platform enabled by science and technological advancements.
올해 컨퍼런스의 주제인
This year's theme, Court, IP, and Harmonization,
지식재산권과
was
관련하여
selected to compare and understand how different countries around the world are addressing the IP-related confrontations and animosities between countries, generations, and functions, as well as underlying conflicts coming from economic, cultural, and value-related
어떠한 방식으로 노력하고
differences.
비교법적으로 고찰할 수 있는 자리를
So
마련하고자
this is indeed
선정되었습니다.
a very good opportunity to look into these issues.
이와 같은 대주제 하에
Under
올해 국제
this
특허법원 컨퍼런스
grand theme,
11월 10일과
we will discuss various topics for 2 days from November 10th to 11th. We'll first look at the recent trends in IP litigation in different countries,
이어서
and then
코로나19 백신 개발과
talk about
관련하여
how other countries are
특별히
granting
관심이 집중되고
compulsory
있는
licenses, a
강제
topic
실시권
that has
제도에
garnered
대한 여러 나라의
much attention
운용
recently with the development of COVID-19
4차
vaccines.
산업혁명 시대를
And then
대표하는
we'll look into how other countries are dealing with the patent law issues relating to artificial intelligence.
컴퓨터 프로그램에 대한 여러 나라의
Afterwards, we'll move on to
저작권,
how countries are protecting computer program
법적
copyrights.
그리고
We'll then
사용자와
discuss
종업원의
how to
이익
strike
조화를
a
모색하기
balance
위한
between the interests of employers and employees
직무
with regard to
발령령
employees'
관련
inventions.
논의를 순차적으로 진행한 다음
And so, after
한국,
proceeding in this
독일,
order,
일본의
the
IP
conference
전문 법관들로
will
구성된
culminate with a moot
고위중재
arbitration
행정부에
session where IP court judges from Korea, Germany, and Japan will come together and come up with the most reasonable way to work out the compensation for the inventor in a hypothetical case.
오늘 영상으로 축사를 보내주신 존경하는 김상환 법원 행정처장입니다.
Kim Sang-hwan, who is the
이상민 국회의원,
Minister of National Court Administration and also to Mr. Seo Byung-soo, we would like to thank you for your welcoming remarks, and also we would like to thank Michael Almond, the Assistant Director General of WIPO, and also Sang Jo-jong, Chairman of Presidential Council on Intellectual Property, for your keynote
2년
speeches.
가까이 이어지는
The
코로나
pandemic
팬데믹으로 인해
that has lasted for almost 2 years is making things
시간적,
tougher
장소적
around
차이에서
us.
오는 온라인 참가의 어려움에 불구하고
Yet, many IP court judges and experts from Australia, China, Germany, India, Japan, Switzerland, Turkey, the UK, and the United States were undeterred by the inconvenience of virtually participating from various different time zones.
IP 담당 법관과 전문가들께 이 자리를 빌려
So I would like to
다시
take this
한번
opportunity
감사의
to extend my
말씀을
deepest gratitude to all of you once again for being here to provide your invaluable input and
세계 여러
support.
나라의
I believe that
IP
the International
담당
IP Court Conference
전문가들
will
사이에
develop into a
지혜와
pivot
경험을
of the international network
소중한
where IP
국제
court judges and experts
중심으로
around the world
발전해
share their
나가기를
wisdom and
희망하면서
experiences. I
바쁘신
hope that all of you
함께해
have a
주신
truly fruitful
참가자
and
여러분들
mobile time
모두에게
here at the
이번
conference.
컨퍼런스가
I
참으로
thank you
유익하고 오래도록 기억에
for taking time
남는
out of your busy schedule to attend today's event. I hope you enjoy today's program. Thank you very much.
네, 이승영 법원장님 감사합니다.
Thank you, Lee Seung-young, Chief Judge of the Patent
다음은
Court, for your remarks.
김상환
Moving
법원
on,
행정처장님의
we will
축사가
hear
있겠습니다.
congratulatory remarks from Kim Sang-hwan, the Supreme Court Judge and Minister of National Court Administration. He wasn't able to participate in person, but he sent us a pre-recorded video.
안녕하십니까?
Greetings to you all.
법원 행정처장을 맡고 있는
I am Sang-hwan
대법관
Kim,
김상환입니다.
Supreme Court Justice and the Minister of National Court Administration. It is my honor to deliver congratulatory remarks for the 2021 International IP Court Conference on behalf of the Judicial Branch of Korea. Congratulations once again on the opening of this conference.
2015년 처음 개최된
I am pleased to see that the conference has grown every year since 2015 to become a venue for exchange and communication among IP specialized judges in the world.
기쁘게 생각합니다. 이번 컨퍼런스는
This year, the conference is held both online and offline as in last year because of the COVID-19 pandemic.
먼저 귀한 시간을
First of all,
참여해 주신
I want to extend my gratitude to experts from home and abroad for joining us in spite of busy schedules.
시차와 거리를 극복하고
Many decided to join us online despite time zone differences and long distances. I want to express my sincere gratitude to the judges and experts from many countries. As you are well aware, the pandemic has caused concerns about infectious diseases and brought challenges that prevent us from meeting others and having close communication in person.
건강과 생명은 물론
We are facing an unprecedented crisis in all aspects, from human health and life to socioeconomics.
그러나 역사를
Nevertheless, history is a continuation of challenges and responses.
치료제 개발과
We are overcoming the crisis through developing a COVID-19 treatment, vaccination, and global response and cooperation.
나가고 있고 가까운
We
시일
expect to return to normal in the near future.
이러한 의미에서 코트 IP
The theme of this conference, Courts, IP, and Harmonization,
이슈가 되고 있는
comes from this background. We will discuss issues that involve patent rights and the COVID-19 vaccine development and explore different cultures and rules in each country. We will also discuss disputes and solutions, which makes this conference very timely and pertinent.
지식재산권은
IP rights have led the advance of technology and culture, resulting in prosperity and humanity. If there are institutional or cultural disputes that happen in practice, I firmly believe that experts and practitioners from different countries can share wisdom and join efforts to find sensible solutions. We are joined by IP experts who will participate online and offline to share experience and wisdom. I believe this very fact embodies the theme, court, IP, and harmonization very well. The conference is held today and tomorrow. The IP experts around the world will join in-depth discussion in various topics. This will be the foundation to enrich and harmonize lives of humanity. In addition, I wish that the success of the 2021 International IP Court Conference will enhance the ties and cooperation among IP courts all over the world. Many people took time out of their busy schedules to participate. Chief Judge Seung-Young Lee and others put great effort into this fruitful and safe conference. I would like to extend my gratitude to all of them once again. I wish health and happiness. Thank you.
다음은 2021
Next,
국제 특허법원 컨퍼런스의
to wish for the successful holding of the 2021 International IP Court Conference. Many people sent their congratulations. So National Assemblyman Lee Sang-min and Seo Byung-soo sent their video messages. We will hear the video message from National Assemblyman Lee Sang-min first.
국회의원 이상민입니다. 제7회
Congratulations on the opening of the 7th International IP Court Conference. It is meaningful that the conference is held in a mixed form of online and offline under the difficulties due to the COVID-19 situation. My special thanks go to Chief Justice Myung-soo Kim of the Supreme Court of Korea for his support, and Chief Judge Seung-Young Lee and judges from the Patent Court of Korea, as well as all the organizing members who have worked hard to hold this conference. I'd like to express my appreciation to judges and legal experts from the US, China, Germany, the UK, Australia, Switzerland, Japan, Turkey, and India for joining the event over the internet. And I'd like to thank all on-site participants also. The International IP Court Conference has become one of the representative and leading international events for academic exchange in IP since 2015. Under this year's theme of court IP and harmonization, I believe the conference will provide a great opportunity to share the wisdom and efforts of each country to address conflicts and disputes related to intellectual property in a reasonable manner. Most of all, discussions on compulsory licensing and artificial intelligence is highly timely and interesting. It is all the more relevant as Daejeon City is a mecca for those working in science and technology fields where not only IP-related government agencies such as the Korean Intellectual Property Office, the Intellectual Property Trial and Appeal Board, and the International Intellectual Property Training Institute, but also tens of advanced research institutes, including KAIST Chungnam National University, are located. Once again, as a co-chair of the World Intellectual Property Hub Promotion Committee and the Fourth Industrial Revolution Forum of the National Assembly, I congratulate the opening of the 2021 International IP Court Conference, and I wish all participants of the conference health and happiness. Thank you.
다음으로 서병수
Next, the
국회의원님의
National
축하
Assemblyman
영상을 시청하시겠습니다.
서병수 has also sent a video message. We will watch it together. Honorable Chief Judge Sung-Young Lee, IP Specialist Judges, experts from both home and abroad, distinguished guests, greetings. I'm Byung-soo Seo, a member of the People Power Party in the National Assembly from Jingu, Busan City. It is my honor to deliver congratulatory remarks for the 7th International IP Court Conference. I would like to welcome IP specialist judges, professors, and legal experts who are joining the conference via online. Also, although COVID-19 persists, there have been efforts to clarify issues linked to IP rights. And I would like to express my respect to the judiciary and the Payton Court of Korea for their continuous efforts to gather insights from globally renowned experts. The 21st century is characterized by rapidly changing science and technology. With the advancement of science and technology, the importance of IP rights is increasingly growing. We're also witnessing more complex disputes and conflicts in the IP area. As a co-representative of the National Promotion Committee for the World Intellectual Property Hub for the 21st National Assembly of Korea, I truly understand that IP is crucial and that we must resolve disputes and conflicts. These are prerequisites for a sustainable society and its development. Going forward, I will continue to study policies related to IP and also focus on legislative activities for the development of IP rights. I hope this conference will serve as a venue to identify global standards of IP lawsuits with reason and harmony. And I also wish the conference a resounding success. Thank you very much.
바쁘신 일정에도 불구하고 본 행사를 위해 축하
I would
영상을
like to
보내주신
thank
의원님과 서병수
Honorable
의원님께
Assemblyman
다시
Lee Sang-min and
한번
Seo
감사의
Byung-soo for
말씀을
sending
드립니다.
pre-recorded congratulatory remarks despite their busy schedules. This brings us to the end of the opening ceremony of today's conference, and we will kick off the actual conference with two keynote speeches. Our first keynote speaker is the Assistant Director General of World Intellectual Property Organization, Marco Elleman. Dr. Elleman was a practicing IP rights attorney since 1995, and from 1999 he joined the WIPO in Geneva, Switzerland, and he now is the Assistant Director General of WIPO, where he leads the IP Innovation Ecosystem Department. We will watch his keynote speech.
Honorable Minister of National Code of Administration,
존경하는 김상환 법원
Honorable
행정처장님,
Member of the National Assembly of Korea, Lee
존경하는
Sang-min and
이상민,
Soo Byung-soo,
서병수
Honorable
의원님,
Chief Judge Lee Sung-jong of the
존경하는
Patent Court
이승용
of Korea,
특허법원장님,
Honorable Professor John Sen-jo, Chairman of the
존경하는
Presidential Council on
국가지식재산위원회
Intellectual
위원장
Property,
정상조
distinguished
교수님,
judges and dear
존경하는
friends.
국가님, 그리고
It
내일
is a
기빈
great
여러분,
honor for me to address you at this
제7회
7th edition
국제
of
특허법원
the
컨퍼런스에서
International
기조연설을
IP
맡게 되어
Court
큰
Conference.
영광으로 생각을 합니다.
I thank the Patent Court of Korea
이
for the
자리에
invitation
연사로
and
설
the
수 있게
opportunity
초청해
to
주신
address you.
특허법원에 감사의 말씀을
The
드립니다.
Patent Court of Korea, established in 1998, is one of the
1998년도에
first
개원한
specialized
특허법원은
IP courts
아시아
in Asia.
최초의 지식재산 전문 법원 중 하나로 계속해서
It
혁신을
introduced
이어나가고
an
있습니다.
international division in 2018,
2018년도에는 국제재판부를 설치하여서 외국어 변론과 서면 제출이 가능하도록
The goal
하였습니다.
is to provide affordable
목표는
and convenient
한국
judicial
지대
services
소송에서
to
비중이
foreign
점점
parties
커지는 외국인
whose
당사자에게
presence
적정한 비용으로
is growing
편리한
in
사법
IP
서비스를
litigation in the
제공하고자
Republic of
설치된
Korea.
것입니다.
The patent court's openness to the world is
세계를 향해
also
열려
seen
있는 특허법원의
in this
면모는
IP court conference,
이러한
which is running in
특허법원
its seventh edition.
컨퍼런스에서도 잘 나타나고 있는데요. 올해로 제7회를 맞이하고 있습니다. 전 세계 유수의 법률 전문가들께서 식견을 나누고자 함께 해주셨습니다. 아시다시피
IP and harmonization.
올해 컨퍼런스의 주제는
As you
Court
know,
IP
WIPO is a
Harmonization입니다.
global convener
잘
for the
아시겠지만
discussions on intellectual property
193개
matters,
회원국을 보유한 와이퍼는 IP에 관한 국제적인 논의에 장을 열어 글로벌 IP 규범을 세우고 조화를 이루어 나가는 기구입니다.
193 member states. Since the 1883 Paris Convention for the Protection on Industrial
1883년
Property
공업 소유권의
and
보호를
the
위한 파리
1886
협약과
Berne Convention for
1886년
the Protection of
문학 예술적
Literary
저작물의
and
보호를
Artistic
위한
Works,
베른 협약은
those
19세기
express the desire for harmonized legal protection of intellectual property work in the face of the globalization resulting from the transport and industrial revolution in late 19th century. The broad historical trend toward harmonization and integration of the IP system at the multilateral level has slowed down in recent decades owing to difference among the interests of stakeholders in the system. We can observe a move away from multilateral solutions toward regional and bilateral approaches, as well as to different plurilateral efforts. Even in areas where there is convergence in laws and governed by international treaties, important difference may remain in domestic law and more so in the application and interpretation by the court. The series of Dabus rulings that is currently in the limelight is a very good example. It concerns a patent application filed in some 17 jurisdictions where Dabus, an artificial intelligence machine, is named as the inventor. CAIPO and a number of other IP offices, such as the European Patent Office, the USPTO, the UK IP Office, refused the patent application. Unsurprisingly, the case is now being litigated in courts in different jurisdictions. The Federal Court of Australia issued the first judicial ruling on this question in July of this year, deciding that an artificial intelligence system can be recognized as the inventor for patent purposes. The UK Court of Appeal and the US District Court for the Eastern District Court of Virginia decided in September and in October respectively that an inventor must be an individual and rejected the patent application. So while much has been achieved in terms of harmonization in the area of substantive intellectual property law, there is place to accommodate difference. The difference are more apparent in the judicial application and interpretation, which are inherently national and territorial. The sovereignty of national judicial structure and the intimate connection with the territory would make it unsuitable to address harmonization in the context of the core. Instead, we may talk about global judicial dialogue, which may take different forms. When a court is tasked to resolve a novel IP question, the court may monitor, review, and be informed by foreign judgment that address similar legal programs. And in appropriate circumstances, cross-reference to the foreign may be well appropriate. And the cross-pollination of judicial approaches will help not only when the reasoning of the other court are accepted, but also when courts depart from the approach of foreign courts. There are important reasons why the solution developed in one jurisdiction may be inappropriate elsewhere. Achieving coherence and mutual respect between divergent legal system and distinct judicial structure through information exchange, while preserving judicial independence in domestic adjudication, is crucial for the predictability and legitimacy of national judiciary. This is the approach promoted in the WIPO work with the judiciary, and with a program of cooperation and exchange of information and experience among judges that have been put in place. This year, WIPO IP Judge Forum expects some 400 judges from 80 different countries participating, and I really look forward to seeing many of you there. WIPO will continue to engage closely with the Patent Court of Korea and with the judges participating in the IP Court Conference to support an effective and balanced approach to IP adjudication that is suited to the domestic framework of each country and at the same time respond to the demands of the modern interconnected global IP ecosystem. Thank you for your attention, and I wish you a stimulating discussion over the next 2 days.
다음으로 국가지식재산위원회 정상조 민관위원장님이 기조 연설을 해주시겠습니다. 정 위원장님은 서울대 법대 교수로 지식재산권법 연구와 강의를 하고 계시고 서울대학교 법과대학장 및 법학대학원장을 역임하셨으며 각종 정부의
And
정책
he
기반,
has
운영에
been
관한
serving as an
지원 활동을
advisor
계속적으로 수행하고
to the policymaking functions of the Korean government. And then currently, he is the private sector chairman of the Presiding Council on Intellectual Property. I'd like to now invite Chairman Jung for his keynote speech.
우선 마스크 벗고 우선
First and foremost, congratulations on the opening of the 7th 2021 International IP Court Conference.
초청해 주신 이승영
I'd like to thank Judge Lee Seung-yong for inviting me to speak at this conference.
코로나 위기 속에서도
Amidst the COVID-19 crisis,
세계 국내 그리고 해외
we are joined by
판사님들
honorable judges, professors, and attorneys from home and abroad as panelists for today's event. I'd like to thank all of them. It is my great delight to be joined by their presence.
어려운 여건에도 불구하고
Despite
특허법원이
this difficult circumstances,
콘퍼런스를 개최해서 이제
Patent Court holds this conference every year. So,
법관들이
now the conference has established itself as an international forum where judges in Korea and abroad share their experiences and information, deepening their mutual understanding.
이번 컨퍼런스는
This year's conference aims to search for wisdom needed to address the IP-related disputes
찾기 위한 것으로 알고 있습니다.
based on insights
전 세계적으로 경제적인
around the world.
가치관의
Many conflicts are emerging due to economic, cultural, and value
이번
differences.
컨퍼런스가
This is why I believe it is very timely that harmonization was selected as the theme of this year's conference.
원장님께서 좀 시간을 여유 있게 주셔가지고 제가
Well, I was allotted ample time by the chief judge, so I prepared a rather long speech.
이쪽으로. 예, 감사합니다.
Thank you.
최근에 첨단 기술 분야에서 핵심
In the
지식재산을
recent cutting-edge
둘러싸고
technology field,
미국과 중국의
the hegemonic competition between US and China
냉전에
is intensifying. It is even dubbed as the new Cold War by some. Also, whether IP rights for COVID-19 vaccines should be waived, this became a hotly debated topic among countries with different interests. Intellectual property is not just an economic or commercial matter, but a matter of national security and public health. For this reason, conflicts among nations surrounding IP issues are escalating. Enforcement of IP rights is gaining much attention from around the world. Conflicts among nations can be addressed by signing treaties to achieve harmonization among different IP laws. Advanced and developing countries have signed WTO and TRIPS to agree on the minimum level of IP protection, thereby achieving such harmonization. Meanwhile, there has also been a movement to sign bilateral or regional treaties to secure a higher level of IP protection, as some countries were not satisfied with the level of protection ensured by the WTO. At the same time, intensifying conflicts among nations have put the WTO system itself at risk. The WTO has revealed its incompetency in dealing with IP disputes between nations. And the organization is also criticized for getting in the way of utilizing essential medicines for public health. 20 years ago, for public health, the WTO TRIPS made the Doha Declaration allowing compulsory licenses of patent rights on essential medicines for public health. Nevertheless, there is still a long way to go to put into practice patent waivers, compulsory licenses, or trade secret disclosure for the COVID-19 vaccines. Immediately after the Doha Declaration, the then U.S. Bush administration came to realize that AIDS treatment is an important initiative for public health, investing for the treatment of AIDS treatment, investing almost 18 trillion Korean won, which is close to 15 billion USD dollars, for the use of generic medicines. The U.S. government launched the United States President's Emergency Plan for AIDS Relief, PPFAR, and has so far allocated roughly 100 trillion Korean won to the plan, leading the AIDS prevention and treatment efforts by 50 countries. As a result, they were able to save close to 20 million people's lives. The PPFAR has not taken any stance on compulsory licensing of patent rights of medicines, but it practically allowed it practically allowed the use of generic medicines. Had it not been for that initiative, saving those 20 million lives would have been impossible. In order to effectively respond to the 21st century's biggest crisis, COVID-19, we should address the challenge of putting the Doha Declaration into action for effective response. It is clear that, in fact, many governments have developed vaccines through heavy investment. It normally takes around 15 years, but this time, in response to COVID, vaccines were developed in merely 1 year. It shows the wonderful accomplishment in science and technology that humanity has achieved. containing the spread of coronavirus quickly is an essential task in the best interest of the entire humanity. In this regard, India, South Africa, and many member states have been arguing that the WTO should apply temporary patent waivers to COVID-19 vaccines and drugs. Nevertheless, despite the Doha Declaration, most of the advanced countries that develop vaccines and cures are still standing in the way of patent waivers and trade secret disclosure. Patent rights do promote the development of vaccines and treatments, but at the same time, it can also hinder the extensive use of vaccines and treatments. This is why we need a balance between patent right protection and broad use of technology, and we're in a dire need of wisdom to harmonize different interests of different countries. IP rights designed to promote invention and creation are fundamentally different from the ownership of an object. IP laws inherently are framed to have balance and harmony to achieve certain legal purposes. The Patent Act not only stipulates provisions on patent right protection, but also exceptions for the purpose of compulsory licensing, research, and testing. In the same vein, the Copyright Act also prescribes not just the copyright protection, but also the provisions on fair use and limitations on copyrights. But whether such provisions and exceptions are actually realizing the balance that we are aiming for, this remains questionable. The regulations and exceptions are difficult to harmonize, in large part due to the COVID-19 pandemic. The COVID-19 pandemic upended our lives and brought upon an accelerated digital transformation. Well, lectures in colleges, music concerts were canceled, and they were replaced by a virtual, non-contact forms of lectures and concerts. Now, we no longer go to actual theaters to watch movies, but do so over our phones at home. And with less personal contact, we started talking with chatbots instead of actual human beings. Rather than going out to restaurants, we prefer to order in our meals. Rather than shopping at brick-and-mortar marts or shopping malls, we are moving to online platforms to order what we need. And COVID-19 has also ironically stimulated the advancement of science and technology for the vaccine development. Such changes are all common in the fact that AI lies at the very center of all this transformation. It wasn't the actual virus, but the cutting-edge AI technology that has brought upon such groundbreaking changes to our lives. AI is becoming smarter because it learns a large amount of data. All of you judges have studied arduously to become judges, but AI, in order to perform tasks, they read a larger amount of data and employ self-learning. AI was able to draw this painting of Edmond de Bellamy because 15,000 pieces of artwork was learned by the AI, which would be impossible for a human painter to do. Also, in order to hold casual conversations between lovers, this robot has learned 10 billion conversations. Oxford, Cambridge, Harvard, Stanford, Yale, the libraries of all these prestigious colleges with 25 million books were scanned, and this was all learned by the AI, and 5 billion search results are being learned by AI in real time every single day. As we are transforming to such non-contact way of living and use of AI, the issues of fair use surrounding such AI technology remains very cloudy. The current IP law provisions and limitations on rights are far from striking the balance. Many are questioning the effectiveness of the current system applied to AI. Copyright, trade secret, database rights are all rights and claims that are in our legal system currently, but limitation of rights is very unclear. Well, our copyright 10 years ago, as the US did, introduced a general provision on fair use in order to strike a balance between protection and use of copyright. But in reality, provisions on fair use being applied to a new technological environment is a new challenge that is difficult for us to respond to and foresee, because the nature of the problem itself may change. This is before the introduction of fair use provision, but to aid searches, unauthorized collection of photo images to create a thumbnail to be provided to internet users was a case that was addressed. The Korea Supreme Court ruled that the thumbnail image would serve the public interest in a way that it was not used for its artistic or aesthetic value, but to provide the internet location information of the photo, thereby making searches more convenient. The court found that although such thumbnail image was provided for commercial purposes, it still constitutes fair quotation, fair use. Even though this Supreme Court ruling was on fair quotation, it is interpreted to be acceptable as the judging criteria for fair use as well. AI is significantly increasing the volume of data that can be utilized. Businesses are using data for commercial purposes, and despite such for-profit usage, there's still no clear rule on what kinds of data used by AI constitutes fair use. According to the U.S. court rulings, transformative use is considered as a critical element. There was the Google case where the U.S. Court of Appeals found that the act of scanning, such as the 25 million books that were scanned, and digitalizing and using of a copyrighted work for book search purposes constitutes transformative use and is therefore considered as fair use. Transformative use is also considered as an important element in determining what constitutes fair use in Korea. This is what I expect. However, it is still unclear whether Korean courts will deem artificial intelligence's data analysis as transformative use. No one can be sure of how it will play out. Well, such uncertainty surrounding the issue of fair use, a number of assemblymen proposed a bill to amend Korea's Copyright Act. If a value can be added by analyzing a large amount of copyrighted data, copying or transmitting such data shall be considered as fair use within the scope necessary for data analysis, and thus is not infringement of copyright.
데이터를 공정 이용하는 것이
So fair use of data for data analysis,
즐기는 것이 아니라
if it is not in order to enjoy the idea or emotions contained in that data, but is simply used for analysis, then it would fall under the scope of fair use. For it is important to distinguish between the two cases, which is close to what the Japanese Copyright Act has in place. But this is only limited to the cases where the data can be lawfully accessed. Therefore, if spiders or crawler bots surf the internet, whether their free access of data also falls under this category remains unclear.
데이터의 활용이 중요하다고 보고 저작권법 개정안을 제출한 의원들이 있는가 하면
Unlike these lawmakers who propose to amend the Copyright Act, recognizing the importance of data utilization, other lawmakers believe that we need a much stronger data protection. These lawmakers place more emphasis over protection, on protection over utilization, and have also proposed many bills to that effect. These lawmakers tabled a bill to amend the Unfair Competition Prevention Act to expand the legal protection of data. If a significant amount of data on technology and business is collected and managed electronically, any unauthorized use of such data should be deemed as an act of unfair competition, and there is no exception allowed in the amendment for data analysis purposes. So, there are at least 5 bills that are pending with relation to this issue. If these are actually legislated, then a potential overprotection could lead to undermine the utilization of data. So we would have to keep a close eye on which bills will actually be legislated and how they may be amended, reflecting the actual needs in practice. Well, balance and harmony in the area of IP laws become more important in the context of criminal punishment against IP infringement. This is because criminal punishment has more far-reaching impact on invention and creation than a civil liability. The bloody code may undermine the balance and harmony in IP law, and this is a phenomenon that may be unique to Korea. The Korean Supreme Court recently ruled that even an act of providing an internet link can be punishable when it aids and abets a violation of public transmission rights. Is this really culpable as aiding and abetting a violation of public transmission rights? Has a different nature, I believe. There are websites where music or movies are posted without obtaining consent from the copyright owner, and if you provide a link to such website to gain advertisement earnings, knowing that posting on such a website is an act of infringing the copyright, the provision of rerun services, such an act constitutes aiding and abetting copyright infringement according to the ruling. However, a link is a key means of sharing information and enjoying freedom of expression on the internet. Therefore, utmost caution should be paid when a link is used as a ground for determining an offense of aiding and abetting a crime or a joint illegal act. Korea's Supreme Court also clarified the requirement of willfulness in order to recognize an offense of aiding and abetting copyright infringement by using a link. And there should be sufficient knowledge of the fact that the principal offender is infringing the copyright. However, interpretation of this willfulness requirement is a tricky issue. So, compared to other advanced countries that take great caution when enforcing criminal punishments against copyright infringement, Korea's copyright law and court rulings seem to be leaning more towards protection of copyrights, which makes us wonder whether we are truly realizing the right balance. There has been criticism that the Korean courts underestimate damages and damages claims relating to IP right infringement. Failure to recognize damages at a reasonable level could undermine the protection of IP rights. To address this problem through legislation, the KIPO amended the Patent Act, Trademark Act, Design Protection Act, and Unfair Competition Prevention and Trade Secret Protection Act to introduce punitive damages. Punitive damages are adopted by the US and many other countries as well. But we must keep in mind that these countries allow punitive damages in patent infringement, but do not enforce criminal punishment against patent infringement. We also have criminal punishment provision on patent right infringement. So, adopting punitive damages on top of that would be an extremely rare case. Probably the only case. And this could lead to consequences of double punishment or excessive sanctions. A proper next step would be to eliminate the criminal punishment provision, as we have the punitive damages provision in place. In order for our IP law enforcement to strike the right balance and achieve harmony, I think the courts need to be stricter in demanding and interpreting the willfulness requirement that I mentioned. Employees' invention is the topic of one of the sessions of this conference. Employees' invention is a difficult and important issue that requires effective coordination and balance between the interest of the employer and the employee. The employee's rights over employees' invention, whether it will be transferred to the employer and receive compensation, is to be governed by the agreement between the two parties. But the Korea's Invention Promotion Act stipulates that the employer is obliged to pay compensation to the employee, but the issue here is the amount of the so-called reasonable compensation. The employer's profit coming from the service invention, the compensation rate, the contribution rate of the employee are all factored into the calculation of the compensation. This directly affects incentives for invention for the employees. Therefore, it is critical to strike the right balance surrounding this issue. On the other hand, if there is no agreement or service regulation specifying compensations for employees' inventions, the employees have still the right to claim reasonable compensation. We cannot always forward such cases to the court, and it would make it difficult for the employer to foresee its profits. Therefore, we have to focus more on the actual purpose of the Copyright Act when dealing with such issues. The protection and utilization of data requires harmonization from around the world. Balance and harmony surrounding IP rights should not only be discussed domestically, but it is an issue that should be dealt through a global joint effort. At today's International IP Court Conference, I'm greatly honored to have honorable judges and attorneys and experts. I hope that input and insights from our renowned participants will greatly contribute to the realization of such balance and harmony in the IP law field. My speech was rather long, but thank you for your attention.
Chairman Chung, thank you very much. I think it was a very meaningful keynote speech that really cut through the very theme of this year's conference. It gave us a lot of food for thought. Once again, why don't we give him a big round of applause. We're going to take some time to organize a stage. Right after we set the stage, we will begin session 1. So we ask for your patience for just a little while. Thank you.
네, 착석 안내 들어갑니다. 시작하겠습니다. 자리 착석 부탁드립니다.
곧 1세션을 시작하도록 하겠습니다.
We will soon be beginning session 1. We would like to ask all participants on site to please take your seats. We will shortly be beginning session 1. We would like to ask all participants at the site to please take your seats. We will now begin session 1. Please take your seats.
지금부터 국제특허법원 컴퍼런스의 첫 번째 세션을 시작하겠습니다. 이번 세션은 IP 소송의 최근
We will now
동향이라는
begin session 1 of the International IP Court Conference. We will have Song Yeol-seo as the moderator. He's the chief presiding judge of the Payton Court of Korea.
큰 박수를
Please welcome him with a big round of applause.
예, 반갑습니다. 안녕하십니까? 오늘 제1세션의 사회를
So greetings. I'm Song Yeol-seo. I will be moderating session 1.
제1세션은 해외 주요 국가와
So
우리나라의
in the first session, we will be looking at the recent trends in global IP litigations in Korea as well as other major countries around the world. So this is the first session of the conference. Starting from session 2, we'll be looking to specific topics. But before jumping into this discussion, we'll be looking at the major changes in the IP status around the world as well as looking at the trend of major court decisions. Not only United States, but also Switzerland, Turkey, India. We'll be looking at recent developments in these countries, and so we'll be able to broaden our horizon internationally related to IP litigations. So we ask for your understanding. So I'm a very handsome-looking man, but because of the quarantine measures for the COVID-19, I would have to wear a face mask. So I do regret not being able to show my very handsome face to all of you. So let me introduce today's panelists.
여러분 온라인에 참석해 계신 분은 마음으로 큰 박수를.
So those of you taking part via online, please welcome everyone with a big round of applause in your hearts. So on my left is Taek-soo Chung, the High Court Judge of the Payton Court of Korea. So he has already said his hello, so I will omit that. And from the Law School of UC Berkeley, we have Professor Jeremy Fogel. And also we have Judge Elian Ince from Turkey, and also we have Prasifa Singh, the presiding judge of Delhi High Court, and also President Mark Schweitzer from the Swiss Federal Patent Court, who will be joining us through a pre-recorded video. We'll be skipping the detailed bio because of the time constraint, but I can say this, that all of our panelists have built up a brilliant career in the IP litigation litigation area in their respective countries. So please refer to their detailed bios in the booklet that has been handed out to you. And so there is a reason why these 5 panelists or 5 countries have been selected for the first session as panelists. Do you know why? It's actually related to one of the words that are included in the theme of this conference. I'll give you the answer at the very end of today's session. So let us jump into session 1. So in session 1, we will be dealing with broadly 3 topics. First is the trends and changes in major IP statutes in the countries, so the respective countries for the last 3 years. And also the second question is the trends of major IP cases for the last 3 years. And the third question is current legal issues or those expected to be hotly debated in IP. So the written answers of our panelists are all included in the booklet that has been handed out to you. So in this session, with regard to these 3 questions, among the written answers that you have already provided, you can highlight those parts that you believe are really pertinent, most important for this questions. First, we will invite our very first panelist, and it's Professor Jeremy Fogel from the United States. Professor Fogel, are you online? Greetings. Hello.
예, 교수님 제 말씀 잘 들리나요?
Professor Fogel, can you hear us?
예, 잠깐. 기술적인 문제가 교수님 아마 교수님 소리가
I think we have some technical problem here. There's a really huge echo from your part.
자, 교수님 반갑습니다. 혹시 제 목소리
Professor
잘
Fogel,
들리시나요?
can you hear me well?
저희들이 아마 소리가 들리지 않는데 스태프분들
We can't hear Professor Fogel. We do have technical staff with us, so please check the issue with the audio.
그럴까요? 예, 예. 포겔 교수님 아마 기술적인
Professor Fogel,
문제가
because of some
그래서
technical
저희들이
glitches,
기술적인 문제를 조금
we need,
해결할 때
while we are resolving this issue, please wait a while. So we will move on to the next panelist
예, 하겠습니다. 예,
and take care of this issue in between.
Okay, thank you.
네, 알겠습니다.
지금도 되는 것 같네.
Well, I think it's working now.
혹시 지금
Okay, is this good now?
yes. 예.
Yes,
예,
yes.
반갑습니다. 지금 많이 당황하셨죠? 예.
I'm sure you must have been quite taken aback by this problem.
I'm fine. I'm happy to be with you. And I just wanted to say for the first 15 seconds, I'm sorry I'm not with you in person. I was in Korea right before the pandemic started. I had an absolutely wonderful time. I was treated with such warm and wonderful hospitality, and I look forward to being with you again sometime when it's safe for that to happen. But I'm so grateful for the relationship that our institute at Berkeley has developed with the Korean judiciary, and thank you for inviting me. My 3 points actually all relate to the same general point, which is who is making the decisions in patent cases. As you know, the United States, along with the UK and Australia and India and a few other countries, is a common law jurisdiction. Most of the world is a civil law jurisdiction. And in our system, it's an adversarial system. So instead of the judge being the primary investigator of the facts, that is done through presentations by the parties. And the parties, because they have an interest in the outcome, don't always present the facts in the most objective way. So you get, in the same case, you might have one party painting one picture of reality and the other party painting another. And this extends to technical experts as well as other witnesses. The judges, on the other hand, in our system are generalists. They are not trained as technical experts. Very, very few judges in the U.S. federal courts have a technical background. A few more are experienced in hearing patent cases, but even so, you are limited by your understanding of the technology. I was a judge for 20 years in the federal court in San Jose. I heard well over 150 patent cases, and there were cases I simply didn't understand the technology, and I needed the help of experts to do that. And that creates an incentive for the parties to find experts who will present the facts in the light most favorable to them. So part of the solution to that problem in the U.S., and it's not a case law solution, or it was a statutory change that was made several years ago, was to create a stronger administrative review process for patents. So after a patent is issued, the patents can be reviewed by something called the Patent and Trademark Appeals Board, which is actually a very robust administrative body, and they have the technical expertise to review patents for obviousness, for other forms of invalidity, and that actually has been helpful in reducing the number of patents on the market that lack technical merit. And the people making those decisions are trained, as I said, in the technology. So that's been a major shift. I will say in a few minutes how that I think is somewhat in peril because of directions that our Supreme Court is taking. But I think that's probably the biggest change in the way IP cases are litigated in the U.S. in the last 3 years, which is the increasing reliance on administrative proceedings. The second point is that our courts continue to be struggling with identifying what is patentable subject matter. You know, what is a natural phenomenon and what is something that can be patented. And our Supreme Court has tried a number of times to define it. I think it's fair to say they haven't really succeeded in coming up with a definition that works all the time. Our Federal Circuit, which is the intermediate court, the appellate court that handles all patent cases by statute, they issued an opinion on patentable subject matter that had 11 different opinions. The judges came up with 11 different opinions as to how the case ought to be decided. So this continues to be a real struggle for us. And then the other one, which relates to who the decision maker is a dispute over where cases should be tried. This was in our system, it's called venue. It's the location of where cases are tried. And as you know, the U.S. is a big country physically. And the parties try to manipulate where cases are heard and by which judge. And there was a trend for a number of years that plaintiffs, people who were asserting infringement of patents, wanted their cases heard in Texas because the juries, and it's another way that we're very different. We have jury trials in patent cases. Juries in Texas were giving big verdicts for plaintiffs. And so people were trying to manipulate the venue rules so that they could have their cases heard there. And that, of course, has come under fire, and our higher courts have tried to attack that process. The Supreme Court issued a decision, and the Federal Circuit has issued some as well. So those are the issues that are being litigated frequently now. The one that I wanted to spend the last few minutes of my time talking about, though, is the role of technical experts. Because when you have a generalist court, like we do here, I never got a degree in science. I heard all those patent cases. I have no technical training at all, other than what I learned on the job. That the role of technical experts in helping courts decide cases is very problematic because, as I said, the parties are incentivized to choose experts who favor their point of view. The court has to decide which expert to believe in determining the scope of the claims. The jury has to decide what expert to believe when they decide the case, and they have no scientific grounding that enables them to do that. And so this has been a continuing problem. Some judges have even institutionalized it where they use the same expert over and over again so that at least they have a a regular court-appointed expert who gives them an opinion. But I think that the real challenge in a common law system where the judges are not technically trained is figuring out how to get reliable expert testimony. And that continues to be a big issue here. Administrative proceedings before the Patent and Trademark Appeals Board are a partial solution to that problem because those people do have expertise, and so they can give guidance as to the proper interpretation of patents and whether patents are valid or not. But as I was saying earlier, the Supreme Court has perhaps a majority at this point who, as a matter of philosophy, do not want to give administrative agencies a great deal of plenary power, and that may result in the role of PTAB and other administrative agencies being limited as a result of constitutional interpretations by our Supreme Court. And I think that's something that we'll need to watch very carefully going forward. I did want to comment on Judge Schweitzer's comment and question about people contesting invalidity later on in the proceeding. Is there ever a time limit for that? Can people keep changing their claims as things go forward when it appears that one particular set of claims may be invalid? And I think as long as the patent hasn't been cleared by the Patent and Trademark Office, as long as the administrative process is still ongoing, it seems to me people routinely change their claims in order to get them issued. And that's been true in patent prosecution all over the world. I think the question that Judge Schweitzer is asking is, once you get in litigation, can a party change the interpretation of its claims? Can they say, well, my patent doesn't really mean what I said it means something else? I think that's very problematic as a matter of fairness to the parties. I think it's very hard from an economic standpoint. It's very hard to rely upon patent rights if a party can keep changing what they mean and what the proper interpretation of those rights is. So I think that's a very dangerous road to go down. I don't think it would be possible in the U.S. I went back and actually looked at an old case of mine that I decided probably 15 years ago, and that issue came up. Looked like the patent was going to be held invalid. It actually did end up being held invalid, and the claimant tried to come up with a new we found a new benefit of our patent that we didn't claim, but it actually is a really good benefit, so we shouldn't have our patent invalidated for obviousness. I said, you can't do that. That's not, it's not fair to anybody, and certainly not people who are your competitors who might want to practice the same type of invention. And that was upheld by the Federal Circuit. So I don't think there's a lot of openness here to changing the interpretation of patent late in the day. So those are my comments, and I look forward to hearing from my colleagues from other countries. And again, thank you for inviting me to participate.
예, 포겔 교수님 감사합니다. 예, 몇 년간 우리 컨퍼런스에서 자주 언급됐던 특허 대상 적격과 특허 소송의 법정지 문제, 그리고 정정에 관련된 여러 가지 깊은 경험과 식견을 보여주셨습니다. 바쁜 업무 가운데서도 이렇게 참석해 주신 포겔 교수님께 다시 한번 감사드립니다. 그리고 아마 교수님께서 우리 보내주신 아마 프로필 사진을 아마 보시면 알겠지만 역대 컨퍼런스 중에서 가장 신비감이 뛰어난 프로필 사진이 아닐까 생각이 됩니다. 그래서 이 프로필 사진을 보면 대가의 자유로움이 느껴져서 저도 앞으로 프로필 사진을 어떻게 변경할까 하는 데 대한 영감을 받았습니다. 다시 한번 깊은 감사의 말씀을 드립니다. 마지막으로 개인적으로 I'm sincerely appreciate for your participation.
네, 다시 한번 참석을 해주셔서 감사드립니다. 머지않은 시점에
버클리 알럼나이.
네, 제가 또 버클리의 동문이기 때문에 네, 다시 한번 대면으로 판사님 만나 뵈시기 바랍니다.
하는데 제가 특정 팀을 응원한 건 아닙니다. 예, 다음으로 그러면 터키의 질리아 인제 판사님.
Now moving on, we will listen to the presentation of Judge Zilia Ince from Turkey.
인제 판사님 제 말씀 잘 들리십니까?
Judge Ince, can you hear me?
예, 바쁜 업무 중에도 이렇게
So despite your busy schedules, thank you for joining us as a panelist today.
가까운 시기에 한국에서 직접
I hope I will be able to meet you in Korea in person in the near future. So, among the topics for the first session, please focus on the most important one, and please go for 10 minutes.
Okay, can you hear me?
예, yes.
Yes, we can hear you well.
Thank you. Hello, everyone, and greetings from Turkey. I'm so happy and honored to be at such a distinguished conference. Thank you very much for inviting me, and thank you for the cooperation. Okay, I will directly start with my presentation. First of all, for the statutory amendments, I'm going to talk about the coming into force of the new IP code, which came into force in 2017. The IP code abolished previous IP-related decree laws, 4 decree laws, and entered into force on 10 January 2017. As it's known, Turkey has been a candidate country for the EU for a long time. After having the candidate country status, Turkey conducted official negotiations with the EU in order to become a member of the customs union. And within this framework, Turkey had to adopt its national IP law in accordance with the EU legislation. In order to fulfill this liability, in 1995, Turkey quickly implemented decree laws relating IP rights, such as patents, trademarks, industrial designs, and geographical indications. The legislator at that time preferred decree laws because fewer procedures were required, and it was fast and easy, actually, to put into force, and they had the power of law as well. Even though they should have been transformed into laws as soon as possible, they remained in force until the entry into force of the IP code. And I'm going to talk about some essential changes in the IP code regarding trademarks, designs, patents, and international exhaustion principle, which was accepted. For trademarks, new types of trademarks were accepted. When the IP code came into force, EU trademark directive was in force, and the definition of the trademark transformed from the directive. The obligation of showing by drawing has been abolished. As soon as the signs are capable of distinguishing the goods and services absolutely and accurately, any sign like words including personal names, figures, colors, letters, numbers, sounds, shapes of goods or packaging could be a trademark. And another change is coexistence principle, notary letter. In the light of the old legislation, decree law, let's say, both the Turkish Patent and Trademark Office and the court accepted the unity principle of trademarks as a public order. Actually, if something is a public order in Turkish domestic legislation, judges per se take into account the issue during the whole case without any time limitation, and the parties are able to take the subject to the court as well. Although the registration of the same or very similar trademark in the name of different parts sometimes appear as a need, because of the unity principle, the system did not allow this. So after this drastic change, coexistence principle and notary letter, the trademark application may not be refused on the grounds of the unity principle. The bad faith claim is regulated as a separate opposition and invalidation ground for the trademarks. And another change is, if a trademark is not used, it will become non-functional. When a party applies for registration of the trademark to the office, when I say office, I mean Turkish Patent and Trademark Office, an earlier trademark owner was able to oppose it, but if the mark is not used in the registered class, the office is able to reject the registration demand. Okay, and also the office is authorized to revocate a trademark, which is called administrative revocation. Before the IP code, only the courts had the authority to revocate or invalidate a registered trademark, but after the code, also the office is authorized for this. But entering into force of this provision is postponed for 7 years, and it will come into force in 2024 because it's a very drastic change. And when it comes to designs, unregistered designs were not protected before the code. After the code, both registered and unregistered designs are protected. And for designs, novelty examination is foreseen for the registration. When it comes to patents, one of the most important improvements is post-grant opposition system. We did not have post-grant opposition system in the decree law period, but now we have. And one of the most important development is the IP code abolished all criminal sanctions in case of patent infringement. Now we have criminal sanctions for trademarks and copyright issues on the code. And there is no more patent granting without going through an examination process. This will lead to stronger patents in Turkey. And compulsory license situations are extended. In patent decree law, there were 3 reasons for compulsory license. After the IP code, we have 3 more reasons, 3 more situations for the compulsory license. And the legislator preferred international exhaustion principle for all types of IP rights. And for the second subject, the case trends, I'm going to talk about them. I have 2 cases, the internet service provider's liability and the use of trademark for criticism on the internet environment. The first case is Turkish Court of Cassation case and paved its way to the Court of Cassation Grand Civil Chamber. I chose to present this case since it was solved in the Court of Cassation, Grand Chamber, as I said, and in the internet service liabilities, in our domestic system, court system, we use notice and takedown system. In this case, the litigant was a trademark owner who is a famous perfume company, and the defendant was an online shopping website, which is very famous, like Amazon in Turkey, actually. The litigant claimed on the ground that the defendant exposed the goods, which were counterfeit perfumes, on their website, and demanded declaratory and removal of the infringement, termination of the selling activity on the website, destruction of goods, and moral damages. The regional court, which was Istanbul First Civil Court of Intellectual and Industrial Rights, ordered an interim injunction at the beginning, and as a final judgment against the defendant to remove infringing content from its website, but rebuffed the claim to grant damages. After 2 appeals to the 11th Civil Chamber, Turkish Court of Cassation 11th Civil Chamber, which is relevant for the commercial cases, and IP cases are commercial cases in Turkey. The Grand Chamber, after the 2 appeals from that chamber, then the case went to the Grand Chamber, and the Grand Chamber anonymously went on to conclude that upon receiving a petition claiming on the infringement, case petition, let's say, the defendant became aware of the civil wrongdoing and hence had to be required to pay damages. And the second case is the use of trademark criticism on the internet environment. This was a constitutional court case, and the defendant, the constitutional court ordered that, concluding that the decision, I just realized that I have only 1.5 minutes, and I will try to conclude. The constitutional court concluded that the decision of the first instance court was proportionate and the intervention was in accordance with the requirement of the democratic social order, and stated that it was clear there was no violation of the applicant's right in terms of freedom of expression. And for the last topic, the hotly debated thing for the IP-related issues is mandatory mediation. After entering into force of the law in 2019, civil mediation in Turkey has become mandatory for certain IP cases, actually commercial cases, and as per commercial code, Turkish commercial code, IP cases are related commercial cases. According to the law, mandatory civil mediation where financial remedies, namely an award of payment of a sum of money as a performance of damages, are sought. In this sense, the claim in question must be a monetary nature. Thus, any claimant who intends to commence a formal action with a commercial pecuniary claim is first required to undergo mandatory mediation. However, an implementation problem occurs when monetary and non-monetary claims are raised together in IP cases, because the code introducing mandatory mediation does not provide a specific rule for disputes combining both monetary and non-monetary claims. So the Turkish courts had three options: passing through mandatory mediation and entering into force into the merits of the case for all claims, dismissing all claims based on procedural issues, and separating claims based on mandatory mediation requirement. Turkish courts preferred the last option for a long time, but in 2020, Turkish Court of Cassation 11th Chamber gave a different decision and said that if a pecuniary and non-pecuniary claims are together brought to the courts, then it's not the mandatory mediation is not useful. So it can be seen in front of the courts, before the courts. So it's a very hot debate. It's a very hot issue debated in Turkey. And this is the end of my presentation. Thank you very much for listening.
예, 인재 판사님 대단히 감사합니다.
Yes, Judge Inse, thank you very much for your comments. You sent us a very detailed response, and 10 minutes was a very short time for you to speak.
Yes, unfortunately, sorry.
예, 개인적으로는 상표
Well,
사용에서
personally, the coexistence principle and the administrative revocation right and protection of unregistered design were all very insightful and new inputs for me. Through your input, I hope that cooperation between the Korean and Turkish IP practitioners will become more active.
I'm afraid to say correctly thank you in Turkish, but I try. Teşekkür ederim. Again, teşekkür ederim. 자, 그럼 다음으로 인도의
So we'll move on to the Indian speaker. Judge Singh, we'll pass on the floor to you.
싱 부장 판사님
Judge
반갑습니다.
Singh, greetings.
예, 바쁜 일정 중에서도
Good morning. Thank you. Can you hear me?
예, 바쁜 일정 중에서도 이렇게
Yes, thank you very much for taking part in today's event as a panelist, despite your busy schedule.
제1 세션의 주제 중
So among the topics for session 1, in your view, can you speak on the most pertinent issues for about 10 minutes?
Yes, please.
네, 알겠습니다.
Okay. Very good morning to all of you.
여러분, 안녕하십니까? 버글 교수님, 인세 판사님, 다시 한번 이렇게 뵙게 되어서 기쁘게 생각합니다.
Yes. In the first topic which I would be speaking about is the recent trends in IP in India. But before I do that, I would like to extend my gratitude to the Patent Court in Korea for inviting me today. I have been to Korea only twice, maybe in the last decade or so. I'm sure it's changed a lot. And I look forward to visiting your Patent Court. I read about the Patent Court in Korea and the International Division in your reference book, and I'm highly impressed to see how you would be doing foreign language litigations in Korea. That's a very unique and an innovative step which I haven't come across in any other jurisdiction. The issues that we face in India are not very different from what Professor Fogel and Judge Inze have already said. But let me introduce you to the entire IP ecosystem in India. Firstly, I want to say that we have statutes for almost all IPs in India, including the basic IP rights and for geographical indications, semiconductor integrated layouts, almost all the major IP rights, except for trade secrets. So there is a debate in the national IPR policy, which came out in 2016, as to whether we need to have a sui generis system or a statute for trade secrets that debate is still on. We do not have a statute on trade secrets as of today. Apart from that, the most important development that has taken place extremely recently as of February, as of 2021, is the abolition of the Intellectual Property Appellate Board. We had created an appellate board for dealing with appeals and original revocation and cancellations of patents and trademarks. This board has been abolished, and the jurisdiction has been vested back with the high courts in India. So this has proved to be a challenge in the last few months. And the Delhi High Court, where I sit where I'm one of the members, judges in the court, has taken two important steps to deal with this issue. The first and the foremost was the creation of the Intellectual Property Division in the Delhi High Court. And we've also started drafting the rules for this IP division, and hopefully in the next month or so, we should be notifying them because they are up for stakeholder comments as of today. Secondly, we also face the same challenges in respect of experts in patent litigations, as Professor Fogel was saying today. And so we have drafted specific rules for patent suits in the Delhi High Court. And these rules have also been put up for stakeholder comments and are likely to be notified maybe in the next couple of months maximum. These particular rules and both these sets of rules have given a lot of emphasis on the technical aspects of intellectual property matters. So we are going to be permitting claim construction briefs, infringement briefs, and invalidity briefs to be prepared and filed by parties along with their pleadings. And for the IP division, there are two sets of technical experts that we are planning to provide for. The first set of technical researchers would be like law researchers. The IP division would be having two researchers who are technically qualified, so that on a daily basis, the judge can interact with them and get inputs on very basic technical matters. We also would be having a panel of scientific advisors in the court itself, maybe both from India and abroad, who can be used as court-appointed experts for patent litigations. And I think we not only need technical experts in patent matters, but recently we've realized that in one of the copyright-related issues, royalties were to be prescribed by the court, and the court considered that economists or accountants would also be required in order to analyze the accounts, etc., of the parties and fix royalties. So these two sets of rules, in my opinion, are going to be changing the manner in which intellectual property disputes would be dealt with in the Delhi High Court. And I have learned that even the Madras High Court has set up a committee as to how to deal with the matters which would be coming from the IPAB. So there would be a lot of change in the next couple of years, 2021 and 2022, in the various high courts in the country. So apart from these two major developments, I would also like to highlight that there is an amendment contemplated in the Competition Act of India, because there is a lot of conflict which is taking place between competition law and intellectual property law. So as on today, the statute provides for an exception in relation to anti-competitive agreements alone. But in respect of abuse of dominance, there is no exception for IP. And Section 4A is contemplated under the bill to be provided as an exception to anti-competitive conduct. So IP can be an exception to anti-abuse of dominance, and I don't know how this is going to work out, but this is one amendment which is under contemplation. The next one or two smaller developments are, there is a patent prosecution highway which has been signed with, it's a pilot program with Japan as of 2019. So we are hoping that with the experience of that, we would be able to have more and more agreements with various other countries. Now, moving on to the latest issues in intellectual property cases. If you see in the reference book, it is a detailed answer which has been given from me and my team at page 33 of the reference book. There are various issues that courts are facing currently, and the most important issue relates to online IP violations, both trademark and copyright violations, because as Judge Inze also just said, we are facing counterfeiting products on e-commerce marketplaces, etc. and piracy of various television channels and sporting events on the internet. So the courts have become very, very strict in this, and they've evolved the concept of dynamic injunction. So it is not sufficient, especially in respect of rogue websites, which have predominantly, infringing content. The court has said it is not sufficient to simply pull down the URL, but also pull down the entire website. And since mirror websites can come up very quickly, you can have copied websites immediately when one website is pulled down. So the court has come out with the new concept of dynamic injunction, which can be granted by Indian courts. One of the major challenges we are facing in patent litigation is jurisdictional conflicts. There was a litigation where an infringement suit was filed in the Delhi High Court against a defendant, which was a Chinese company. The Chinese company then filed a suit for declaration and injunction in the Wuhan District Court in China, where they obtained an injunction that the American company cannot proceed with the infringement action in the Delhi High Court. So this is a major conflict of jurisdiction issue which we faced. The High Court has taken a view recently and has held that patent rights being territorial and infringement action cannot be stopped in this manner. So an anti-suit injunction has been granted by the Delhi High Court very recently. The third issue I would like to highlight is about global injunctions for infringing content. Google raised a defense in one of the cases that the Indian court cannot grant a global injunction. I'm sure this situation is similar to the equistic issue which Google has faced in the US and in Canada. But the High Court has taken a view that if the content is uploaded from India, then an Indian court can grant a global injunction. In the area of pharmaceuticals, since I have 1 minute to go, in the area of pharmaceuticals, the biggest issues we are facing are in respect of Marcus formula claims. There are issues about coverage and disclosure. There is a recent trend of decisions which have come out in relation to AstraZeneca patent. This is commencing the discussion had started in the Novartis decision of the Supreme Court as to whether the coverage of a patent can be higher or larger than the enabling disclosure in the patent claim. So the courts are taking different views in different cases depending on the facts. And I do see that there will be a lot of debate in these matters going forward. So I would like to end by saying that e-commerce platforms are providing a huge challenge for IP. There are recent intermediary guidelines which have been issued by the Indian government in 2021, making it much more stricter. The compliance by intermediaries has to be much stricter than it used to be before. So we are having an evolving ecosystem, and we are in for interesting times in India. And I look forward to the discussions today. Thank you. Thank you very much.
예, 신구장 판사님 감사합니다.
Thank you, Judge Xing.
방대한 내용을
A vast amount of information has been provided to us in India. The repeal of the IPAB and the creation of an international division in the Delhi High Court, and also the IP examination highway program with Japan, and also a few cases related to jurisdiction has been explained to us. So, Judge Xing, I think, represent the very history of the IP area in India. So she is a widely respected legal expert. So I would look forward to a time to meet with you personally.
See you in Korea soon. 예, 다음으로 마크 슈바이츠 연방법원장님의 발표를 사전 준비된.
Next, we will watch a pre-recorded presentation of Mark Spicer, the president of Swiss Federal Patent Court.
It is a great honor to have been invited to the International IP Court Conference, even if only virtually, and I do hope that I will one day be able to all see you in person. As you can probably guess from the background, I'm at home. My office is not equipped for video conferencing. Our courtrooms are fully equipped for video conferencing, but I didn't want to sit alone in a very large courtroom for this session. So this session one on the trends in IP in Switzerland. Well, the trademark and patent law has not been changed recently. What has been changed recently is the Copyright Act. Here, there was a number of changes. One of the more important ones was that, according to a Supreme Court decision of the Swiss Supreme Court, right holders were not allowed to collect the Internet Protocol addresses of people sharing illegal copies of copyrighted works, mostly movies, of course. This was, according to the Supreme Court, a violation of their data privacy. And this led to a lot of criticism by the associations of the right holders and a lot of pressure, notably by the United States, where, as we all know, a lot of the major movie companies are headquartered. And now the law has been changed. It came into force, well, actually last year, April 2020. And now the right holders can collect Internet Protocol addresses and then forward them to the relevant authorities who can find out and identify the people behind the Internet Protocol addresses. There were other changes, stay down provision for hosting providers. There was always a takedown decision provision. Now they have to make sure that illegal content not only is taken down, but is not re-uploaded. So this is in trend with most major jurisdictions. I think it's nothing unusual. A major revision of the Patent Act is currently pending. It is still being subject to parliamentary debate, so it is not clear exactly where it is going. I will make a few remarks about it later on. Now, major trends of IP cases in my country. I should add, probably for the benefit of the listeners, that I am the president of the Swiss Federal Patent Court, and we are competent only for patent cases and supplementary protection certificates. Both infringement and validity, unlike, for example, the German Federal Patent Court, but we do not handle copyright or trademark cases. So I am, unfortunately, probably not the right person to inform you about any trends in copyright and trademark litigation. Now, in patent litigation, I should also say that Switzerland is a relatively small country. We have about 8.5 million, population of about 8.5 million, which is actually less than Seoul. So the city of Seoul has more people than the whole of Switzerland. So the number of cases being litigated, and especially the number of cases that actually goes to trial and goes to judgment, is relatively small. So it is difficult to say there is an overall trend. What we do see, which I think is interesting in the last couple of years, is we see fewer cases of classical pharmaceutical disputes between originator companies and generic companies. This used to be a mainstay of patent litigation in Switzerland. It was probably half of all the cases were originator against generic entry. Now, this is much less. We this year had a few cases, but it's much less than in the past. And therefore, actually the overall number of cases is slightly declined, and there is a shift more towards medical technology and to some extent information and computer technology. Although I should say that, unfortunately, in my opinion, but it's a fact that Switzerland is not a leading nation in internet information and computer technology. We are strong in pharmaceuticals, as you probably know, and there is little litigation in the field of ICT industry, simply because it's not an important field in Switzerland. There is the occasional case, but it's certainly not something where Switzerland is leading the charge internationally. Now, current legal issues hotly debated in IP. Before I mention the revision of the Patent Act, which I think is, it's very peculiar for Switzerland. I'm not sure how much of interest it is to an international audience. One thing that we see recently in patent cases is that patents are increasingly being found invalid for modifications after during the prosecution. So this is a trend that comes from the European Patent Office, which is increasingly strict about amendments to both the claims, most importantly, but even the specification of the patent may only be amended in a very limited way during prosecution. And if you run afoul of these provisions, it leads to the invalidity of the patent. And recently, about half of the patents that we found invalid were found invalid due to added subject matter, I think is the term that the Americans use for this. This is a recent trend. I'm personally not sure that this is a happy trend. It becomes very formalistic, but that's the way things are. Increasingly, this is being litigated. Obviously, novelty and inventive step are still important issues, but the added subject matter has become increasingly important over the last couple of years. You have to be very, very careful about amendments to your patents during prosecution. Now, as I said, in Switzerland, I would say, most important issue is the revision of the Patent Act. There has been a first draft, which has been widely criticized, to be honest. The background is that Switzerland currently does not have fully examined patents, national patents, I should say, to be precise. Swiss national patents are not examined for novelty and inventive step. So you could theoretically actually file a patent for the wheel in Switzerland. And if you formally do it correctly, you have specifications, you have a claim, and it's done formally okay, you would get a patent for a wheel, because the patent office cannot reject an application for lack of novelty or lack of inventive step. Of course, if you did get a patent for a wheel, the patent could be invalidated by the competent court. So my court, the Federal Patent Court, could find it invalid. So if you would try to enforce it, you would not come very far. It would not be enforceable. However, you would get it on paper, you would get it. Now, this has been criticized, and there has been a suggestion that Swiss patents should also be fully examined also for novelty and inventive step. This was a suggestion in the first draft, but for a number of reasons, the industry and also professional associations were not happy with this draft. And as it currently stands, the idea is to keep the not fully examined national patents, so not examined for novelty and inventive step, and have in addition a fully examined national patent. So you would keep the current non-fully examined patent plus have an additional fully examined patent. Now, personally, I'm not sure how big of a demand there is for this fully examined national patent if you can also get a national patent with the same duration and the same rights without a full examination. If you want a fully examined patent in Switzerland, the easy route and the way that everybody does is you get a European patent and then validate it in Switzerland. So over 90% of patents in force in Switzerland are European patents. So they are granted by the European Patent Office in Munich and The Hague. And then they are validated in Switzerland and they have the same effect as a Swiss patent. They can also be found invalid for the same reasons and before the same court. So if you want a fully examined patent, you go the European route and you get a fully examined patent. And if you don't want that for a number of reasons, then you can get a national patent which is not fully examined. Now, this proposed revision will add another option, which is the option of a fully examined national patent, but it will keep the current system of a not fully examined patent. So that's the way things stand. I'm not sure this is something other countries would want to emulate. It is, I think, based on historic reasons. The main reason being that the number of national patent applications is relatively small. and it is difficult for the Swiss Patent Office to have examiners which are qualified in all the different technical fields. So this is historically the reason why they did not do a full examination. Again, if you want that, you can go to the European Patent Office. Now, I'm not sure why this has now changed and why now suddenly they should be able to do a full examination. So as you can hear, I have my doubts, but this is how things are standing. So I think my time is up. I don't want to hold you up. I hope everybody is having a great conference, and as I said, I hope to see you in person one day. Bye-bye, and I see you in session 5.
예, 감사합니다.
Thank you very much, President Schweitzer. Thank you for explaining the recent trends in IP law in Switzerland. I enjoyed the view of your personal study. I noticed the interesting designs, and I really appreciate your honest and frank remarks about Swiss and international IP trends. Well, we are a bit late on time and we're going longer than expected, but still we have rich content that has been prepared, so we will proceed with the session. We may go 10 minutes over the allotted time, and now we will hear from Judge Chung Taek-soo from Korea Patent Court. So, all of the honorable IP experts from around the world, hello, I am Judge Chung Taek-soo from Korea's Patent Court. I'm in a bit of a dilemma, actually. I want to make sure to secure your lunch break. So as much as I want to share all the content that I have prepared, I want to honor your lunch break, so I will make my comment very short. So with all the honorable panelists from around the world, I was very impressed by the diversity. As the keynote speaker, Professor Chung, mentioned, we must understand the diverse systems of different countries and show mutual respect. So there were many interesting points in Switzerland. There's no full examination on novelty and inventive step for domestic filings, and you showed a very rather questionable stance on the amendment. But the non-examination was abolished in Turkey, so that was a very striking contrast. In the US, on the other hand, well, PTAB is being strengthened while the IPAB was abolished in India. So we are seeing very contrasting trends among different countries. Also, as long as there is the consent through the notary, then the coexistence principle is now being introduced in Turkey. That was a very new input for me. Well, I say this because Chief Presiding Judge Seung-yeol wanted me to give a brief comparison between the system of other countries versus that of Korea. So that is why I'm making such comments right now. I gave a quick summary, but I just want to add one more comment. Well, this was from India. Judge Singh, she mentioned the Novartis case. As you are aware, well, you might not understand the full content of the case, but it was about the genus and the species substance, and if the species of substance have significant effect compared to genus, then it can be registered. So In India, there is no distinction between the novelty and inventive step, and the requirements are resembling that of the US. And what is more important is that effect is of the utmost importance. And Korea also had a Supreme Court decision on Abdisaban. I can't go into too much detail, but we are going on a different path than India. And the US, Japan, EU, I think we are joining that similar path. So such roads or paths for the future is being shaped by the circumstances of each country. I think that should be acknowledged. So how is the legal ecosystem and environment of Korea different from that of the other countries, and how can we reach a consensus? I think these are issues that merit much contemplation and discussion. I believe that in IP law, I don't think there is one golden path. Even philosophically, changes bring innovation. Well, we should avoid just ruling out what is different from us, but we should respect such differences, and that was the insight that I got from the first session of IIPCC, and it was a great honor for me to join as a panelist for this session. I would like to extend my gratitude to every participant, and thank you.
Yeah.
Judge Jung, thank you very much. Because of the time constraint, I think he shortened his comments. So there is a written response that has been provided by Judge Jung in the reference book regarding the three proposals that he makes. He also includes many of the pertinent court decisions in Korea. And looking through his written response, I was able myself also to organize my thoughts about the topics at hand. So I would like to suggest to all of our panelists and participants to please look through this written answer by Judge Jung. I myself benefited greatly by reading his answer. So let me conclude today's session. I would like to thank all of you who have prepared for and participated in today's session, especially those who have participated from overseas via online. I would really like to see you face to face in the near future in Korea. So early this year, when the fatigue over the COVID-19 pandemic was building up, the Chief Judge, Seung-Young Lee of the Payton Court of Korea, presented the slogan for this year for the Payton Court. Let me introduce that slogan to you. In the New Year's address, Chief Judge Lee talked about the resilience, immunity, capability, so strengthening all three factors. He said that these were the key qualities that legal experts should have in this age of pandemic. So, as Chief Presiding Judge, I myself added harmony to the three qualities, and I crafted the slogan for 2021 for Payton Court. The word rich, however, we didn't have enough time to commercially prepare this as a official slogan. But I would like to take this opportunity in today's conference, in wrapping up the session one, I would like to shout out this slogan to all of you. Especially, I really would like to send this message to the panelists. I wish all of you to be rich. And there was a quiz at the beginning of this session. Do you know why we have selected the 5 countries that we did as panelists? I don't think any of you would have been able to find an answer to this. It was a very difficult question. So we have 5 countries participating as panelists in session 1, and for the 5 countries, the title of this session was Recent Trends in Global IP Litigation. So litigation, in the litigation, Mediation. We have 5 countries participating. And what is the corresponding word should? Swiss, S, U for United States, and I for India, T for Turkey, and South Korea S. So suits.
전형적인 사후적 고찰입니다.
Yes.
사후적 고찰이고
That was,
국가가 선정된 것은
a joke.
그래서 대명하는 5개.
So these 5 countries are representing suits.
정말 수고 많으셨고.
I really would like to express my appreciation for all your hard work and participation. I really look forward to meeting you in person in the near future in Korea. So with this, I would like to wrap up session 1. Thank you very much for your attention.
예, 정말 재밌고 유익한 시간이었던 것
It was a
같습니다.
very fruitful and interesting session. Thank you, Chief Presiding Judge Seo Seung-yeol and Judge Chung Taek-soo from the Patent Court.
오후 세션은 점심 식사 시간을 가진 후
So after lunch break, we will move on to session 2 from 1 p.m. on the topic of compulsory licenses. So please follow the protocol for preventing COVID and have a great lunch break. Thank you. We will begin the session 2 from 1 p.m. sharp, so please return to your seats.
잠시 안내 말씀드리겠습니다. 13시 정각부터 두 번째 세션을 시작하도록
From 1 p.m. we will begin session 2.
입장하셔서 자리에
Please return to your seats.
지금부터 2021 국제 특허법원 콘퍼런스
Now, the second session of the 2021 IIPCC will begin. This session will look at recent trends in granting compulsory licenses, and it will be moderated by Soo-min Kwon, the High Court Judge at Patent Court of Korea. And let's invite him and also the panelist Judge Koo Sung-jin to the floor. Thank you.
Good afternoon, everyone. I am Soo-min Kwon, Judge Hyun-min Kwon, currently serving at the Payton Court of Korea. I'm going to be moderating the session on the recent trends in granting compulsory licenses. I will be asking our panelists about their valuable insights into this topic. So I hope those of you are taking part on-site or via online to be able to gain very beneficial information and new insights into this topic. And let me introduce the panels. First, for detailed bios, please refer to the reference book. First, from the United States, we have with us Sapina Kumar, professor at University of Houston Law Center. Despite it being very late in the evening, professor is taking part in today's event. And next is Pratibha Singh, presiding judge of Delhi High Court. Next is from the München University, Professor Dr. Dorcher, Private Law, Intellectual Property and Unfair Competition at the Ludwig Maximilian University of Munich. Despite this being very early in the morning, Professor Ansgar Oli is with us. And finally, we have with us Sung Jin-koo, judge at the Payton Court of Korea. Recently, due to the COVID-19 pandemic centering around the developing countries, there are increasing voices calling for the compulsory licensing under the waiver from provisions of the TRIPS agreement for the vaccine treatment, and the developed countries are resisting this movement with concerns that this might undermine the very purpose of the patent system. And so in this situation, I think this will be a very meaningful session in order to find a harmonious solution to this conundrum. In session 2, we will be looking at 4 topics. First is on the type and the requirements for compulsory licensing, and second is for the calculation of consideration for compulsory licensing. Third is the procedures related to compulsory license, and the fourth topic will be about how such issues are playing out in different countries. And so with regards to the pharmaceutical compulsory licensing, which is gathering a lot of attention, we will be discussing this topic. What we would like to add at this point is that already the panelists have submitted very detailed answers for all of the questions. So in the reference book that you have received, these written answers are all included. And so because we only have 1 hour allotted to us, at this session, we will have to ask you to answer in a way that is concise and deals with the key points in your answers. So when you speak, please keep in mind the time that is indicated in the screen. So I ask for this understanding from the panelists. And now we will discuss this topic. in Session 2 about the type and requirements of compulsory licensing. So let me ask two questions altogether. So the type and requirements of compulsory licensing related to patent rights in your country, especially whether there's a requirement of public interest, and secondly, whether pharmaceutical patents have any differentiated requirement compared to other patents. First, we would like to invite Professor Kumar about what's the case in the United States.
Thank you. In the United States, there are two applicable provisions relating to compulsory licensing: 28 U.S.C. Section 1498 and the Bayh-Dole Act. Under 28 U.S.C. Section 1498, this addresses the situation in which the government or a government contractor uses a patent without permission. Generally speaking, the government has very broad powers to use patents. There are no formal requirements that the government needs to meet before it uses a patent, whether pharmaceutical related or not. And generally, the government cannot be sued without its express consent. What Section 1498 does is the government provides limited consent to be sued for patent infringement, allowing the patent holder to obtain damages, though injunctive relief is not available to the patent holder. And it's worth noting that the government need not inform the patent holder that it is using its patent without permission. Under the Bayh-Dole Act, that covers inventions that arise from government-funded research. A federal government agency that funds research retains a royalty-free license to practice the patent. And also a third party can petition for a compulsory license under the Bayh-Dole Act from the federal government by filing a request with the government agency that funded the original research. For these march-in rights under the Bayh-Dole Act, they're supposed to be used to alleviate health or safety needs which are not being reasonably met by the patent holder. However, it's important to note that no agency has ever utilized these march-in rights, making it unclear in the United States exactly how useful they are, nor has any third-party petition for march-in rights ever been approved. Thank you.
Thank you. So there is no general provision on the compulsory licensing in the U.S., but they have the Article 1498 under the USC, as mentioned, and there is the Bayh-Dole Act. From the Patent Act Articles 200 to 2012, that is where you can find the Bayh-Dole Act. Now we will listen from Judge Singh from India. She sent a very detailed response in the IP law field, even besides patent. But today, please, given the limited time, focus on patent, please. Thanks.
Very good morning to all of you in Seoul. Good evening to the participants from the US and in Munich. Thank you for having me. On compulsory licensing, as the moderator and the introductory speaker have said, I will focus on patents because we do have compulsory licensing in copyrights, as also in the field of telecommunications. If you're interested in those, you can look at page 64 and 65 of the reference book. But coming to patents themselves, I think there are two relevant provisions. The first relevant provision is Section 84 under the Patent Act, in which the controller can either suo moto or on an application by any person interested, grant a compulsory license. There are broadly three tests that are required to be satisfied. Firstly, if the patentee is not satisfying the reasonable requirements of the public in India. Number two, if the patented product or commodity is not available at a reasonably affordable price. And three, if the invention is not being worked in India. On all these three grounds, the party can approach the controller for a compulsory license. Secondly, in public interest under Section 92, the central government also has the power to issue a notification that the patent would not be enforced by the patentee. So the three conditions which would be normally considered by the central government would be if there is a case of a national emergency, or if there is a case of extreme urgency, or in the case of a public, in the case the patented invention is required for public non-commercial use. So on all these three grounds under Section 92, the central government can also issue a license. Though the license can be issued without hearing the patentee, however, the terms and conditions would have to be fixed thereafter, and the intention would always be to ensure that the patented product is available at the lowest price to the public, and the controller and the central government normally would apply the test of public interest while granting a compulsory license. And you can see the definition of public interest in the Bayer judgment, which is at page 65 of the reference book. Thank you.
예, 감사합니다. 다음은 독일의 올리 교수님의 답변을 듣도록
Thank you. Now we will listen from Professor Oli from Germany.
Thank you very much, and good morning from Munich. The law of compulsory licensing in Germany can be compared to Sleeping Beauty and the Sword of Damocles. Sleeping Beauty, it was sleeping for a very, very long time. There were no cases of compulsory licenses until 2017, when arguably the Sleeping Beauty was kissed awake by the Supreme Court. The Sword of Damocles, it's pending over the patent owner. It doesn't fall down, but the patent owner needs to be aware that it can always fall down. Next slide, please. In Europe, there is no provision for compulsory licenses in general, even not under the Unified Patent Court Agreement, which might enter into force soon. So the provisions that exist are German law provisions, namely the provision for compulsory licenses in Section 24 of the German Patents Act. There is also a provision on state use. And I should also mention that remedies against the misuse of a dominant position in friend cases can have a similar effect. And finally, I should point out that there is a new disproportionality defense, slightly reminiscent of the eBay and Merck exchange case in the United States, but not as far-reaching in German law. Now, the requirements under Section 24, which are on the next slide, is that the license seeker must unsuccessfully attempt to obtain permission, and there must be a public interest which requires the compulsory license. As for the public interest, next slide, please, the onus of proof is on the applicant. And all cases that we have had on public interest really concern medicinal products. We don't have any cases from other areas of technology. One criterion, if the applicant's product possesses properties which other products on the market do not have, or if the product has less side effects, then this might be a reason for finding the public interest. This was found in one case about which I will talk a little bit later, the Raltegravir case, which was the one case where a compulsory license was upheld by the Supreme Court. However, if the public interest can be satisfied by other basically equivalent products, that militates against finding a public interest. The attempt to obtain permission within reasonable time must be determined on a case-by-case basis, but it can be started after the application has been made, but it must be made within a reasonable time. Thank you.
네, 감사합니다.
Thank you. So India and Germany has two types of compulsory licensing, one by the government. And also the cases are looked at to determine the scope. But there is no EU level provision, and that was very interesting. And also the Sleeping Beauty analogy, I guess, still works here. I guess she is still waiting for the kiss. Please compare what you have with our system in Korea. Now we will hear from Judge Koo. Hello, I am Judge Koo. So about compulsory licensing, I am very appreciating this time to talk with the panels of other countries. Well, when it comes to the Korean Patent Act, there are two types of compulsory licensing. First is when there is a national or dire emergency, or when there is the need for public interests, the government deems it necessary for granting compulsory licensing. And type 2 is when a party with intent to practice the patent invention files a petition for adjudication and without any justifiable causes in natural disaster or force majeure event, if the patent has not been practiced in Korea for at least 3 consecutive years, except and if 4 years have passed since the filing date of the patent application, and second, if it's necessary to practice for public interest, and third, if it is necessary to practice the invention to export medicines to country that intends to import them, then this compulsory license is granted. And for reasons that are directly tied to lives of nationals, such as preservation of life, health, and property, this would be deemed as public interests. And for the pharmaceuticals, the following are the grounds. For petitions to import medicines, it must be for diseases that threaten the public health, and there should be no sufficient manufacturing facilities in Korea for that particular medicine, and it must be a time when the Minister of the Interior and Safety declares as a state of disaster to mitigate the grave effect and damage. And also, second is a case where we need to export to a country that intends to import. Thank you.
So next, going on to the second topic, that is the criteria for estimating the remuneration or compensation for compulsory licensing. One of the biggest reasons, traditional reasons for granting, for being reluctant to grant compulsory licensing is the issue of compensation. And this shows how sensitive an issue it is to estimate the compensation for compulsory licensing. So I'm going to ask two questions here. So the first question would be, so what are the estimation criteria and what factors are considered in determining the payment for compulsory licensing? And secondly, how is the payment estimation for compulsory licensing different from the reasonable loyalty that is recognized as damages in an infringement case? So we'll hear first from Judge Singh to hear about the Indian case.
Thank you. Broadly, the 4 factors that are considered in a compulsory license application would be, firstly, the investment made by the patentee if they prove it on record. Secondly, what is the extent of working they are themselves doing and what are the margins, etc., that they are generally using for sale of the product. Thirdly, what does the controller think is the reasonable price that the consumer can pay, keeping the first and the second factor in mind. And fourthly, the duration of the license. So if it's a longer license period, then the royalty can be distributed over a longer period, and therefore it could be a smaller royalty rate. But if it's for a shorter license period, then the royalty rate is likely to be higher. But insofar as contrasting this with damages and infringement is concerned, in infringement cases, there are 3 types of damages that can be granted: direct damages, indirect damages, and punitive or exemplary damages. But insofar in direct and indirect damages, we follow the normal principles of common law while we calculate how to grant damages. And sometimes there are other accentuating factors which may lead to higher damages. But in the case of intellectual property, usually punitive damages are not granted by Indian courts. And in order to tell you as to what is the way in which royalty is calculated, I would like to take the case of one of the compulsory licensing cases of Bayer, which was granted in India. And this was the Nexavar drug. There, the royalty which was granted was based on the UNDP recommended royalty rate, which was 4%. That's what the controller gave. But then the IPAB increased it to 6 to 7% after considering the fact that the applicant for the compulsory license, i.e. the generic company which was making it, was having a large amount of margins to its distributors and retailers. So it was increased from 4 to 6 to 7%. But the most important feature of that case was that the patentee did not give any evidence to show what was their investment in the drug research. So that led to this kind of a royalty rate, which was 4% initially and 6 to 7% of the net selling price. So I would like to stop here. We can expand it in the next question.
예, 감사합니다. 예, 인도는 법률로
So thank you very much. By law, India has very detailed regulations for estimating the compensation. And the next of our case, I think, will be introduced in more detail in the fourth question. So next, we'll hear from Professor Oh Lee from Germany.
Yes, thank you. As I mentioned before, there is only one case in which a compulsory license was upheld, so we do not have much experience in Germany with the calculation of royalties. German courts basically use the same method for calculating adequate remuneration for compulsory licenses as for reasonable royalties when assessing damages. There are three possibilities how you can assess damages in German law. The reasonable royalties approach is one of them, and basically the same principles apply to the calculation of the remuneration in the case of a compulsory license. So the starting point, the reference value, would be the net turnover from the sale of the applicant's product. But if only one component of the product falls within the scope of the patent, this can be reduced. There are several factors that courts take into account when determining the percentage. The range of the percentage seems to be between 2 and 10%. Sometimes it's mentioned that the percentage can be as high as 15%, but there are no, as I said, there is no practical experience with that. Factors are the scope of the compulsory license. The broader the scope, the higher the compensation. Significance and value of the patent, the higher the inventive step, the higher the significance for technological progress, the higher the compensation. The threat potential of the threat of a potential injunction, whether the invention is already ready or whether the applicant still has to invest own efforts, and whether the license is granted to a direct competitor or whether it's not. In the Ralti-Gravier case, the only case which we have, the court considered the threat potential to be rather high, as the applicant made significant progress by selling this particular drug and would have been compelled to take the drug from the market had there been no compulsory license. Also, the parties were direct competitors. On the other hand, the patent did not disclose the drug as such, but it gave rather basic information. Indeed, the patent was revoked at a later stage. So it was a rather weak patent, and it still required quite a bit of development on behalf of the applicant. Also, the compulsory license did not cover the full scope of the patent, but only a smaller section. Based on these factors, the Federal Patent Court held that a license fee of 4% of the applicant's net turnover was appropriate. Thank you.
네, 감사합니다. 독일은 판례로
So thank you very much. Through court precedents, the compensation for compulsory licensing is determined. So the Ralti-Gravier case is very important. So in the fourth question, I think we will go back to this case again. Next, Professor Kumar from the United States will answer the question.
For compensation cases under 28 U.S.C. Section 1498, the statute itself provides little guidance. So courts look to the Patent Act for guidance in terms of how to compensate the patent holder. And what they generally do is they award a reasonable royalty based on a complicated 15-factor test known as the Georgia Pacific factors. In the interest of time, I will not go into all 15 of the Georgia Pacific factors, but just realize that it's many, many steps, many different factors that get balanced to determine if a reasonable royalty is appropriate and what level that reasonable royalty shall be. Theoretically, lost profits can also be recovered, at least in some infringement actions against the government. However, such damages seem to be very uncommon. Now, under the Bayh-Dole Act, it depends on whether you are talking about the federal government or a third party. A federal government that funds research resulting in a patent retains a paid-up license. So theoretically, they could exercise their march-in rights and not have to pay any royalties at all to the patent holder. a third party utilizing Marchand rights under Bayh-Dole would be obligated to pay compensation upon terms that are reasonable under the circumstances. However, we have a Sleeping Beauty problem of our own in the United States, where Sleeping Beauty is still waiting for a kiss. That is to say, we don't have a single case where an agency has used Marchand rights or where a third party has successfully obtained Marchand rights and petitioned for compulsory licensing. So in the United States, we don't know either exactly how that would be calculated, what would be considered to be reasonable compensation, because we have no case law.
예, 감사합니다.
Thank you very much. So the Sleeping Beauty analogy is used extensively today. So in the case of Bayh-Dole Act, only in limited cases payment should be paid out. However, not a lot of court precedents exist. So let us compare with the Korean case. So I think this situation in Korea is similar. In the case of Korea, with regard to this issue, the Payton Act of Korea stipulates that when adjudicating grants of a non-exclusive license, the remuneration shall in principle be based on the total amount of estimated royalty for the patent term and shall be calculated by multiplying the following: the total estimated sales quantity, sum of estimated sales quantity by year during the practice term, the unit price of sales, an average of factory price by year during the practice term, and share a ratio derived from how much the patent contributed in producing the unit product, and the reference ratio of 3%. However, this is subject to change in 2 to 4% in light of practical value, industry applicability, etc. of the patent. In cases where the total sales quantities are hard to estimate, an amount of compensation or remuneration per product unit may be calculated as follows: the unit price of the product times share times the reference ratio. In addition, the cases where an amount of compensation or remuneration is not determinable as stated above, the amount may be determined pursuant to the criteria announced by the Commissioner of KIPO. According to the announcement aforementioned, the amount shall be based on the arithmetic means of the invention values evaluated by the 3 evaluation institutes. It is true that the formula used to calculate the amount of compensation for a compulsory license, which is the total estimated sales quantity times the unit price, and share times reference, is structurally similar to the reasonable royalty recognized as damages in patent infringement lawsuits. This is because if a compulsory license is granted, it shall be deemed that an agreement is made between the parties as stipulated in the written adjudication. However, the two are distinguishable in that a reference rate used for the calculating compensation is set to 3% and could be adjusted in a range of 2 to 4% in light of industry applicability, while the reasonable royalty should be determined in an objective and reasonable manner. Thank you very much.
Now let's move on to the third question on the procedures for compulsory licensing. I will ask 4 sub-questions together. So first, how does your country stipulate the applicant and respondent for compulsory licensing, and who adjudicates on a petition? And second, is a non-exclusive licensee eligible for compensation? And third, which process is used between documentary examination and oral argument? And fourth, how can parties appeal to the adjudication? First, let's hear from Professor Oli.
Thank you. So the applicant under German law is the company which seeks the license and must be capable of working the invention, and the respondent is the patent owner. The exclusive licensee can join the proceedings if it wishes as an intervener under the general rules of German civil procedure law. The competent authority for granting compulsory licenses is the Federal Patent Court, das Bundespatentgericht, and the Federal Patent Court applies its general rules of procedure, so basically the same rules of procedure which also apply in revocation proceedings. I should also point out that compulsory licenses can be granted in interlocutory proceedings, and they have actually been granted in interlocutory proceedings. In particular, the Ralte Gravier case, which I will talk about in a minute, was a case of interlocutory proceedings. A non-exclusive licensee is not eligible for remuneration. appeal against the decisions of the Federal Supreme Court can be made to the, or appeal against the decisions of the Federal Patents Court can be made to the Federal Supreme Court. This appeal is an appeal on both points of law and facts. Thank you.
예, 감사합니다. 독일은 행정부가 아니라 법원.
So the court, the patent court adjudicates on compulsory licensing. This is very interesting. And now let's hear from Professor Kumar for the US.
Under Section 1498, these cases are litigated in the U.S. Court of Federal Claims, and they are a bench trial similar to any other federal court case, but no trial by jury is available. Either the patent holder or an exclusive licensee is the applicant. Like either of those parties may file a Section 1498 proceeding seeking damages against either the federal government or a federal government contractor that's using the patent without permission. In the event of an adverse decision, the patent holder or exclusive licensee may appeal that decision to the U.S. Court of Appeals for the Federal Circuit. Non-exclusive licensees do not appear to have any rights under Section 1498. Under the Bayh-Dole Act, Marchand rights are subject to a very complex and cumbersome administrative process. So cumbersome that it's been subject of great criticism in terms of just how difficult it is to navigate. If the funding agency were to decide to issue a compulsory license under the Bayh-Dole Act, then the decision would not take effect until the inventor, assignee, or exclusive licensee had the opportunity to appeal the decision first. Again, non-exclusive licensees do not appear to have any rights under the Bayh-Dole Act. And again, I must mention, we don't have cases where a Marchand rights or compulsory license have been issued under the Bayh-Dole Act. So we can only speculate based off of what the statute tells us. Thank you.
네, 감사합니다. 예,
Thank you.
부끄러운 행정 절차가
Yes,
법에 따른 강제
you mentioned that maybe the extremely complex procedures may be a reason why there are no cases where compulsory licenses were granted under Bayh-Dole Act. Now let's hear from Professor Judge Singh for India.
Thank you. In India, we are there are two procedures with which the compulsory licensing can be granted. And any person who is interested could apply for a compulsory license to the controller. It can be opposed. The controller has to first take a prima facie view as to whether a case is made out to even start the proceeding. Once the controller thinks that there is some prima facie case made out, then the copy of the license petition is sent to the patentee. It can even be opposed by any licensee whose name may be on the register or any other person interested. It says any person desiring to oppose the application or the patentee. So it can, I think by that terminology, even a non-exclusive license can oppose the grant of a compulsory license. So after the application is filed, the usual pleadings are completed and a hearing has to be granted to the patentee or the opponent by the controller. Even in case of where the central government has, issued a notification for grant of compulsory license without hearing the patentee, thereafter all these procedures have to be followed and the proper terms and conditions would have to be set by the controller. So in India, the compulsory license cannot be granted by a court of law. It can be granted only by the controller. And after the controller has taken a decision on this matter, usually the matter used to go in appeal to the IPAB, but now the IPAB has been abolished a few months ago, and therefore it would go to the High Court concerned. The interesting question, however, is that in India, we've only had one major compulsory license which has been granted, and at least 3 or 4 of them which have been rejected. And I think in the next few questions, you would be highlighting that those cases, and I'll be discussing about the same. And insofar as documentary and oral evidence is concerned, yes, initially there are oral documentary pleadings and affidavits in evidence, but thereafter the oral hearing is also granted to the patentee and to the compulsory license applicant. So those are my comments on this.
네, 감사합니다.
Thank you. So the appeal is no longer going to be forwarded to IPAB, but the High Court instead. That was impressive. And lastly, we will hear from Judge Koo. So, as for Korea, in type 1 cases, applicant is the government, and in type 2, it is a person who intends to practice the patented invention. The respondent is the patent owner. And if exclusive license is granted, then whether exclusive licensee and the patent owner should be joint respondents or only the exclusive licensee should be is still debated. And KIPO's commissioner is the adjudicator. For type 1, non-exclusive licensees are eligible, but there's no clear provision when it comes to type 2, so this could lead to some debate. According to the presidential decree, in Article 4, well, the petition for adjudication has to be delivered to the non-exclusive licensee also, and when determining the compensation, the non-exclusive licensee's opinion will be heard. Basically, the adjudication is made through documentary examination, and the commissioner may hear the opinions of the Industrial Property Dispute Mediation Committee and the heads of relevant authorities. But for type 2, it is not only for determining the compensation, but also to make the adjudication itself. So it allows a wider, broader room for incoming opinions from diverse experts and relevant authorities. When it comes to appeal method for type 1, the general administrative opposition procedures is followed, while for type 2, administrative appeals or revocation actions can be filed against the adjudication. However, the compensation determined by the adjudication shall not be ground for appeal. This is to prevent the procedures from being delayed. In order to appeal the remuneration, there should be a separate suit that should be filed.
So the non-exclusive license holder can also receive compensation under the Korean law. I think that was a key characteristic of Korea. So we'll go on to the fourth and very last topic. In the case of the fourth topic, we'll look at the major cases related to compulsory licensing in the pharmaceutical area. We'll divide this topic in two categories. First, whether there are any cases in which pharmaceutical compulsory licensing has been granted or prices have been lowered because of this, and also whether there are any cases in which the compulsory licensing on pharmaceutical products have been dismissed. So we'll look at those cases where it was actually granted. With regards to Professor Kumar, so after the 911 attacks, there was a case where the drug price has been lowered for the ciprofloxacin antibody.
So in the early 2000s, there was a bioterrorist attack in which anthrax got sent through the mail system and thousands of people got sick, primarily postal workers. And the main treatment for these anthrax attacks was ciprofloxacin, which belonged to Bayer, was still under patent. So the US government sought to purchase large quantities of this antibiotic from Bayer, and Bayer was offering the drug, but at a relatively high price, between $1.75 and $1.83 per tablet. The government thought that this price was too high, and negotiations began. Now, during this time, Canada was licensing licensed the drug to a domestic pharmaceutical company to produce a generic version of ciprofloxacin without Bayer's permission. And when Canada did that, Bayer began negotiating with it and started offering better prices, finally offering it for only $1.30 a tablet. So in light of the Canadian government's successful negotiation, the US threatened to produce its own generic version of the drug. And moreover, it threatened to go one step further. It threatened to pass legislation to actually strip Bayer of any compensation. Normally under 1498, it would be entitled to a reasonable royalty, and the government was threatening to take even that away from Bayer. So faced with these threats, Bayer agreed to sell ciprofloxacin for only 95 cents a tablet. So theoretically, the government did not formally exercise its compulsory licensing power, but it threatened the Bayer Corporation, so it effectively was using that power. Thank you.
예, 감사합니다. 미국은 전통적으로
So traditionally, United States has been very passive in granting compulsory licensing. However, in this situation of anthrax attack for public interest, the United States government showed its willingness to intervene if necessary. I think this was a very significant case. Next, the floor goes to Judge Shing about the sorafenib case.
Yes, thank you. This was the sorafenib tosylate case, which was used for treating liver and kidney cancer. This was a drug which was not a cure. I mean, I must not use the word cure. It was expected to, increase the life expectancy of the patients who were suffering from cancer. And the drug itself was not being manufactured by Bayer in India. In 2008, there was hardly any imports. 2009-10, there were very, very minimal imports, and there were a large number of patients who required the drug. That's when the generic company called Natco applied for a compulsory license, and the price at which they agreed to sell the product to the consumers was 1 by 30th. I mean, 30 times lower than Bayer's product. And the product of Bayer was available for 120 tablets. It was $284,000, 284,000 rupees. And what Natco wanted to sell it was at 8,800 rupees. So it was considerably lower. And when they applied for the compulsory license, the controller looked into the statistics and looked at all the working that was being done by Bayer. I'm not sure there was any working at all by Bayer in India. There was no manufacturing, and it was hardly available to anyone in the public. And looking at the large mass of patients who required this drug, the compulsory license was granted in 2012, and at 4%, as I said earlier, net selling price as the royalty rate. And this went to the IPAB, which increased it from 6% to 7%. And this was upheld by the Bombay High Court and by the Supreme Court. What was interesting in this case was the fact that Bayer did not even choose to lead any evidence in respect of its investment in developing this drug. So I personally feel that if they had led that evidence, the royalty rate may have been higher, but the controller did take into account as to what could be a reasonable price, which the consumer or the patient can afford in India for kidney and liver cancer. And accordingly, the royalty rate was fixed by the controller. And in my own experience, this is the only case where compulsory license has been granted. And I must say that even during this pandemic, I was presiding over the writ jurisdiction in April and May when the second wave hit India. And there were several drugs where I used to find cases of drugs where patented drugs were not available at all. And they were being sold at 20 times the rate and in black markets. And therefore, I do think that patentees ought to have been, more made access to these patented drugs more easy, at least during the COVID pandemic. And I'm sure they are taking steps now, but we did face a big crisis during the second wave of the COVID pandemic. But no CL was issued.
네, 감사합니다.
So thank you very much. As we have heard, the Sorafeni case was the only case where compulsory licensing was granted in India. What is noteworthy is that when examining the granting of the compulsory licensing, what was most important was that whether it was provided at a reasonable price to the public. Next, we'll move on to Germany. With regards to the 2017 Federal Supreme Court decision of Rotogravir, please, Professor Oli, the floor is yours.
Thank you. So Rotogravir is the only case in recent German legal history in which a compulsory license was not only granted but also upheld by the Federal Supreme Court. The appellant in this case manufactured a substance called Rotogravir, which fell within the scope of the defendant's patent. And Rotogravir was a substance which was used to treat HIV infections, and it turned out that it had less side effects on pregnant women and on small children. Now, the applicant applied for an unlimited compulsory license. The Federal Patents Court rejected this unlimited compulsory license, but it was prepared to grant a compulsory license for the forms of administration which were already available in the market. And it did so in interim, or as you might call them, interlocutory proceedings. It's perhaps interesting to quote the second head note of the Federal Supreme Court judgment because it tells us something about the criteria for granting compulsory licenses. I quote, "A public interest in the grant of a compulsory license for a pharmaceutical substance can exist even when only a relatively small group of patients is affected. This is the case in particular when this group would be exposed to an especially high risk if the medicament in question were no longer available." In this case, the applicant was able to show that the respondent's product and all other drugs that were available on the market had significant side effects when administered, as mentioned before, to pregnant women and to small children. Given that these groups of patients relied on the drug and that there was no reasonable alternative in the market, there was a sufficient public interest, although both groups were very small. Thank you.
예, 감사합니다.
So thank you very much. In the case of Rotogravir case at the Federal Supreme Court of Germany, it was the only case in which the compulsory licensing has been recognized, especially in the decision of the Supreme Court. Rather than the small size of the patient, the small side effects of this product was emphasized. I think this was an important point. So because of the time constraint, we'll move on to the second question.
First, we will ask Professor Kumar to share cases about Xalatan of Pfizer and Fabrazyme of Genzyme and AbbVie's ritonavir. Thank you.
There's been various cases where public interest groups have petitioned the National Institute of Health, the NIH, to exercise march-in rights for drugs, but none of them have ever been successful. Back in 2004, petitioners sought march-in rights for Pfizer's glaucoma treatment drug, Xalatan, and the basis for that challenge was that the US price for Xalatan was higher than any other country in the world. And they argued that was making it too expensive for many patients. However, because the drug was readily available for purchase in the United States, the NIH denied the petition, saying that the drug was available. In 2009, another public interest group petitioned the NIH to utilize march-in rights for Genzyme's Fabrazyme drug. And this was a very notable case because there was an actual drug shortage of Fabrazyme. There was not enough to supply patients who needed this in the United States, and there was evidence that patients were being harmed because of this. And part of the challenge was brought by patients who couldn't get access to the drug. Nevertheless, the NIH still denied the petition. They noted that it would take too long to find a manufacturer willing to produce the drug and for that generic drug to gain regulatory approval, claiming that the drug shortage was not expected to last very long. Basically, the NIH was relying on assurances from the pharmaceutical company, even though the delay kept getting longer and longer than what was originally promised. A third petition attempt in 2004 and also 2012, public interest groups asked the NIH to utilize Marchand rights for 6 patents used to manufacture AbbVie's drug ritonavir in order to reduce the cost of the drug. And again, the NIH denied the request, concluding that AbbVie was producing an adequate supply of the drug and that they were providing it for free or at reduced cost for those who could not afford to pay the full price. And the NIH once again declined to address pricing disparities between drug prices in the United States versus every other high-income country in the world. So together, these unsuccessful attempts show how reluctant the government is to utilize Marchand rights in the United States, even when there are drug shortages. Thank you.
네, 감사합니다.
Thank you. Next, the floor goes to Judge Singh to share cases on dasatinib of BMS and AstraZeneca's saxagliptin. Thank you.
Okay. In the case of dasatinib, this is a drug used for the treatment of chronic myeloid leukemia, CML. And in India, the cost of this drug was approximately about $1,360 and for a month's therapy. Whereas what the BDR Pharmaceutical suggested as a generic company when it applied for a compulsory license was that it would sell it at $100, or less than 10%, about 8% of the total cost of the patentee's drug. But when BDR filed for an application for grant of compulsory license before the controller took the view that the requirements and the conditions under Section 84 were not satisfied, and the compulsory license was rejected by the controller. The company then, the BDR company went to the central government under Section 92 as well. But the central government held that there was no national emergency or urgency or any kind of crisis which required the grant of a compulsory license. So this was one of the cases where it was rejected. In the second case of Lee Pharma versus AstraZeneca, this is a drug called saxagliptin, which is a gliptin drug meant for diabetes treatment. And even in this, the case of Lee Pharma, the license application of Lee Pharma was rejected. The controller took a very interesting view in this matter. What the controller did was he used the comparable drugs which were available in the market, the various other gliptin drugs which were available, and felt that there was no major requirement because there were various other gliptins which were available, and also that those drugs were also available at an affordable price. The controller also held that saxagliptin's price was comparable to the other gliptin drugs. So on both issues, on the availability and on pricing, the controller took a view in favor of the patentee, that is AstraZeneca, and rejected the petition for compulsory license by Lee Pharma. I'm aware of one more case where the license was rejected because in India, post the Doha Declaration, under 92A, an Indian company can even export to a foreign company which does not have a manufacturing setup. And there was one application by NATCO, I remember, for export of a patented drug to Nepal. However, the controller rejected it on the ground that the proper sale and invoicing, etc., was not produced. And they were not sure about the genuinity of the person purchasing it in Nepal, though, of course, Nepal did not have sufficient manufacturing capabilities. So a large number of CLs have been rejected by India, unlike the perception which is there internationally about this.
예, 감사합니다. 다음은 독일의 오올리 교수님께 폴리페론
Thank you very much. Next to Professor Oli, pass the floor so that you can speak about the 1996 Federal Supreme Court's decision on polyperon as well as the alirocumab.
Thank you. There are two cases in German law in which applications for compulsory licenses were rejected. The first one is the decision of 1995. That's the polyferone case. Concerned an ingredient called interferon gamma, which was used to treat arthritis. And the applicant argued or claimed a compulsory license and argued that polyferone was a very valuable drug because it had received an early marketing authorization and it was the only drug containing this particular ingredient which was better for the treatment of arthritis. Well, the Federal Patent Court granted the compulsory license. It thought that the invention of a new application of a patented substance was a strong indicator for the public interest and that the disease in question here, namely arthritis, was a very serious disease. The Federal Supreme Court, however, allowed the appeal. This was really the first judgment in recent German legal history which concerned compulsory licensing. So the Federal Supreme Court reviewed older judgments of the time before the Second World War, also looked into the Paris Convention. And then the Supreme Court agreed with the Patent Court that the public interest could justify the grant of a compulsory license if the pharmaceutical product had therapeutical qualities which were significantly better than those of the drugs available in the market. However, on the basis of the evidence given by a court-appointed expert, the Federal Supreme Court was not convinced that polyferone actually had these properties, so the case failed or the application failed on the facts. The second case is a recent case, alirocumab, decision of 2020, and this second case is concerned a monoclonal antibody which reduced cholesterol levels, and the applicant claimed that this drug was significantly better than anything else on the market and that it actually saved lives. Now, once again, the second head note of the Federal Supreme Court is quite instructive, and I quote, "Public interest requiring the grant of a public license for a medicinal product may be affirmed if significant results of a clinical study according to recognized principles of biostatistics have shown that the active substance of the medicinal product has therapeutic products which are not or not to the same extent proven for other products on the market." However, the application failed on the facts. The applicant had argued that its product significantly reduced the risk of people dying from metabolic disorders, and the court felt that the applicant had not satisfied its onus of proof, and hence the Patent Court and also on appeal the Federal Supreme Court denied the compulsory license.
네, 감사합니다.
So thank you very much. After listening to the cases in different countries, so I think the ground for admitting the granting the compulsory licenses is similar. However, the grounds for dismissing is all different. So happy families are all happy for the same reasons, but unhappy families are unhappy for different reasons. This was a quote from Anna Karenina, and I'm reminded of this quote. And now I pass on the floor to the Korean speaker. So in the case of Korea, there are not many cases of compulsory licensing, and so I'm going to introduce two represented cases where the application had been refused. So first is the Gleevec case. The Gleevec is a treatment for leukemia. Non-government organizations against Novartis, the patentee, filed a petition for adjudication on grant of non-exclusive license for Gleevec. The principal ground for the petition for adjudication was that it was particularly necessary for the public interest to provide an affordable generic drug by granting a compulsory license because of insufficient supplies of Gleevec and its high price that hinders the patients suffering from CMR from consuming the drug. The respondent argued that in determining whether to grant a compulsory license, the following factors must be taken into account: the urgency of granting the compulsory license, number of patients, contagiousness, the accessibility of the drug, existence of alternative means. However, the respondent argued that the alleged compulsory license should not be granted because the number of patients was only about 600, the disease was not infectious, the drug has been supplied sufficiently, and Gleevec is not on the list of WHO list of essential medicines. The Commissioner of KIPO dismissed the petition for adjudication on the following grounds. All chronic leukemia patients were subject to national health insurance at the time, meaning patients only have to pay about 10% of the drug price set by the Ministry of Health and Welfare, and Gleevec supply was sufficient at the time, and importing the drug for self-medication pursuant to the relevant articles stipulated in the Foreign Trade Act was allowed. Let me introduce a second case, the Fuseon case. Fuseon is a medication for terminally ill AIDS patients, and Korean non-profit organizations filed a petition against Trumeris, the owner of the patent for Fuseon. The petitioner argued that even if Fuseon was urgently needed to treat AIDS and irreplaceable patients, access to the drug was severely restricted as Fuseon was not supplied in Korea for at least 4 years due to a failure in negotiation on the price. And the Commissioner of KIPO dismissed the petition for adjudication. The Commissioner saw that the damage to the patent system would be greater if the patent right was to be restricted on the ground of discontinuation of drug supply due to negotiation failure on the price. Not only that, the Commissioner considered the following factors: practitioners and non-government organizations failed to present detailed execution plans such as direct manufacturing, outsourced manufacturing, the import of the drug. Thus, it was unclear whether the patient's access to the drug could be protected with the grant of a non-exclusive license. And AIDS medications other than Fuseon had been continuously developed and commercialized in Korea, and the patient's access to medicine was improved as the patentee supplied Fuseon for free, and the urgency of adjudication was eased. Thank you very much.
Thank you. So those were responses from all of the panels on the prepared questions. We filled up our 1 hour allotted for the session, but do we have any questions from the floor? Please raise your hand if you do. Yes, since we are short on time, I think, yes, it'd be a good idea to end the session here. I'm so regretful that we have to end so soon, but we heard about the compulsory licensing systems from all of the panelists' countries. We earned a lot of insights. We had the honor of listening insights from honorable panelists. I hope we will have another opportunity to hear more deeply about the topic from our panelists. And thank you for all the on-site participants also. So that would bring an end to this session. Thank you.
Thank you very much. With this, we would like to wrap up the second session. We would like to thank our moderator as well as also the Korean speaker for moderating this session.
잠시 휴식 시간을 가지신 후 14시 20분부터
We'll have a short break and starting from the 20 past 2, we will begin the third session.
Session 3 will begin at 4:20. From 2:20, Session 3 will begin. So please enter the hall and take your seats. Session 3 will begin shortly. Please take your seats. Session 3 will begin shortly. Please take your seats.
이번 세션은 인공지능 시대의 특허법상 도전들이라는 주제입니다. 오전 기조연설에서 마르코 알레만 와이퍼 사무차장보님이 언급하신 다보스 사건들을 포함하여
So this session is on the challenges of the era of AI, along with Davos case that Marco Aleman, WIPO Assistant Director General, mentioned. We will explore various issues related to patent and AI. So please welcome Woo Sung-yeop, Judge of High Court. And Lee Hae-jin, also Judge of High Court, and Kim Kwang-nam, Judge.
안녕하세요. 저는 방금 소개받은 대한민국 특허법원의 우성엽 판사입니다.
Thank you for the introduction. I am Woo Sung-yeop, the High Court Judge at Patent Court of Korea. So, in the alphabetical order, I would like to introduce panelists for this session. Please refer the booklet for their detailed bio. Please give them a big round of applause. First, it's Raymond T. Chen, Judge of the United States Court of Appeals for the Federal Circuit. He sent his pre-recorded presentation. Second is Hae-jin Lee, the High Court Judge of Patent Court of Korea. Third, it's Kwang-nam Kim, previous judge at the Patent Court and the Daegu District Court of Korea. And fourth is Mark Lemley, professor at Stanford Law School. Fifth, Richard Mead, a judge in charge of intellectual property in the High Court of England and Wales. Sixth, we have Judge Hu Ami from Shanghai High People's Court in China. Seventh, we have Judge Nai Peram from the Federal Court of Australia. And eighth, we have Presiding Judge Tamotsu Shoji from Intellectual Property High Court of Japan. Judge Shoji also sent his pre-recorded presentation. As such, it's an honor to have honorable judges and professors from around the world. The Japanese and the American panelists have sent pre-recorded video clips, and all other panelists are here with us real time virtually. Despite your busy schedules, thank you for joining this conference. And it's 5:20 in the morning in the UK, so special thanks goes out to Judge Richard Mead. This session, we will look at the challenges to the Patent Act in the era of artificial intelligence, and I look forward to hearing insights from the panelists. Especially, we will first look at the patent eligibility of AI programs and the patentability of AI-related inventions and Patent Act-related issues that has to do with AI inventions, and fourth, about the infringement by AI. So, since we have received detailed responses from all the panelists, which are in the reference book, please refer to that. We have many panelists for this session, as well as many topics, so I apologize in advance for not allotting enough time. So please make your answers within the allotted time. And I have one more announcement. To all the participants in the seminar, whether the AI can be viewed as a person who has ordinary skills in the art, POSITA, and whether we need to amend the Patent Act to give the status of inventor to the AI. This is asked through a survey, so please, if you receive the text, please answer the survey. Given the time constraint, let's jump into the topic. So the general concept of AI-generated invention is as what you can see in the slide. Please refer to that. Let's look at the first and second subtopics. It's the AI robot cleaner system case. The claim is on the left side of the booklet, and this robot cleaner system, this is where the learning data A is learned with algorithm B. So video recognition model is included in this system. We will now begin with the first question. It is about the patent eligibility of AI program inventions. Common questions 1 and 2 will be asked together. So please inform us of the examination criteria or determination criteria for patent eligibility of AI program inventions in your country. Second, please let us know if the program itself is a patentable subject matter or whether it has to be equipped within a storage device in order to be eligible. Please limit your answers to 1 minute and 30 seconds. So the alphabetical order of the country's name will be followed for the responses. First, we will hear from Judge Humi from China. Thank you.
Hello, Humi 판사님.
Hello. Professor Humi?
Yes, I'm here. Hello.
예, 답변을 부탁드립니다.
Your answer, please.
In China, for the common question 1, in China, the Patent Office of National Intellectual Property Administration (PRC), hereinafter CNIPA, accepts, examines, and approves patent applications and authorized patents. According to the patent law of the PRC, the inventions as used in this law means inventions, utility models, and designs. According to the guidelines for patent examination, there are no examination or determination criteria specifically for AI program inventions, but examination criteria for inventions involving computer programs can be for reference. Since authorizing patents is a duty of the CNIPA, the judge in China will not re-examine the eligibility of the patent generally. For common question 2, according to the patent law of the PRC Article 25, rulers and methods for mental activities should not be granted patent rights. According to the guidelines for patent examination, the invention patent application involving the computer program, which is a part of technical solution, is the object of patent protect. The purpose of executing the computer program to solve technical problems, to control or handle external or internal objects by technological means of running the program on computer, and thus get technical effect in accord with nature, makes the computer program patentable. Therefore, in China, the AI program itself is not eligible for patent registration if the program can't be combined with specific technical solution. Thank you.
Thank you very much for that answer. So in the case of China, with regards to program inventions, if they cannot be combined with devices, they are not patent eligible. So next, moving on to Japan, Professor Tamuchi will hear his video message.
Patent eligibility of AI program inventions. Common question 2. In Japan, a program itself is concluded in the definition of the product invention. Patent Act, Article 2, Paragraph 3, Subparagraph 1. As for a patentable subject matter, the program itself can be patent eligible if a claimed invention recites the creation of a technical idea utilizing the law of nature. Patent Act, Article 2, Paragraph 1. According to the examination guidelines for patent and utility model of Japan Patent Office or JPO, the creation of a technical idea utilizing the law of nature can be established by proving that information processing by the software is concretely realized by using hardware resources. Also, in accordance with Article 2, Paragraph 4 of the Patent Act, not only a computer program itself, but also any other information equivalent to a computer program can be patent eligible.
예, 일본 조지 판사님
Yes, thank you very much for that answer. As you are well aware, in the case of Japan, in the patent law, the program itself is recognized as invention of an object. And next, we'll move on to Korea. In Korea, Article 2, Paragraph 1, the Patent Act provides that the term invention means the highly advanced creation of a technical idea utilizing the laws of nature. However, the Patent Act does not prescribe a program itself as a product invention. The Korean Intellectual Property Office provides patent examination guidelines that show the patent eligibility for an AI invention as follows, where the specific software in an AI-related invention performs data processing using hardware. The following constitute the creation of a technical data utilizing the laws of nature. The data processing device that operates in cooperation with software, the operating method itself. However, a computer program itself is only a set of orders stored to operate a computer, and thus is not a creation of a technical idea utilizing the laws of nature and cannot be deemed as an invention in Korea. An AI program itself is not patent eligible, but an AI program stored in a computer readable medium is. So far, no precedent presents how to treat AI program inventions in Korea. As you can see from the slide, the number of patent applications in Korea related to AI is increasing sharply. Thus, we expect that the market is going to expand at a rapid pace going forward in this area. Thus, we can expect that there will be a case where patent eligibility standard for AI-generated inventions is determined. Thank you very much. Thank you for the answer. Next, from UK, Judge Richard Mead will hear your answer.
Mr. Chairman. Thank you very much for your kind invitation. In the UK, this law is governed by an international treaty, the European Patent Convention, which is applied uniformly in the states that are signatories to the EPC, and the eligibility for patentability of computer programs is dealt with by Article 52 of the European Patent Convention, and this provides that a computer program as such is not patentable. But a computer program may be patentable if it is claimed in a form which gives rise to a technical effect. In particular, a technical effect can reside in controlling a real physical system, or indeed in controlling the physical operation of the computer itself. But the computer program on its own is not patentable, and nor is it an adequate technical effect that the computer program runs, for example, faster. There's been quite a lot of law in the European Patent Office about this, and in my document, which is in the handbook, there are quite a lot of examples given of situations where computer programs have been held to generate a technical effect, and therefore the overall effect is that with a proper claim form, AI can be embodied in an invention. Thank you.
네, 답변 감사드리겠습니다. 예, 들으셨다시피 영국이나
As you have heard,
원칙적으로 프로그램 자체는
in principle, in UK,
테크니컬 이펙트, 그러니까 기술적 효과가
they're not deemed as a patent eligibility, but if there is significant technical effect, they can be deemed as patentable.
미국 패널 분들의 비디오 답변은
And now the video message from the US speakers encompasses the common questions 1 as well 2. So in the second topic, we will be showing the video.
그러면 첫 번째 질문을 마치고 두 번째
And now move on to the second question.
넘어가겠습니다. 이번 질문은
Moving on.
이번 질문은 인공지능 관련
This question is about whether the learning data or learning data structures or algorithms have patent eligibility. So please explain whether your country has precedents or some academic discussions regarding this topic, and please limit your answer to 1 minute and 30 seconds. First, we will hear from Judge Humi from China.
In China, if a claim is essentially to protect the computing and operation of the data, but application did not reflect that the algorithm can be used to solve specific technical problems in some technical field, the claim can't be regarded as patented technology by which can solve specific technical problems and get technical effect in accord with nature. That's to say, whether or not the data or algorithm have the patent eligibility depends on if they can be used to solve a specific technical problem or not. Up to now, that and the algorithm by itself are not eligible for patent registration. Thank you.
네, 답변 감사합니다.
Thank you for your answer. Judge Humi mentioned that algorithm and data itself has no patent eligibility, but it has to be seen whether it has effect of solving specific technical problems. Next, we will hear from Judge Shoji from Japan. We will watch the video.
Question 3. Since running data is mere information or mere material, running data can't be in a computer program. Then, how about any other information equivalent to a computer program? It means to have similar properties to programs in terms of prescribing computer processing, so that mere presentation of information such as running data can't obtain patent eligibility. On the other hand, according to Examination Handbook for Patent and Utility Model of JPO, data structure satisfies the condition I mentioned, and it can obtain patent eligibility as any other information equivalent to computer program. About algorithm, creation of mathematical theorem as mere arbitrary arrangements or mere mathematical formula can't be an invention, which means creation of technical ideas utilizing the law of nature. On the other hand, a trained model that can be evaluated as information processing by the software is completely realized by using hardware resources can be deemed as a program or any other information equivalent to computer program.
예, 답변 감사드리겠습니다. 예, 이어서
Thank you for your answer. Now we will hear from the Korean panel, Haejin Lee.
대한민국에서는 학습 데이터나 알고리즘
Well, Korea recognizes in Korea, well, the algorithm itself cannot be an invention, but if it is stored in a device or a medium, then it may be patentable. So the claims of the storage device or the computer device can be included in the claim. So a computer readable medium that records data structures such as structure A, B, and C, etc., operated in a computer may be an example of a claim. And recording medium that is readable with a computer recorded with a computer program that runs with means or function A, B, C may be an algorithm claim. So when it comes to AI-related inventions, learning data and algorithm are important elements that determine the performance of the technology. As the process outcome may vary depending on the factors such as type, nature, quantitative size, and qualitative level of learning data, the type and complexity of the algorithm, and the number of layers, there is heightened awareness about the importance of learning data and algorithms. So it will need protection under patentability. Thank you.
그럼 이어서 영국의 리처드 미드 판사님의 답변을
So now let's hear from Richard Mead.
Thank you. In the EPC, there is no specific legislative provision for artificial intelligence, and they therefore have to be considered in the category of computer programs generally. But the European Patent Office's guidelines do contain a lot of information about how AI inventions are handled, and they include examples of inventions which can be claimed. So one example they give is the use of a neural network in a heart monitoring apparatus for the purpose of identifying irregular heartbeats. And that's an example where a technical contribution is achieved. And the technical contribution in question is the monitoring and gathering of that information. And another example that they give in the guidelines is the classification of digital images, videos, audio, or speech signals based on low-level features such as edges or pixel attributes. So, as I say, there are concrete examples, and there's no, in principle, reason to deal with AI as a separate category from computer programs, and they therefore can be patented as long as they don't attempt to claim the algorithm as such, and also noting that it's not enough to obtain a technical effect just that the algorithm is included on a physical storage medium. There has to be a technical effect in the real world. Thank you.
예. 미드 판사님 답변 감사드립니다.
Yes, Judge Mead, thank you for your answer.
5에서
The EPO
기술적 기여가 있어야 하고 기술적
shows that technical effect and technical contribution are required for patent eligibility.
첫 번째 주제에
So
질문과 답변을
we heard all of the answers for that question. Now let's move on to the second topic.
두 번째 주제는
So second topic is the patentability of AI-related inventions. In AI-related inventions, the importance of learning data and algorithm are gaining increased recognition. However, there is discussion about whether such learning data should be regarded as information, an algorithm be treated as mathematical formula, so that they should be excluded in the judgment of inventive step. So there is a discussion about this. With regards to learning data and algorithm, 1-1 and 1-2 questions, we'll put it together. First, please explain whether your country deems learning data as an element subject to inventive step determination of an AI program. Secondly, if there is a case where the only thing that differentiates the invention described in claims and publicly known prior art is the data, while other features and functions, means, and steps are of the same kind. In this case, can an invention obtain the novelty? An inventive step, only with the difference of such data? So please limit your answer to 1 minute. First, to Judge Homi from China.
According to the patent law of the PRC, the inventions are used in this law means inventions, utility models, and designs. The invention refers to any new technical solution relating to a product, a process, or improvement for. Generally, if learning data is an integral part of the technical solution, it will be subject to inventive step determination. If the difference in data is not enough to make substantial difference between technical solution in the claims and the prior art, the invention can't obtain novelty only with the difference of such data. Thank you.
예, 답변 감사드립니다.
Thank you very much for that answer.
필수 요소로
So as an accession component, if the data is recognized as essential component and when there's differentiation with prior art, there is a possibility of it being recognized for inventive step. Next, we'll hear the answer from Shamusoji through videos.
AI-generated inventions. 1. Running data and algorithm. Common question 1, 2. Since running data themselves are mere information, it seems that such a claimed invention can't obtain the novelty and an inventive step. However, according to the examination guidelines of JPO, an invention that has characteristic relating to modification of training data and processing of training data can obtain the novelty and an inventive step. Accordingly, in the AI robot cleaner system case, where all elements other than learning data A are identical, if the learning data A has the characteristic I mentioned, the invention can obtain the novelty and an inventive step in Japan.
네, 답변 감사드립니다.
Thank you very much for that answer. Next,
이혜진 고판사님의 답변을
we'll hear the response from Judge Lee. So Supreme Court decision 2009-436 held that patent eligibility of an invention should be determined based on the entirety of what is claimed. Further, in Supreme Court decision 2005-3284 held that when a claim of a patent invention is comprised of more than one element and elements are organically combined, the technical idea of the whole claim is the substance of invention subject to the inventive step analysis. Therefore, in determining inventive step of a claimed invention, it is not encouraged to disassemble the claim into a number of individual elements and then examine whether each separate element is publicly known or not. Thus, the Supreme Court decided that an inventive step of a patent invention shall be determined based on the entirety of the invention in its organic combination. Considering this, as to AI program inventions, the learning data disclosed in the claim shall also be subject to the determination of inventive step as a part of the whole organic combination. Further, as stated above, that the learning data itself is independently patent eligible in the form of a claim. Next, we'll move on to Professor Judge Mead from UK.
Thank you very much. In the law that we apply in the UK and the European Patent Office, the exclusion under Article 52 for computer programs as such is separate and different from the assessment of inventive step. And as long as a method or product claim which includes a computer program has the required technical effect, then inventive step is assessed taking account of all elements of the claim, including any computer program or learning data or similar. And therefore, the answer to the question is that learning data is part of the consideration for inventive step, and it can provide the necessary differentiation from the prior art. Thank you.
네, 답변 감사드립니다.
Thank you very much for that answer. So it can be subject to inventive step determination, and where there is technical effect, then inventive step can be recognized. And so
이어서 학습 데이터
next,
알고리즘 관련된 질문을
moving on from
드리도록
the learning data, we'll move on to the algorithm.
예. 먼저
First,
프로그램 발명의 진보성 판단에 있어서
please explain whether your country takes an algorithm subject to inventive step determination of an AI program invention. And like the question on the learning data, when compared with publicly known prior art, if everything else is the same and there is only the difference in algorithm, can, based on the algorithm alone, can novelty or inventive step be recognized? So please limit your answers to 1 minute. So, Judge Humi, you go first.
Under the current patent examination system in China, if an algorithm can be combined with a specific device or can be applied into a specific technology scenario to solve technical problem, then such a algorithm can be subject to inventive step determination of an AI program invention. If different algorithms lead to different technique solutions, the difference in technique solutions makes claims of the patent application inventive. Thank you.
Thank you very much for that answer. In China, algorithm for a particular, if it is combined to a particular device or scenario and it can solve a technical problem, then its inventive step can be recognized. And so we'll hear the answer from Judge Tamochi from Japan.
There are no precedents in Japan. In my personal opinion, if algorithm B has not been previously used with respect to solving problems in the specific technical field that the invention belongs to, the novelty and an inventive step of the invention can be recognized with such a difference in algorithms.
예. 깔끔한 답변.
Thank you for that very concise answer. And now we will hear the answer from Judge Lee from the High Court. When it comes to AI-related inventions, there's a growing awareness of the importance of learning data because the processing results can vary depending on the type, nature, and quantitative size. The CNN that has enhanced the function of artificial intelligence is used. If an application abstractly recites a type of algorithm without more, it will be difficult to recognize as an inventive step based on the difference of this only. However, the performance of the AI would depend on the layer and the complication of the algorithm. And so if the kind of algorithm is indicated in the claim, then based on such difference in algorithm, inventive step can be recognized. Thank you very much for that answer. Now we'll hear from Judge Mead from UK.
Thank you. Yes, the answer to this question is that in principle, the inventive step can reside solely in the algorithm, as I explained previously. It is worth saying that the European Patent Office assesses inventive step by what is called the problem and solution approach, and it therefore would be necessary that the algorithm should achieve some actual technical advance compared with the algorithm in the prior art. But the answer to the question is that in principle, even if everything is the same between the patent claim and the prior art apart from the algorithm, then inventive step can reside in the nature of the algorithm. Thank you.
Thank you very much for that answer. The performance of the algorithm and the function of algorithm can actually lead to a decision for inventive step.
Thank you. Now let's move on to the second sub-question of the second topic. It's about person having ordinary skill in the art, FOSITA. So with the advancement of AI technology, there are talks that in the near future, an AI that can learn all prior art, so machine having ordinary skill in the art, MOSITA, might replace FOSITA. This is the talk of the day. So common questions 2-1 through 4 will be asked together. There are many questions. So first, please inform us of the determination criteria to confirm the technical level of the FOSITA and the prior art in your country, and explain whether the recent development of AI technology has impacted the determination criteria stated above. Second, please explain the degree of technical level of FOSITA, well, with the relation to the case of the cleaner robot example that we have explored, and the scope of prior art that should be considered. And also, the technological level of FOSITA will be more advanced, and the scope of prior art is to be expanded due to the development of AI, which will make it more difficult for an invention to be granted a patent. Please inform us of your opinion thereon. So we have allotted 3 minutes for each response for this question. So we'll hear from Judge Humi first.
Well, 2 questions before. According to the guidelines for patent examination, first refers to a hypothetical person who is assumed to know all of the common technical knowledge in the field before the date of filing or the prior date, to know all of the prior art and is capable of conducting routine experiments before above-mentioned date, but not being creative. If the technical problem to be solved leads to the person to seek technical means in other fields, the person should also have the above-mentioned capacity. According to the patent law of the PRC Article 22, the prior art referred to in this law means any technology known to the public before the date of filing in China or abroad. The prior art includes technology publicly published in domestic or foreign publications, publicly used or otherwise known to the public at home or abroad prior to the filing date. The prior art should be available to the public before the filing date and includes contents from which the public can learn substantive technical knowledge. In China, at the legislative level, the recent development of AI technology has not impacted the determination criteria stated above yet. For the questions 2, 3 to 4, in China, the Patent Office of CNIPA is responsible for patent examination. As a judge, my opinion may not be so professional. With the progress of the time, the development of technology and the scope of prior arts will definitely expand. The AI is also part of the technology. The AI definitely have influence on patent licensing, but it's difficult to predict the scope and the degree of the influence. So perhaps it might be easier to acquire patent licensing with the help of AI, not more difficult, is my opinion. Thank you.
예, 답변 감사드립니다. 예, 다음으로
Thank you for your answer. Now we will listen to Judge Tamuchi. Thanks.
To person having ordinary skill in the art. Current question to 2. In Japan, Patent Act stipulates definition of the facete as a person ordinarily skilled in the act of the invention. Article 29, paragraph 2. A person ordinarily skilled in the act means a hypothetical person who meets all the following four conditions. 1. A person who has a common general knowledge in the technical field. 2. A person who is able to use ordinary technical means for research and development. 3. A person who is able to exercise ordinary creativity in the selecting materials and modifying designs. 4. A person who is able to comprehend all the matter in the state of the art in the technical field, and comprehend all technical matters in the field relevant to problems to be solved by the invention. Accordingly, the degree of technical level of the facete in the case above should meet all conditions I mentioned in the technical field of the cleaner. Common question 2-3. In Japan, the scope of prior art to be considered is required to all the following conditions 1-4. That is, 1. Relation of technical fields. 2. Similarity of problems to be solved. 3. Similarity of operation or functions. 4. Suggestions shown in the content of prior art. Accordingly, the scope of prior art to be considered on the case above need to contain cleaner field, robot field, and AI program field.
예, 쇼지 판사님 답변 감사드립니다. 그러면 이어서
So thank you very much, Judge Shoji. And now we'll listen to the answer from the Korean judge, Judge Lee.
판단의 진보성은 통사의 기술자, 즉 토진파의 기술 수준에 근거하여 판단하고 있습니다.
So the inventive step of a patent invention is determined based on the technical level of the posita. As AI technology advances, it is being discussed whether the person with ordinary skill in the art posita can be replaced in the near future by a machine having ordinary skill in the art. Hereafter, the Musita AI, which is an artificial general intelligence that can learn and practice all prior arts. Such a shift from posita to Musita would not be considered as an abrupt and unprecedented change under the Payton Act. The hypothetical concept of posita can sufficiently help to carve out the concept of Musita. In practice, we see that a posita is a hypothetical person under the Payton Act that possesses the general technical knowledge in the relevant technical field and who can collect all the information in the state of art in the field relevant to the technical problem of the invention before the filing and make it his or her own. Therefore, as technology advances, it is expected that the level of the posita would also rise to a higher level. Additionally, a composition that belongs to a different technical field, but a posita can easily utilize, can be used as a prior art to deny the inventive step of a patented invention. As convergence technology advances, the boundaries between technical fields have continued to blur. For these reasons, the expansion of the scope of prior art is also predicted. So, such a shift from posita to Musita would not be considered as an abrupt and unprecedented change under the Payton Act. The hypothetical concept of posita can sufficiently help to carve out the concept of Musita. So, personally, I do not expect substantial changes in the standards for determining an inventive step of patent applications until reaching the singularity at which AI exceeds the sum of intelligence of all human brain power. However, as AI technology advances, the technical level of the posita is expected to go up and the scope of the prior arts to expand. As such, the technical level of a posita and the scope of the prior arts are expected to present important legal issues in lawsuits in the future. As you can see from the slide, in the case of the invention of a robot cleaner in which AI technology is used, who should be the posita? In my personal opinion, along with the robot cleaner technology, the IoT technology, and the AI technology, the person that has all these technology will be posita. The prior arts to be considered would also include the aforementioned technologies and their adjacent fields. In reality, experts from these technical fields team up to develop AI robot cleaners, such as the example that we have seen, then the POSITA may also be such a team of experts. That is all.
네, 답변 감사드립니다.
Thank you very much for the answer.
이어서 영국의 리처드 미드 판사님의 답변을 듣도록 하겠습니다. 부탁드립니다.
Judge Mead, it's your turn now.
Thank you very much.
네, 감사합니다.
The skilled person or the skilled addressee is a fundamental concept in UK and European patent law. We refer to the skilled addressee, but in appropriate cases, the person of skill in the art can be a skilled team incorporating multiple disciplines, and in advanced fields of technology, that is very commonly the case. The skilled person possesses the common general knowledge of their field. They do not have necessarily knowledge of all of the prior art unless it is common general knowledge, and they're not entitled to consider items of prior art together unless it would be obvious to combine them. And I'll say more about that in just a moment. We assess who the person of ordinary skill is from factual evidence about what teams are working on the relevant problem in the real world. And we also combine that with drawing inferences about the task that is set by the patent in suit to implement its teaching. And it's to be inferred that the person of skill in the art has adequate technical training to put the patent into effect. The person of skill in the art has a concept that has had to be adapted for appropriate technology many times over the years. For example, in relation to genetic engineering, it was necessary to reassess the court's approach. I'm sure there will be a fresh assessment for AI, but I don't think there will be fundamentally any different approach taken. The technical level of skill or qualification of the skilled person depends on the field in issue, and no doubt for artificial intelligence inventions, that person will have a postgraduate degree or a doctorate. So far as the scope of the prior art is concerned, I've already said that the skilled person is not deemed to know all of the prior art. They're only entitled to consider pieces of prior art one at a time, but in principle, prior art from any field at all can be considered and can be put forward by somebody who's attacking a patent, because the policy of our patent law is that people must be free to work any item of knowledge available to the public, and therefore there is no conceptual limit on the prior art that can be cited, although if it's not from a relevant technical field, then the court may consider that the ordinary skilled person would simply reject it and not carry it forward. I don't myself think that there's any danger that the high degree of skill required in this field will change the requirement for inventive step, because the skilled person may be very, very highly skilled, but as a conceptual matter in our law, they are completely lacking in any inventive characteristics, and therefore this shouldn't make a difference to the assessment of inventive step. Thank you.
예, 답변 감사드립니다. 예, 통상의 기술자는 진보성
Thank you for your responses. So, POSITA also is a very important criteria when we examine the specifications of the applications also. So, please look at the reference book for more details when it comes to the response from the judge, Richard Mead, and it gives a very interesting light on this case, and the fact that POSITA does not have to be aware of all prior art is a very interesting comment from Judge Mead. Thank you.
두 번째 주제의 마지막
So we will move on to the last sub-question of this second topic about the specification requirements. When it comes to AI program invention, learning data and algorithms are rarely specifically mentioned, but rather they are recited in a vague manner. So whether the applicant can properly fulfill this element is an issue. So here comes two questions with regards to this topic. Regarding the requirements for the specification, please introduce if your country has any criteria. And when it comes to AI program invention, if learning data and algorithm are not definitely specified in the specification, does this violate the requirements for the specification and claims in your country? Please limit your answer to 2 minutes. We will first hear from Judge Humi from China.
For common questions 3.1, the answer is according to the patent law of the PRC Article 26, specifications shall set forth the invention in a manner sufficiently clear and complete so as to enable a person skilled in the relevant field of technology to carry it out. Where necessary, drawings are required. The abstract shall state briefly the main technique points of the invention. The claims shall be supported by the specification and shall define the extent of the patent protection sought for in clear and concise manner. For common question 3.2, according to the patent law of the PRC, the fundamental requirement for the specification and claim is that a person skilled in the relevant field of technology can carry out patent technology in light of the contents of the specification, solve the technical problems, and produce a designed technical effect. In the case above, if there is no specific learning data and an algorithm in the specification so that the person cannot figure out the technical solutions, then the patent specification is deemed as a violation of the requirements for the specification. Thank you.
Thank you for your answer. So, if technical solution cannot be figured out based on the specifications, then it would be a violation of the requirements for the specification, according to your answer. Thank you. And now we will listen to Judge Shoji.
3. Requirements for specification. Common question 3.2. In Japan, with regard to the requirements for the specification, Patent Act provides 3 requirements such as enablement requirement, support requirement, and clarity requirement. If it is not specified as running data A and algorithm B, but simply disclosed as running data and an algorithm, it would be a violation of enablement requirement and support requirement in Japan. The reason is as follows. Enablement requirement. A case in which although technical procedures or functions are stated in the claims, the detailed description of the invention does not state how such technical procedures or functions are executed or implemented by hardware or software, and yet in which the claimed invention can't be carried out because a person schooled in the art can't understand the invention even based on the common general knowledge at the time of filing. It would be a violation of enablement requirement in Japan. About support requirement. If the running data or algorithm is mere abstractly specified in the claim and not specified running data in the detailed description of the specification, and a person skilled in the art can't understand what the invention is even based on the common general knowledge at the time of filing, that would be a violation of support requirement in Japan.
네, 답변 감사드립니다.
Thank you for your response. Now we will listen to Judge Lee.
최근 들어 전 세계적으로 AI 관련 프로그램 발명이 급격히 발전하면서
Recently, as the number of AI-related program inventions is growing rapidly across the world, the number of relevant applications has also increased. And there is heightened awareness about the need for protection of such inventions. But as you can see from the slide, most of the program inventions are written in a means plus function form or a step plus function. And many times the claims are broader than what has been actually invented. Also, many patent specifications do not set out the learning data or algorithm in detail, making it hard to specify the scope of protection for the invention in many applications. Only a few program inventions specify their source codes. Rather, they just only disclose a simple flowchart or a representative user interface, UI, or one or two user experience-related drawings. It is unclear how these programs can actually be practiced. In the past, most program inventions were written in the means plus function claims and consisted only of abstract ideas, and such applications were often rejected and invalidated in Korea. But there seems to be no precedent yet as to AI program inventions. In this case, the learning data and algorithm are not specified, and if specific means or process to create learning completion model is not included, then FOSITA will not easily be able to practice based on specifications only, so this would be a violation of the specification requirements. Such AI program inventions are different with other inventions in that language and diagrams are insufficient to clearly deliver how it works. So, in order to suit such nature of AI program inventions, the determination criteria and evaluation standards should be amended. Thank you.
네, 답변 감사드립니다.
Thank you. Now, Judge Mead, please give your answer. Thank you.
Thank you. The relevant statutory provision is Article 83 of the European Patent Convention, which is transposed into UK law in our Patents Act, and it requires that the skilled person is able to implement the invention from the description and using their common general knowledge across the whole scope of the claim without undue effort and without exercising any invention. And that requirement is general and applies to inventions of all kinds, not just AI or computer programs. The specification is required to set out the way to implement the invention in ordinary language, and it is not preferred to include source code. The requirements of the EPC examination guidelines express a preference for ordinary language, which may include flowcharts, and it's permitted to include source code, but it's not required, and it's not encouraged, and it's not permitted as the only means of enabling performance of the invention. These requirements of enablement across the scope of the claim are very fact sensitive, and there's no absolute requirement. I don't believe there's any decision absolutely about the level of specificity with which an algorithm must be expressed. But in the particular situation explained in these questions, where there is simply a disclosure of learning data and an algorithm, then it's easy to imagine that the requirement of Article 83 would not be met because the skilled person would need to use undue effort or invention to implement the claims. Thank you.
예, 영국 미드 판사님 답변 감사드립니다.
Judge Mead, thank you so much for your answer. So that it was the last response for 3-1 and 2. So now let's look at the video that Raymond Chen, a judge from the U.S. court, sent us. So we will only show a part of it, but you can access the full video through a link that will be provided later. Thank you.
Thanks. So, Mark, I think you wanted us to move on to patent eligibility questions.
Yes.
Here in the United States. And so I'll just go ahead and first take the lead on this question. And when it comes to patent eligibility for AI inventions here in the United States, I think the first fundamental question that has to be addressed, and the most pressing question, is really what is the current state of our law on the eligibility of computer implemented inventions. You could also call them computer software inventions. So to understand what will happen to the patentability of AI inventions, we need to know what is the law for computer software. And unfortunately, that's not an easy, straightforward answer at the moment in light of a few very important consequential Supreme Court decisions in the past decade on this issue. The Supreme Court has really changed the legal framework for how we in America must think about patent eligibility across all technologies. But one of the very most impacted fields is certainly computer software. Now, Section 101 of the US Patent Act governs the subject matter eligibility requirements for all patents. And under Section 101, whoever invents any new process, machine, manufacture, or composition of matter can obtain a patent. But the courts at the same time have long interpreted this provision as excluding so-called abstract ideas, laws of nature, and natural phenomena from being patent eligible. And software patents invalidated under Section 101 are typically deemed ineligible as being directed to mere abstract ideas. And understanding what the Supreme Court means by its abstract idea exception has proven to be a very difficult exercise for lower courts, including the Federal Circuit, as well as the USPTO, to apply to individual cases. And although what constitutes an abstract idea is not straightforward, the Supreme Court has stated in cases like Bilski and Alice that fundamental economic practices long prevalent have been deemed to be an abstract idea. In addition, the mental steps doctrine, which states that activity that can be performed through an ordinary mental process in the human mind or using a pen and paper are also alone without anything more in the claim is ineligible for patent. And furthermore, claims that are drafted in a result-oriented manner that lack implementation details for achieving a desired result are also regarded as directed at being mere the abstract idea of the desired goal or result itself. And let me see if I can give you an example of that. The very first example in a United States court decision is the Wyeth versus Stone case from 1840, where the inventor there had invented a technique for cutting a very large block of ice into equal smaller sizes. And in the 1800s, ice was very important. It was the only way to keep things cold. Refrigeration had not been invented. And so this particular inventor had invented a specific technique to cut ice in equal sizes. And he had one good claim, which claimed a method of cutting ice based on what he disclosed in his patent. But then he had a second claim, and the second claim said a method of cutting ice by any means, regardless of means. And that second claim, that very broad claim, was struck down by the court in that case as being so broad as to cover just the abstract principle of cutting ice. And because it failed to recite in the claim any means of cutting the ice, it was deemed essentially to be an abstract idea. And I think that 1840 decision is really the origin of the abstract idea exception. And so the principle behind the abstract idea exception is to prevent inventors from drafting claims at such a broad, generic level that the claim it preempts an entire field of inquiry because it claims the result itself. In this particular instance, in Wyeth v. Stone, it's the result of cutting ice into equal sizes. So getting back to computer software inventions and their eligibility, this has been an issue in the United States for at least 60 years. In the 1960s and 70s, the USPTO regularly refused to grant patents on computer software inventions, believing that they were just directed to abstract ideas occurring inside a hardware machine. And then in the 1990s, it appeared that the Federal Circuit had settled the issue by concluding that a programmed computer that produced a new useful result should be just simply understood as a special purpose machine that qualifies under Section 101. But now in the past decade, the Supreme Court has overruled that generous view of the law and is now demanding a much more rigorous inquiry, while at the same time not providing much guidance to us lower courts on how to apply that more rigorous inquiry. So in response, the Federal Circuit has done its best to piece together a new framework to and asks that we look at the patent claim as it's drafted to see if it really provides any kind of specific implementation for accomplishing a technological process. So some commentators have likened the current state of patent eligibility law to Europe's technical effect requirement for patents. So when we at the Federal Circuit look at examples of computer implemented invention patents, that there are times where they actually disclose in the patent specification a patent eligible computer software based technical improvement to some kind of computer technology. But the patent claims are unfortunately drafted at just simply too high a level of generality, such that the claims don't specify adequate implementation details, thereby leading to a conclusion that the claims are just simply too abstract. And because artificial intelligence inventions are at their heart computer implemented inventions, AI will likely face similar challenges in claim drafting to ensure that they're not claimed in a generic, vague way that fails to specify the particular means of how the artificial intelligence is actually accomplishing its tasks and what the artificial intelligence actually is, as opposed to merely what it's accomplishing. And that same challenge will likely be true for any invention that the artificial intelligence itself produces. There will be a challenge in trying to characterize what that resulting invention is, as well as what are the specifics that that resulting invention performs, what steps that it undertakes. So I heard Professor Lumley talked about an example of a self-driving car relying on artificial intelligence. And so you can imagine a claim that's drafted to a self-driving car in which, and the claim says, wherein artificial intelligence self-learns on how to safely drive a car while navigating through traffic, period. And if the claim is drafted at that level of generality, then there's a very real risk that a claim like that could be struck down as being just to the abstract idea of using artificial intelligence, whatever form of artificial intelligence that may be, that will control a car to be driven safely through traffic without really providing the real implementation details. So that's the challenge we're at. that we face here in the United States with the abstract idea exception. It comes down to really understanding at what level of specificity must a claim be drafted at in order to avoid this abstract idea invalidity problem. So I'll leave it at that.
And maybe I'll jump in at that point.
Yeah.
I think it's I think everything Judge Chen has said is correct, both about the sort of contours of the law and also the challenges and the difficulty of applying a pretty vague standard here. I do want to note a couple of reasons to think that this may be particularly challenging for AI. The example that Judge Chen gave is a good one. There is a strong incentive, I think, all things being equal, for patent lawyers to try to write their claims very broadly, particularly in a rapidly developing field like AI, because they don't know exactly how the algorithms will work in the future, and they want to have effective protection. That instinct runs directly up against the abstract ideas limitation, though, right? And I think that's particularly true with AI, because it's not just that I don't know how other people might develop technology in the future. I don't even know for sure how my own AI will develop technology in the future, right? One of the great benefits and interesting things about machine learning algorithms is they may well develop and move in directions that their sort of human creators don't predict. You create the initial conditions of the algorithm, you get the training data set, but it might be that the right way to navigate safely through traffic is something the AI comes up with that nobody really had in mind. Now, I think that presents some problems for trying to protect the AI itself. You can solve the problem of abstract ideas as a patent claim drafter by writing a very narrow and specific claim, identifying the specific way you solve the problem in the specific algorithm in a normal software case. It's much harder to do that if you don't yourself know how the algorithm has solved the problem. And I think that is compounded by the fact that the algorithms themselves are going to change and refine how they solve problems as they learn. And so one of the real challenges for patenting AI is not the question of, is AI ever patentable? I think if it meets the doctrinal limits that Judge Chen suggested, you can get a patent on artificial intelligence. But if you want an effective patent on artificial intelligence, you've got to confront the problem that I can't just claim the result. I can't just claim navigating safely through traffic or translating words. And I may not know enough to describe or claim at a level of detail precisely how it is the AI is going to solve that problem. Even if I do know how my AI works right now, from a patent enforcement perspective, what I really need to know is how will things work 5 or 10 years from now. It takes several years to get a patent through the US Patent and Trademark Office. Then you go into litigation, which can take several more years. And so I think one of the things that is a real problem for using patents to effectively protect AI is that the nature of the AI is not transparent, may change very quickly, so that even if I find that right level of abstraction, I may draft a patent that covers very well what my AI does today, but won't necessarily cover very well what my AI or anyone else's AI does 6 months from now. And I think for that reason, we may see that trade secret protection is used more and more than patents, at least among competitors. That doesn't mean we won't get patents and then we won't see patent lawsuits. And we will confront all of these Section 101 issues. But I think one of the more effective ways of preventing people from sort of copying your AI system is going to be to try to use trade secret law, because trade secret law gets automatic protection and it doesn't take sort of years to get through the patent office, and it makes a virtue of the thing which patent law makes a problem, which is that it's not obvious how my AI works. It's not transparent to anyone. That's a bad thing from patent law's perspective. Our doctrines in Section 112 require you to teach people how the AI is working. But it's a good thing from trade secret law's perspective. If I can keep it secret, then I can get effective protection. The big limitation for trade secret law is that it applies only to people who take the idea from me. So we've seen already sort of one high-profile AI trade secret case between self-driving car companies when Google's Waymo division sued Uber, saying that one of their chief scientists had left and taken documents to Uber, and they ended up preventing him from working and kind of shutting down the line of work he was engaged in. So that may be an effective way of getting intellectual property protection in the subset of cases where someone takes the idea from you. It won't give you protection against people who independently develop their own AIs.
네, 미국 패널 분들 첸 판사님과 렘니 교수님.
Yes, Judge Chen and Professor
경청해 주셔서 감사합니다.
Lemley, thank you. As we have seen in the video, the claim and specification requirements, when it comes to that issue, the abstractness or vagueness of the claims are becoming a problem, and abstractness is being addressed by narrowing down the scope of the claims, but through self-learning, how AI solve the problems may change within a matter of 5 years or 10 years. It is very difficult to regulate that matter currently and limit the claim scope. So we have to address the question of whether that will be practicable a decade after today. So yes, that was addressed in his talk, and thank you for your response. And now we will move on to the third topic. We are a little late on time, so we will try to move as swiftly as possible. So the third topic is issues on patent laws for AI-generated invention. In most countries, following the principle of inventorship, the inventor has the right to acquire a patent, but how is a joint inventor interpreted? And if AI joined the invention, then how will that be addressed? So common question number one goes as such. What is the criteria for recognition as an inventor in your country? And particularly, please introduce how the minimum requirements of contribution to become a joint inventor is interpreted. Please limit your answer to 1 minute. In the third and fourth session, Judge Nai Param from Australia is joining us. So we will start with Judge Param. Thank you.
Thank you, Judge Wu, for your kind invitation. In this area, the matter is governed by the Patents Act 1990. It does not define an inventor, but the case law which has developed around the word used in the Act has indicated that an inventor is a person who makes a material contribution to the invention. It follows that concepts like joint inventorship are also recognised. There will be joint inventorship where 2 or more persons have made a material contribution to the invention. The contribution does not have to be the same contribution. It can be separate, and it can occur at different stages of a process. Obviously enough, it also includes collaboration.
Thank you very much for that answer. As material contribution, this requirement was explained to us. Next, from China, Judge Humi. So please limit your answer to 1 minute.
According to the implementing regulations of the patent law of the PRC, Article 13, inventor, as mentioned in the patent law, means that any person who has made creative contributions to the substantive features of the invention creation. Any person who, in the process of accomplishing the invention creation is responsible only for organized work or who offer facilities for the use of the material resource or who take part in other auxiliary functions should not be inventor. The substantive features are the key technique features that reflects the difference between the invention and the prior art. The creative contribution refers to innovative intellectual labor. In China, the person who makes innovative labor is the inventor.
Thank you very much for that answer. Next, Judge Kwang Nam Kim from Korea, please. Thank you very much. According to the Payton Act of Korea, with regards to the definition of an inventor, there is no separate provision. And so based on case law, those who have contributed to the creation of technical idea is required to be defined as an inventor. And so not only the provision of simplified task or idea, it is not enough. The Korean Supreme Court rules that if new ideas are specified through test and thus materially contributes to the creative act, this is seen as an inventorship. Thank you very much for the answer. And now going to UK, Judge Mead.
Thank you. The definition of inventor for the UK is to be found in Section 7 of the Patents Act 1977, and it says that the inventor is the actual deviser of the invention. So it has to be somebody who has done real and specific work. There's very little guidance in our law about exactly how much work is necessary for a person as part of a team to make as a contribution as an inventor. One reason why this isn't explored very deeply is because it isn't a ground of revocation of a patent in the UK on its own that the invention. So this is not always a very important practical question, but the simple answer is the deviser of the invention under Section 7.
예, 답변 감사드립니다. 그러면 공통질문 2와 3으로 넘어가도록 하겠습니다.
So now we'll move on to common question 2 and 3. Now we will look at the specific case on the pharmaceutical invention and talk about the issue of joint inventor. Please refer to the table for the specifics of the case.
위 사안에서 A와 B가
In this case, if A and B are natural persons, who does your country deem to be the inventor of this invention? And moving on, if B was an AI, in this case, then can A be deemed as an inventor? Please limit your answer to 2 minutes. First, we will hear from Judge Parham from Australia. Thank you.
So this question would be seen through the prism of the material contribution test I referred to before. And that has been fleshed out by decisions of the full federal court in Paulwood and in the Gray appeal, making the assumption that the assumption in the question that A provided B with abstract tasks and ideas is one which would satisfy the material contribution test, which seems sensible. Then the conclusion would be that both A and B are inventors for those purposes. Then turning to the second question, where B is switched from being a person to being an AI, the situation in Australia is perhaps a little out of step with other jurisdictions. It appears at the moment that the answer to this question would certainly be that A was an inventor, or at least arguably be that A was an inventor, but there is a complexity in that there is a decision of the Federal Court of Australia in Thaler, Justice Beech's decision, that would hold that B was also the inventor. That case didn't actually have to decide whether A was the inventor, but it seems a likely inference from it that it was. That's a controversial decision. It's under appeal at the moment. I may have to sit on the appeal, so I will be circumspect in my remarks. But those are the answers I would give.
네, 답변 감사드립니다.
Thank you.
이어서 중국의
Now, Judge Humi from China, please go ahead.
For common question 2, in China, B would be regarded as an inventor, as a B made the creative contribution. His work is concrete. However, if A can prove the concreteness of the ideas, not so abstract, it must be concrete. A also can be regarded as co-inventor. For common questions 3, according to the patent law PRC, the inventor refers to natural person, namely human beings, does not include AI. Currently, AI is regarded as an executor of algorithm program, which is a tool to help human beings get intellectual achievement. In the above-mentioned case, although AI generates the final output, A, as a human being who provides the idea, may be the inventor. Because AI's behavior is not spontaneous, its role is completed and the guidelines of AI is regarded as a tool in this case. Thank you.
네, 후미 판사님 답변 감사드립니다.
Thank you, Judge Humi, for your answer. Now we will hear the answer from Judge Shoji.
Issues on patent laws for AI-generated invention. Common question 2. In this case, person B is deemed to be the inventor. With respect to the similar case, IP High Court ruled that a person who gave general advice or instructions is not an inventor. And then Tokyo District Court ruled that any person who merely gave a research subject or general advice or guidance to the subordinate researchers without presenting any specific conception can't be an inventor. With respect to joint inventor, the IP High Court on the above ruled as follows. In order for multiple persons to become joint inventors, such persons must make a substantial contribution in the process of conceiving of an idea to solve the problem and giving a concrete form to the idea under an integral and continuous cooperative relationship. From the viewpoint of those decisions, since person A, who only provided B with abstract tasks and ideas, does not make a substantial contribution in the process of conceiving an idea to solve the problem and giving a concrete form to the idea, A is not the joint inventor. Common question 3. My answer is no. The reason is as follows. In the case of AI conducted what B did in the above case, since only AI was involved in the creative activity of structuring the technical ideas concretely and objectively, enough to enable a person ordinarily skilled in the art to work it. There is no human, that is a natural person, who was involved in the creative activity of structuring the technical ideas concretely and objectively. In Japan, since the Patent Act deems only human as an inventor, AI never becomes an inventor. So, in the above case, there is not any inventor. I think that it needs to be statutory amendment of the Patent Act that a person or an entity who was involved in the creative activity of AI-generated invention can be deemed as an inventor.
네, 쇼지 판사님 답변 감사드립니다.
Judge Shoji, thank you for your answer. Now we will listen to Judge Kim.
Thank you very much. First, the second question, natural person A and B, whether they are considered as inventors. So in this case, A is the project manager or the project leader, and he's in a relationship with B. He gives instructions to researcher B. Of course, until the invention comes out, he will give numerous instructions to B. In Korea, we say he's hounding or grilling B. So if we grill him, what happens? This is what happens. So researcher B has burned up black. Do you think an invention came out because of this process? No, I don't think so. So let us ground him or grill him again. Is grilled white. Now, at this point, inventions come out, right? So B, who has been grilled white, is considered as an inventor under the current laws. But what about A, who has grilled B to the point of, being burned up? Well, it will depend on the specific facts. And the Supreme Court of Korea has reached different conclusions regarding two similar cases. So in order for A to be considered as an inventor, it does not matter how much he grilled B, it would depend on how he had grilled B. If A had given instructions that had contributed to the technical creation, he would be considered as an inventor. But if he had only given abstract tasks and idea, then A would not be considered an inventor. Next, question 3. If B was artificial intelligence, can A be considered an inventor? Should we grill or hound an artificial intelligence, AI? Yes. No matter how much he is grilled, the AI is laughing his head off. So as you can see, if we follow strictly the current laws and regulations, then A cannot be considered inventor. However, the requirement to become an inventor, the contribution to the creation of a technical idea, if this is flexibly interpreted, then A can be considered as an inventor. In short, up until now, in the area of chemical inventions, the importance of lab tests was very much emphasized. But because of the advances in AI technology, the importance of these repeated tests have become weakened. And so if the act of providing abstract tasks is becoming more important, it can be considered as an inventor. Next, we'll ask the Dr. or Judge Mead from UK for his answer.
My answer to common question 2 is that there is no reason in principle why A can't be an inventor, because an invention can be made in the making of quite a conceptual decision, and it could easily be an invention to decide to attack a particular biological target or to use a new kind of assay in assessing this sort of task. And therefore, the inventive thought could take place either at a conceptual level with A or at the level of actually doing the work such as is conducted by B in this problem. So I don't believe there's a definite answer to this, and it's extremely fact dependent. So I don't think there's a definite answer to this. There's no decision yet in our case law about the situation where A sets an AI to work on the task. We do have a decision about whether the AI on its own can be an inventor, and that's been decided in the context of our Court of Appeals decision in the Davos case, which we're coming to shortly. But my answer to common questions 2 and 3 is that merely because A's input is conceptual doesn't mean that he can't be an inventor, and it depends on the nature of the invention and the split of work between A and B.
네, 미드 판사님 답변.
Judge Mead, thank you for your answer.
아까 보셨던 미국의 첸 판사님과 랩니 교수님의 비디오 영상을 3주제와 4주제.
Now we will look at the video of Judge Chen and Professor Lemley on this topic. It will last for about 6 minutes.
So I know we've got just a few minutes left, but I do think we want to talk about the final issue, which is protection for the outputs of AI. And this is an issue that has come up in courts across the world just in the last few months. Is an AI an inventor? Who, and if not, sort of who is inventing the results of this algorithm? Judge Chen, you want to introduce the Thayer case and this problem?
Yeah, sure. So I think everybody here knows that there is a particular person named Dr. Stephen Thayer who has filed patent applications across the world on behalf of his artificial intelligence that he developed. And he refers to this AI he developed as Dabus. And he claims that Dabus, the AI, has itself invented two inventions, that Dr. Thayer has filed patent applications for on behalf of Dabus. And some of those applications include filings at the USPTO, and the USPTO refused to consider these patent applications because Dr. Thayer identified Dabus as the inventor, not Dr. Thayer himself. And in the USPTO's view, because an application must identify an inventor, a machine or a piece of artificial intelligence can't be understood as an inventor, as that term is used in the Patent Act. So after the agency refused to consider these patent applications, Dr. Thayer appealed that adverse decision to district court, and we have a district court decision here in the United States that affirmed the USPTO's decision in refusing to consider these applications for failing to identify a true inventor. And as I understand the district court decision, it looked to the words of the United States Patent Act, which refers to inventors as individuals. And so the real question comes down to whether a machine can be regarded as an individual. And the district court looked to a Supreme Court case, which had to interpret the word individual in a different statute, in a different context. And the Supreme Court in that case concluded that individual meant a natural person. And so the district court here in the Dabus case relied on that interpretation and found that it also ought to apply here in the Patent Act's usage of the word individual. And so therefore, because the Patent Act requires a natural person to be identified as an inventor, that necessarily does not encompass machines like Dabus. Right now, we expect a Federal Circuit appeal to be coming soon, but as far as I know, it hasn't happened yet.
And for obvious reasons, we won't ask Judge Chen to opine on what the Federal Circuit would do in a pending case. But I am under no such limitation. I think the court's analysis of the statute is right. And one of the things it notes is that not just that it sort of says an individual, which has been interpreted to be a natural person, but that other provisions of the Patent Act require that that individual inventor, quote, believe himself or herself to be the original inventor. And the district judge notes that there's no reason to think that the AI would have a sort of state of mind as to whether it believes itself to be an inventor. And that's further indication that the statute has in mind individuals as human persons, not including AIs. I will note that this is an issue that is coming up across the world. The UK courts have aligned with the United States in this respect, and you may hear from other judges on the panel about this. By contrast, in Australia and South Africa, courts and or the Patent Office have concluded that AIs can be an inventor. I think that under the current U.S. statute, its inventorship is going to be limited to to an individual, to a person. It will not include an AI. But I also think that's going to be harder to sustain over time as it becomes further and further removed. The invention is less and less connected to anything any individual person did. And if we get to the point where, yes, I built an algorithm and I asked the algorithm to solve a problem, but I didn't myself sort of direct how that problem was solved, and I didn't even necessarily understand the way in which it solved that problem, it becomes harder to call me an inventor. And it may be that Congress at that point needs to step in and decide what to do. And it's an interesting problem because I think under current law, you could find yourself in a situation in which the AI is not an inventor because an inventor has to be a person. But no individual person is an inventor either because they're not the ones who actually did the hard work. Maybe that's okay. AIs don't necessarily need the incentives of the patent system in a way that sort of human inventors do. But my guess is there's going to be strong pressure at the legislative level to try to determine that these inventions are patentable and to assign them to someone, whether it's the corporation who owns the AI or some individual who's connected with it. But that is, I think, for the future, it's an issue we will have to confront. Judge Chen, any concluding thoughts?
No, I just wanted to check, are we out of time now?
Yeah.
Okay, well, then I'll just leave it there and say thank you very much to the conference organizers. I really appreciate the chance to participate.
Thank you, and we hope the conference goes well.
네, 답변 감사드리고 잘 들었습니다.
Thank you so much for your answers.
답변에서 소개되었던
So it was mentioned in the response, the Dabus case. Let's delve into this case.
관련된 사실관계는 이 슬라이드에
So the facts related to the case are here on the slide. Dabus is an AI that was developed by Dr. Taylor, and
문제 해결을 지시하지 않았다라고
he did not give specific guidances and filed application for the AI-generated invention. So if AI generated an invention by itself without any human intervention, then who shall be the inventor? And who shall be the patentee? And under the existing patent law, are there any concerns about a legal gap that might arise in the protection? Given the time constraints, please limit your answer to 1 minute. Thank you. First, we will hear from Judge Parham from Australia.
Well, on the basis of Justice Beech's decision in Thaler, the answer would appear to be that the inventor is the Davis system. As I say, that's under appeal. The answer to who the patentee is not strictly known. Justice Beech thought that the patentee could be the person who owned the system or wrote the software which operated the AI. Under our statute, that a person can be a patentee if they can take an assignment of the patent from the inventor. Justice Beech thought that that definition might be able to be satisfied. There may be some problems with that. Some people may object that an AI cannot own property. In any event, at least while the decision stands, the answers are as I have given.
네, 예. 나이페란 판사님,
Yes, Judge Parham. You shared the case on Dabus recently that came out from Australia. Thank you. And Judge Humi, please go ahead.
The question is how to apply in the future if the year of super AI is coming. The criteria of the qualification of inventor or patentee may be redefined, but in China, it's the authority of legislature, and the judges can't do much about it now. Thank you.
Thank you. Now, Judge Shoji will give his answer in his video.
Question 4. As I mentioned above, only human can be an inventor. The reason is as follows. Article 36, paragraph 1 of Japan Patent Act provides a person requesting the grant of the patent shall submit an application to the Commissioner of the Patent Office stating the following: the name and domicile or residence of the inventor. From the viewpoint of the above provision, Since AI has not the name and domicile or residence, AI does not become an inventor. In addition, in Japan, the inventor has the right to obtain a patent at the same time as the invention is completed, and the inventor has a right to obtain a patent can transfer the right before filing the application. It is planned to be a natural person as a person who has right and ability and can be an applicant. From the viewpoint of the above interpretation, under the current law, an AI-generated invention without any human intervention would not be protected by the Patent Act.
네, 답변 감사드립니다.
Thank you for your answer. And Judge Kim, please go ahead.
먼저 설문에서는 인간의 개입이 전혀 없습니다.
First, the basic premise of the scenario is that there's no human intervention at all. So
특허법상 인공지능은
it cannot be an inventor. And under the current Patent Act, AI cannot be an inventor. So there may be a void as to who is the patentee as well under the current Patent Act, which adopts the doctrine of inventorship. And even if the Patent Act is amended to grant inventorship to AI, the patent right shall be vested in a natural person. In this regard, the succession of the rights can also be an issue because AI cannot transfer its rights. So it's my personal opinion that we should legislate in order to grant inventorship to AI, and adding automatic assignment through legislation could temporarily solve the issue. Thank you.
네, 답변 감사합니다.
Thank you for your answer. Now, Judge Mead, please go ahead.
Thank you. We have had a clear decision in this country from the UK Court of Appeal that AI cannot be an inventor. And the main reason for that is not a conceptual one, but a practical one to do with the fact that our patent legislation gives substantive legal rights to inventors, and legal rights cannot be held other than by an entity which has existence as a legal individual, and AI does not qualify for those purposes. And so it's clear for the moment, unless there's an appeal to the Supreme Court, which I think is unlikely, or a legislative change, that AI cannot be an inventor. And unfortunately, because of the way that Mr. Thaler phrased his application and the court issue, we don't yet have a decision about whether the person who sets the AI to work on a particular task can be an inventor. That's for the future. Thank you.
네, 답변 감사드립니다. 예. 보셨듯이 인공지능이 발명자가 될 수 있는지에 대해서
So, thank you for all of your answers. We heard from UK, Australia, Japan, and Korea, and under the current law, it is impossible. But Australia and South Africa, AI can be deemed as an inventor, but such decisions are under appeal. So, anyone who is interested can take a look at how the case is proceeding and how laws might be amended with regards to this issue. And now we will move on to the fourth topic, which is patent infringement by AI. I will skip the introductory comments and jump right into the questions. So if many parties conducted a patent infringement, then who will be held liable for patent infringement? Please introduce your country's rules on that. And with regards to process, method, invention, if the server overseas was used to make infringement domestically, then how will that be addressed? And in such case, if part of the act was conducted by using AI, then do the existing discussions apply without change? Please explain and limit your answer to 2 minutes. First, Judge Perham, please go ahead.
Yes, in relation to common question 1, there's no particular difficulty with the concept of there being a joint infringement under Australian law, and no complexity attends that. In relation to questions 2 and 3, these questions do not make terribly much sense under our Patents Act. Our Act turns on the exploitation of the patent, which can happen in a variety of ways. It can happen by importation of a product, it can happen by the manufacture of a product, it can happen by the performance of a process, or it can also happen by authorization. But the critical feature of each of those matters is that these are activities which are conducted by legal persons. So there are difficulties from an Australian perspective in integrating the idea of AI being involved in an infringement. So I think my answers to questions 2 and 3 would be that the question can't really be answered under Australian law.
Thank you very much for those answers. So under the Australian law, the common question 2 and 3 cannot be really definitively answered. Next, we would like to pass the floor to Judge Humi from China.
For common question 1, according to the Civil Code of PRC, Article 1168, where 2 or more persons jointly commit a tort causing harm to another person, they should be liable and severally. In the case of multi-party patent infringement, if more than one person is responsible for the damages, they should be jointly and severally liable. For common question 2, if the ultimate infringement act takes place at home, even if several overseas is used in some steps, it's still be considered as domestic practice of the patent and recognized as a patent infringement according to the domestic law. For common question 3, according to the patent law of the PRC, the juridical status of the AI is not recognized yet. Therefore, even if AI is applied in some steps of patent infringement, it will not be considered as a subject liable for infringement in China. Thank you.
Thank you very much for those answers. Next, Judge Kim from Korea. The floor is yours. Thank you very much. So there are many challenges involved in patent cases. One of the cases that I really would like to avoid would be infringement by multiple parties, and one that involves territoriality and a network invention infringement. Well, with regards to multi-party infringement, there is no established court decision. If I introduce one court decision by a lower court, if one of the multiple parties was controlling or managing other parties, then unilateral liability for infringement can be recognized, and if they colluded together and have practiced together the components of the patented invention, then all the multiple parties can be recognized as having infringed the patent. And also, a network that is based on overseas servers, infringements involving this kind of method, there is no Supreme Court rulings. However, in a lower court, with regards to an act that used an overseas server to engage in infringement about method invention, the implementation method and purpose were considered of the invention in order to recognize the practice domestically of this patent. So I think for infringement by AI, all of these principles can be applied. Thank you very much. Thank you for the answer. Next, from UK, Judge Mead, the floor is yours.
Thank you. There are 2 ways under UK law in which multiple people can be liable for the same commercial exploitation of an invention. One is our general law concerning joint tortfeasors who cooperate together in a single course of action. There's nothing specific to patent law about that. It applies to all torts under UK law. And the second is that under our specific law of infringement under Section 60 of the Patent Act, multiple different kinds of action in relation to an invention can be an infringement as performed by one particular person. So the person who imports an infringing product commits an infringement, and the person who later advertises or sells those products also commits an infringement. So there's no particular difficulty about that. In relation to common question 2, we've had a number of cases where the physical infrastructure to implement an invention has been spread in different jurisdictions, typically as in this question where the server in question is not in the UK. And the legal approach of the UK courts is to ask itself where in substance the method is being put into effect, and where the method provides a user experience. That's typically where the user is situated, which can well be in the United Kingdom, even if the server executing the code is abroad, and there have been several cases of that. In relation to common question 3, I don't think there's any difficulty in applying these principles where AI is involved, and what the courts will look to is the real person or corporation, the entity with legal personality who causes the AI to do whatever it does. But I don't believe there's any particular problem with that.
예, 답변 감사드리겠습니다.
Thank you very much for those answers.
나머지 슬라이드는 일본과 미국에서 서면 답변 보내주신 것을 간단히 정리를 했습니다.
These slides actually show answers from Japan and the US.
특허 침해와 관련된 것입니다.
Now let's move on to the last question.
주체가 누가 될 것인지에 관한 논의를
It is about who will be liable for the infringement.
발전 유형에 따라서 특허 침해 책임의
So, based on the development of AI, who should be held liable? Is it the operator or the developer or the manufacturer? Or AI itself, who shall be held liable for the infringement? And in addition, can AI itself be held liable for patent infringement in your countries? Please limit your answers to 1 minute. First, Judge Parham, please go ahead.
Well, as I said before, because the Act requires an exploitation, there'll be no question of the AI being held liable. The person who will be held liable is the person who makes the product or imports the product or uses the method, and that won't be AI. As to the second question, if one were to grant to AI legal personality, it would be a different ball game. In circumstances where we currently hold that an inventor could be an AI, then it would be reasonably plain. But if the AI had legal personality, it could be held liable. But that seems a rather artificial series of assumptions to make. Thank you.
예, 답변 감사드립니다.
Thank you for your answer.
중국의 후미
Now, Judge Humi from China, please go ahead.
In the primary stage, weak AI is an auxiliary tool of human being, and the user of AI should bear the tort liability. In the man-machine cooperation stage, AI and human beings may participate in the infringement jointly. Human beings can act as an agent or control manager of AI, and the manager of AI shall bear the tort liability. In the independent output stage, strong AI can be cyborg and bear the tort liability. If AI's legal person status is conferred, it is compulsory that AI has independent account so that AI can bear the tort liability independently. Thank you.
네, 답변 감사드리겠습니다.
Thank you, Judge Homi. And now, Judge Shomi's answer will be watched.
Chapter 4, Patent Infringement by AI. Common question 4. Same as a problem, whether or not AI become an inventor, even if patent infringement by AI is recognized, a person or an entity should hold liability for patent infringement, but AI itself. And in Japan, there are various opinions about who should hold liability among a person or an entity. One opinion to the effect that a person or an entity who transfers the products as its business that produced by AI-generated invention should be liable for patent infringement. One opinion to the effect that if a person or an entity offering an AI system as its business plays a main role to practice AI-generated invention, that person or that entity should be liable for patent infringement. One opinion to the effect that an entity who possesses AI system should be liable for patent infringement. That concludes my answers. Thank you for your attention.
네, 답변 감사합니다.
Thank you for your answer. And Judge Kim, let's listen to your answer.
국회에서는 다양한 견해들이 논의되고 있습니다. 현재 주의적인 견해.
It seems that there are various viewpoints in the academia. Currently, the predominant view is that if a natural person earns profits by using AI, that person shall be held accountable for the unlawful acts caused by AI operation. So the AI developer, user, data provider, who will be held liable among those entities is an answer that has no golden rule. The issue should be resolved by comprehensively judging who actually controls and manages the AI and who gains profits accrued from the AI. And whether AI can be held as an infringer, the majority view is that it cannot. That is the mainstream opinion. Even if AI is recognized as the main entity liable for infringement, there is little merit to hold so for now because AI has no executable property like corporations or other legal persons. Thank you. Thank you. Last but not least, Judge Mead from the UK.
Thank you very much. The answer to the first part of the question is that it would primarily be the operator of the AI, but it could in principle be anybody else sufficiently closely concerned with the operation of the AI to be a joint tortfeasor under our general law. And the answer to the second part of the question is that the AI itself could not be held liable for patent infringement because it has no legal personality and therefore isn't a recognized category of entity that could be a defendant to an action. So the answer to that is no, the AI could not be liable on the current state of our law.
예, 미드 판사님 답변 감사드립니다.
Thank you, Judge Mead, for your answer. And due to time constraints, please refer to the reference book for question 5. So that covers all of the questions we prepared for this session, and we are 10 minutes over time. But the survey that I mentioned in the beginning is now beginning, and actually, we have the answers, and this shows the statistics. So this shows the results of how participants here think about the question. The first question was, in the AI era, do you think AI can be considered as Fusita? And
그렇게 볼 수 있다고 생각하시는 분은 29%였고요.
29% agreed, while 71% of our participants said that it would be too hasty to consider AI as Fusita at the current time. And the second question that was asked in the survey
마지막 주제에서 다부스 사건 등에서 논의되었듯이
was,
인공지능이
as the
발명자
Davos
지위를
case addressed,
부여할 수 있느냐
there
없느냐가
are those who believe the Patent Act should be amended to grant inventorship to AI. As some are arguing that this should be solved through legislation.
발명자 지위를 부여하는 내용의 특허법 개정이 필요한지에
So,
대해서
should there be such an amendment or not? To this question, those who supported such an amendment accounted for 31% of the participants, while 69% of our participants did not agree with that idea at this moment. Thank you for your participation, and this brings us to the end of session 3. Even an AI would have had much difficulty answering the questions that were posed to our panelists, but all of them gave us excellent answers, and I would like to thank everyone who are joining us on site and virtually. Please give all the panelists a round of applause, and that will be the end of this session. Thank you.
정말 흥미로운 주제였던 것 같습니다.
It was a very interesting topic. I would like to thank our moderator and all of our panelists. We will take a short break, and at 4:30 p.m., the last session of today will begin. Thank you.
잠시 후 16시 30분부터 세션 4가 시작됩니다.
At 4:30, session 4 will begin.
휴식 시간이 너무 짧게 드리는 것 같습니다만
I'm sorry that the break is very short, but we have sessions that are planned ahead, so please
세션을 시작하겠습니다.
bear with me. Session 4 will begin shortly, so please come back to your seats.
네 번째 세션을 곧 시작하겠습니다. 밖에 계신 분들은 모두
Session
입장하셔서
4 will begin now, so please take your seats.
곧 4세션을 시작하겠습니다.
Session 4 will begin shortly. Please come back to the hall and take your seats, please.
지금부터 오늘의 마지막 세션인 네 번째 세션을 시작합니다.
Now we will proceed with the last session of the day. The last session dealt with various Patent Act-related issues on AI and programs. Now we will take a little twist and look at how programs can be protected under the copyright law. We will look at what differences there are in the various discussions and what special issues arise. This will be very interesting to watch during the session. I'd like to introduce the Korean moderator and panelists. Seol Bum-sik, the presiding judge of Seoul High Court of Korea, Tae Park, presiding judge of Seoul Central District Court of Korea, and Son Young-eun, judge of Patent Court of Korea. Please give them a round of applause.
So we now begin session 4. Good afternoon. I am Bum-sik Seol, presiding judge at the Seoul High Court of Korea. I'd like to thank everyone for taking time to participate in today's event. So in the modern society, whether consciously or unconsciously, people without using computer system cannot undertake social activities. So computer programs permeate all aspects of our everyday life, and so that shows that the industry-related computer programs is growing by the day, and also as a result, legal disputes over computer programs is increasing as well. So how to protect the computer programs legally is a subject of much discussion, but in this session, we assume the protection based on Copyright Act, and we will share the experiences of different countries and seek viable directions going forward. So with regards to resolving disputes over Copyright Act, pertinent issues first. computer programs that are subjected to protection under Copyright Act. Second, the judgment of substantial similarity. And the third topic is how to estimate the damages arising from infringement of copyright. And fourth, the fair use and exhaustion of rights. So we are going to discuss these four topics in this session. We have panelists from China, Dear Lingen, judge from Shanghai High People's Court of China, and Judge Richard Mead, judge in charge of intellectual property in the High Court of England and Wales. Judge Mead has been participating in the third session as well. He will continue on to participate in the fourth session. And so Professor Ansgar Oli, and Chair of Private Law, Intellectual Property and Unfair Competition at the Ludwig Maximilian University of Munich, and also Tae Park, Presiding Judge, Seoul Central District Court of Korea, William Patry, the American lawyer, and Young Son, Judge Payton Court of Korea, and Robert Schroeder, a judge from the United States District Court for the Eastern District of Texas. In the case of Judge Schroeder, given his personal circumstances, he would not be able to join us on a real-time basis, but he has sent us a pre-recorded video message, and so we will watch the video and pursue the discussion. So we'll jump into the first topic, the computer programs that are subject to copyright protection. So we have sent common questions to our panelists. The first question, so the concept of computer programs that can be subject to protection under Copyright Act. So the any cases in which this has been an issue? Can you please introduce those cases? The panelists will be allotted 2 minutes each for their comments. First, we would like to invite Professor Oli from Germany.
Yes, thank you very much. Good morning from Munich, or good afternoon, or even good evening to Seoul. So copyright law in Germany is based on EU law. Copyright law has been harmonized to a great extent in the European Union, and there are two directives which have done so in this area. First of all, the Computer Programs Directive, and then, for general copyright principles, the Directive on Copyright in the Information Society. German law was passed to implement those directives, and German law has to be interpreted in accordance with the directives, taking into account the case law of the European Court of Justice. Now, the Computer Programs Directive does not define what a computer program is, but the recitals to the directive say that computer programs are protected in any form, including the preparatory materials, but that, however, computer programs have to be distinguished from the underlying ideas and principles which are not protected. There is also an originality requirement dealt with in the directive. A computer program must be original in the sense that it's the author's own creation. Now, in case law, we sometimes find references to other definitions. For instance, in a case decided by the Berlin Court of Appeal, the court held that a computer program is a series of commands which is directed to a computer with the purpose to cause an effect. The European Court of Justice seems to be of the same view, at least it held in the BSA case, that graphical user interfaces as such do not qualify as computer programs, as they only allow users to apply the program. Thank you very much.
So, Professor Oli, thank you very much for those answers. Next, Judge Juringen from China. We invite you for your answer. Judge Juringen, we can't hear you. Can you turn on your microphone? If it is off, can you check whether your microphone is on? Yes, we can hear you now.
Thank you. Good afternoon, everybody. Article 2 of China's regulations on the protection of computer software stipulates that computer software refers to computer programs and related documents. Article 3, Part 1 provides that a computer program refers to a sequence of coded instructions that can be executed by an information processing device, such as a computer, in order to obtain a result, or a sequence of symbolic instruction, or a sequence of symbolic statements that can be automatically converted into a sequence of coded instructions. Since its establishment in December 2014, Shanghai IP Court has concluded 430 cases of copyright infringement against the computer software, and the legitimate interests of software copyright owners has been protected. Thank you.
Thank you very much for that answer. Next, we'll move on to our Korean speaker. So, Judge Park, the floor is yours. Thank you very much. Let me be very brief. For a detailed answer, please refer to the reference book. I also include cases related to this issue. So developing a computer program, you have to set the purpose of the development. In order to achieve that purpose, you need to have a prepared algorithm to support this purpose. But it does not end there. In the end, the source code and the object code, in the literary form, the program is expressed. And so the computer program is seen as a form of literary work. That is how it is discussed when it comes to protection of copyright law. So like a literary work, among the programs of the plaintiffs, if there is any creativeness, that is specified. And with that work and the defendant's program, comparison of the source code is made in order to determine the substantial similarity. And as an assumption or premise for this process, the plaintiff's program, it has whether it is eligible for protection under the Copyright Act is determined. In the case of Korea, as is indicated in the question, the computer program from early on in the Computer Program Protection Act and under the Copyright Act, we have a definition provision. And the definition provision, although there has been slight modification over the years, much of the core content continues to be maintained. So, in order to achieve a certain result, computer and other devices with information processing functions, directly or indirectly, the series of commands, is it expressed in that manner? Well, if you look at the actual cases, whether it is a simple data or it is expressed in a series of commands or instructions. So that was the key focus of the cases. And aside from that, within a large program, partially the plaintiffs, the parts that are claimed for protection by the plaintiff, can they be seen as an independent computer program has been an issue. Whether they can be seen as a computer program has been an issue. So for more detailed explanation, please refer to the reference book. Thank you very much. Thank you very much for that answer. Now we will invite Mr. Patry from USA. I believe it's late at night in the United States. Please introduce the situation in the United States.
Thank you. It's actually early in the morning. It's 2:43 in the morning. Thank you for having me. In the United States, copyright for computer programs has existed by statute since January 1st, 1978. Protection is a mix of two things. A statutory definition of computer programs, which is a set of statements or instructions to be used directly or indirectly in a computer in order to bring about a certain result. So that's how we define the subject matter that's protected. But in addition, computer programs are subject to the general principles of copyright law that apply to all subject matter. There is some tension, I think, in that because the definition of computer program requires a functional result, and that's exceptional in the case of copyright law, which doesn't extend to functional attributes. We also have, of course, the general principle that ideas, systems, methods of process aren't available. So these tensions are worked out by case law. We're, of course, a common law country, and we decide things by case law. So, to fully understand it, you would have to look at different cases and different facts, and that's the way things are in the United States. Thank you.
Thank you, Mr. Patry, for that answer. So, we'd like to pass the floor to Judge Mead of UK. Can you explain about the UK situation?
Yes, thank you very much. It's very clear that computer programs are protected as copyright works in the UK. They fall under the category of literary works, although it's not very important for the protection of copyright works exactly which category they fall into. Apart from that, I can be very brief because despite the UK's exit from the European Union, for the moment at least, we are very closely aligned to European law, and the result is that the overall position in the UK for the moment remains almost exactly the same as Professor Oli has already explained that it is in Germany, and we still have reference to the case law of the Court of Justice and to the principles of European law. So we are in almost exactly the same position as it applies in Germany for the moment. Thank you.
Thank you very much for that answer. So, we will ask supplemental questions to United States and China, which has slightly different legal systems. Recently, the programs are showing a trend of becoming multimedia products, and so aside from the code in which the orders or commands are contained, whether the design material for the multimedia are seen as part of the programs or are they treated as different creative works? First, we'd like to invite Mr. Patry from USA for his answer.
Oh, my turn?
Yes, it is your turn.
Oh, thank you so much. So, following up on Judge Mead's comment, the characterization of computer programs in the United States as a literary work isn't particularly important. What really matters is whether there's an original work of authorship or not. If there is, it's protected. And if there is a single author of all the elements of the computer program, that single author, of course, owns copyright. For registration purposes with our Copyright Office, we have procedures that would allow a single registration for all of the code elements, as well as any visual elements, game elements, and etc. So what matters for us is whether there's an original work of authorship and who owns it. If you own all the elements, then that's wonderful, and you can get a single registration and you're protected. Thank you so much.
답변 감사합니다.
Thank you very much for that answer. Judge Du from China.
Thank you. My opinion is it can be protected by China's copyright law as a computer software work. In this case, hard company has requested the protection of game software as computer software works for many games, such as Muse-Dash, Going to the Moon, and Us in its operation, arguing that the defendants in the case violated the copyright of his computer software by providing free download of his game on the website. The court upheld his claim. Thank you.
네, 답변 감사합니다.
Thank you very much for that answer.
이어서
And
기술과 연구에 대한 보충
next.
드리겠습니다. 최근 멀티미디어 기술이
Now we have questions for Germany and the UK. With recent advances in multimedia technology, there are cases in which music, image, and motion picture are the main parts, while the code to control them is additionally included. If such a work is deemed to be a musical work or a cinematographic work based on the nature of the content, not the program, in such cases, it would be difficult to distinguish it from a program that includes music, image, and motion picture. So please explain about how your country distinguishes programs from such works. So Professor Oli first.
Thank you. In the case of complex works, protection of the computer program and of other types of work incorporated in this complex work can be protected side by side cumulatively. Let me give you an example of a recent German Supreme Court case which concerned the computer game World of Warcraft. In this case, the Supreme Court decided that the computer program is protected, but also the film elements are protected as cinematographical works, and the music is protected as a musical work. And this is also how I understand the European Court of Justice, which in the case Nintendo and PC Box, although with a very short reasoning, said that computer programs were complex matters and that graphic and sound elements were protected under the InfoSoc directive, which is the general copyright directive in the European Union. I take that to mean that these elements are protected under general copyright principles independent of the computer program protection. Thank you.
네, 답변 감사합니다.
Thank you. And now Judge Mead from the UK, please give your answer.
Yes, the position in the UK is very similar. It's always been recognised that some forms of commercial exploitation can include multiple copyright works. That's been the position for motion pictures with soundtracks and music and so forth for a long time. So there is no difficulty in recognising that with multimedia works there can be multiple copyright works of multiple different kinds involved, and that will typically be the computer program as a literary work, some of the artwork as artistic works, and so on and so forth. So UK law, as with European law, deals with this by assigning a number of different copyright works which can be protected independently and may well be owned by different people. Thank you.
네, 답변 감사합니다.
Thank you for your answer.
공통질문 두 번째.
Now we will move on to common question number 2. It is whether the font file is deemed to be a program or a work of art. Please explain how your country looks at this issue. First, Judge Du from China, please.
Fonts can be protected by China's copyright law as computer software works. The shapes of words displayed through the font library program can also be protected as artworks if they are original. In this case, Beida Fangzheng Company required the fonts to be protected as computer software works, and each Chinese character of the 5 fonts as artworks. The Supreme People's Court of China held that the fonts can be seen as the computer program. However, it's not artwork. They are not graphic or three-dimensional artworks consisting of lines, colors, or other means. However, the Supreme Court also pointed out that the font shape displayed through the word library program, if originally, can also be protected as artwork. Thank you.
네, 답변 감사합니다. 독일 올리 교수님.
Thank you. Professor Oli from Germany will now give his response within 2 minutes.
Thank you. I think we should distinguish between two issues. The first issue is whether the font itself can be protected regardless of whether it's in an analog or a digital form, whether it can be protected by copyright law. And the second question is whether the fact that the font is digitized adds anything to the equation. Let me answer question one first. Can fonts be protected under copyright law? The traditional answer under German law is no. There is a seminal judgment of 1911 in which the German Supreme Court held that fonts normally don't satisfy the originality criterion. This judgment related to old German fonts, which you see here on the slides as well. And so what the court said is basically design protection is how you protect fonts, and copyright protection is usually not available. There is a more recent Austrian case, Austrian law being rather similar to German law, which I also mentioned in the material, which is along similar lines. It should be mentioned, though, that the criteria for protection of works of applied art are in flux a little bit. We've had case law of the European Court of Justice, the Kofemel case, which concerned jeans. The criteria are a little bit unclear there, and the German court, in its birthday train judgment, has arguably lowered the threshold for works of applied art, so it remains to be seen what that means to fonts. As for computerized, digitized fonts, there is a first instance judgment by the Cologne District Court, which held that fonts can actually be protected as computer programs, but this judgment is criticized in the legal literature because it does not distinguish sufficiently between the fonts as such and the underlying program. I think the prevailing view, with which I also agree, is that basically in most cases fonts are graphical data and they are not protected as a computer program. This may be different in cases like FontForge, for instance, computer programs which allow users to create fonts. They may be protected as computer programs. Thank you.
예, 감사합니다.
Thank you. And Judge Mead, the floor is yours.
Thank you. The answer for the UK on this question is a short one. Fonts have long been recognised as a category of copyright works, and they are recognised in our commentary as being artistic works. They still have to qualify as original copyright works. So a slavish copy of an old font won't be a copyright work simply because it lacks originality. But in terms of conceptually speaking, whether a font, provided it meets all the other requirements for copyright work, can be a copyright work, the answer is yes, and it's regarded as an artistic work.
예, 답변 감사합니다. 이어서 미국 슈러도 판사님의 설명.
And Judge Schroeder's reply will be provided through the video.
Typefaces are not eligible for copyright protection. The machine code used to display the font is protectable. An exemplary case is Adobe Systems Inc. versus Southern Software Inc. from the Northern District of California. The court in this case upheld the copyright protection of Adobe's font software. A defendant who was accused of copying Adobe's font software argued that, quote, the numerical reference points that define an outline of a glyph were unprotectable as a matter of law, end quote. The court, however, saw the creative aspect of the program, specifically each rendering of a specific glyph, required choices by an Adobe editor as to what reference points to select and where to place those points, and held that the defendant's product infringed the software program.
Thank you. And now we will hear from lawyer Patry.
Thank you very much. This is a topic I love. I think Professor Oli's framework is the right one for the US as well. So the answer is that type fonts in any form are original, but they're not protected. It is an example of subject matter that's not protected, but could be because of the opposition of authors and publishers who are worried about being infringed. So I think that's regrettable. I think they're very artistic, but they're not protected under US law. What can be protected is software that generates typeface. What's protected is not the digitized version of the font, but rather the underlying computer program that generates it. So it's protected as a computer program regardless of what the particular output is. I worked in the Copyright Office and wrote the regulation on this, and the office is very clear that you are protecting the software and not the font. Thank you.
예, 답변 감사합니다. 한국의 박태일 판사님.
And now, Judge Park Tae-il.
한국에 대해서 말씀드리겠습니다.
Okay, so speaking for the Korean system, well, as all other panelists have introduced the fonts files that were expressed, or if we look at it under the copyright law or design law, and protection of computer programs under the copyright law, these are the three issues that should be addressed. Well, in Korea, the font itself, through the Supreme Court decision, is not protected. However, the computer program that expresses the font, we explore the eligibility of the program, and if it fulfills all other conditions, then it is deemed as a copyrighted program. And in 2004, with the amendment of the design protection law, while Korea traditionally requires it to be a product, but the font itself can now be protected as a design. Thank you. Thank you for your explanation. So this will end the discussion on the first topic, and now we will move on to the second topic. It is the determination of substantial similarity. So the common question number one is with regards to determination of substantial similarity, is there an official agency that makes that determination in your country, and what method of appraisal is used in your country? Please explain. And common question 1-1 is about the appraisal practices in your country, how the actual practices takes place in your country when it comes to such appraisal procedures. First, we will hear from lawyer Patrick.
Thank you very much. So among the many wonderful things we've adopted from the UK is their system of determining these issues. And in the United States, they are all determined by people like wonderful Judge Schroeder. The only twist is that we have a jury system, so that these issues can be determined by juries, but there's no agency that does it. We're a pure common law country on these things. Thank you.
Thank you very much for the answer. Next, Judge Schroeder. We will hear his video answer.
Substantial similarity between programs can be reviewed by the courts or by the Copyright Office Review Board. With respect to courts, they engage in a substantial similarity analysis in copyright infringement cases. For example, to prove copyright infringement, the plaintiff must show that the defendant had access to the plaintiff's work, and second, that the defendant's work is substantially similar to the protected parts of the plaintiff's work. Substantial similarity can be found even if some elements of the work were changed. Although the terminology differs across circuits, the analysis in the American courts is similar to the Korean system in that the courts will perform an abstraction, filtration, comparison analysis. In other words, number one, the asserted program is dissected according to the different levels of generality. Number two, the unprotectable portions of the work is filtered out. And number three, the remaining work's total concept and feel is compared to another work. With respect to the Copyright Office Review Board, Although it's not required, an author may register his or her work with the U.S. Copyright Office and place a copyright notice on the work. In examining the registration application, the Register of Copyrights reviews the work. For a plaintiff who has the burden of proving his case of copyright infringement of a computer program, it is important to specify the defendant's program which is alleged to infringe the copyright of the plaintiff's program. However, there may be cases where the plaintiff cannot obtain and submit the source code or project code of the defendant's program. In such cases, the defendant shall submit the source code, etc., of his or her program. However, even if the defendant submits the source code, the plaintiff may argue that his or her copyright was not infringed by the submitted defendant's program or the source code was falsified after the incident. On the contrary, the defendant may argue that what the plaintiff submits claiming as the source code of the defendant's program is not the source code of his or her program. In this case, an erroneous conclusion can be made, even if the substantial similarity is properly appraised.
Thank you very much for that answer. I agree with much of what has been said by Judge Schroeder. So next, Judge Mead from UK, the floor is yours.
Thank you very much. In common with the US, we don't have a particular agency entrusted with the task of assessing similarity, and it has to be decided by the tribunal who finds the facts at trial, which is a judge in our system, a high court judge such as myself, or a judge from some of the lower courts for claims of smaller value. The test in UK law is not so much whether there's a substantial similarity between the copyright work and the infringing work overall, but only whether a substantial part has been taken. And in practical terms, this means that only a small amount needs to be taken before there is infringement. That is modified by the effect of some European case law, which still has effect in the UK, that it is necessary that that which is copied to amount to an infringement has to contain elements which are the expression of the intellectual creation of the author of the work. And this brings in an additional kind of qualitative assessment of what has been copied. And it may be that a small part or a large part, even potentially, doesn't amount to an intellectual creation of the author of the work, although in practical reality, there have been few cases where people have avoided infringement under that heading. Thank you.
Thank you for that answer. Next, Professor Oli from Germany. The floor is yours.
Thank you very much. I must say that I found the questions in part 2 very difficult to answer. And I give you a flippant reason why, and I give you a serious reason why. The flippant reason why is I don't really know how to determine substantial similarity because I'm not a computer expert. It's very difficult to say. We don't have Supreme Court cases in point, and we don't really have very clear guidelines. There is no agency, no appraisal agency in Germany. And what the courts usually seem to be doing is they usually appoint an expert whenever copying is not clear, a computer expert who will point out what the similarities are and what the differences are. When we look at the legal context, I think we should distinguish between the reproduction right on the one hand and the adaptation right on the other hand. The European directive gives both rights, so does German law in interpretation of the directive. And as far as the reproduction is concerned, this time it is my pleasure to refer to what Mr. Justice Mead said earlier, because the same EU Court of Justice cases apply, as does the Infopac case. So even small parts, the reproduction of even small parts can be an infringing reproduction. It all depends on whether the part which has been taken is in itself protected as such. And if that is the case, also the copying of a small part can be a reproduction. The other question is, when is a program an adaptation if there are changes? And let me perhaps answer that in relation to the next question, which I think also still addresses this point. Thank you.
Thank you very much for that answer. Next, a judge Duringen from China will hear your answer.
Thank you. The Ministry of Public Security of China issued the technical method for software similarity inspection. The comparison method of the source program is to compare and verify its directory structure by name and so on. It's more complicated to compare the target programs. First, the hash values should be calculated for both target program files. If all corresponding by hash words are the same, the software are the same. If hash values are different, follow these 5 steps. When the plaintiff and the defendant dispute whether the defendant's software infringes the plaintiff's software copyright, the appraisal body will identify their contention issues, such as whether the source and target programs of the two software are consistent. The appraisal report issued by the institution plays an important role in finding out if the two software constitute the same or similar technical facts. When Chinese courts hear cases of copyright infringement of computer software. Thanks.
Thank you very much for that answer. So finally, Judge Son from Korea. So the PowerPoint presentation, is it on? Is it up? Yes, it is up. So let me explain about the Korean situation. Likewise, because of time constraint, let me be very brief. Please refer for a more detailed explanation to the reference book. Under the Copyright Act of Korea, a separate agency called the Korea Copyright Commission appraises the similarities through the following process and represents its findings in a percentage. Set the subject and items to be appraised and set the importance and weight of each item. So the Korea Copyright Commission has a lot of experience and knowledge, expertise about this issue. So there are, however, cases where reappraisals are commissioned to other expert agencies, such as a research center under a university. Thank you very much. So with regards to the appraisal agencies and organizations, I think that was a very good comparison that was made.
Now we will move on to the next set of questions. When it comes to programs copyright infringement, how are open source, the source codes addressed in your country? Please explain about your country's legal system surrounding that issue. I apologize. I accidentally skipped multiple sets of questions and skipped to the last part. Okay, let me re-ask the question. We are now going to cover common question number 2. It is about how we specify the source code of the defendant's program. In your country, how do you set the method to accurately specify the source code of the defendant's program, and which is suspected to infringe a copyright, or a method to confirm whether that source code submitted by the defendant is what is suspected to infringe a copyright? We will first hear from the Korean panel, Judge Son. Thank you. So for the plaintiff, before filing the suit, the evidence preservation can be filed, and there should be a preparation session for the appraisal. And after looking at the source code, we can identify whether that is the identical source code that is suspected to infringe. And if the defendant refuses, then the specific provision can be leveraged also. For the plaintiff, Article 375 can also be applied in this case. Thank you. Yes, Judge Son made a very brief response. Please refer to the reference book, which has a detailed explanation about the Korean system surrounding this issue. Now, we will hear from Attorney Patry.
Thank you. I want to correct one of the slides from before that said that there was a copyright review board. There is no such entity. All of our issues are decided by courts. On this particular issue of specifying the source code, this is not a substantive part of copyright law. It's a procedural issue that's decided under our general federal procedural questions. And it would work this way, which is that you as the plaintiff claim your work was infringed by the defendant's work. You would have to say what the defendant's work is to know whether it's been infringed or not. You may not have the source code, in which case you would, after filing your suit, ask for discovery. So for us, these are all procedural issues that has nothing to do with the substance of copyright law at all. Thank you.
Thank you for your answer. And we will hear from Judge Schroeder through the video that he sent us.
Source code review is common in copyright or patent cases involving computer programs. A party producing the source code may end up producing its most recent version of the source code, or it may produce every version of the source code. Version control is important and useful to narrow the scope. Even where the most recent version is produced, considerable diligence is required on the software's custodians to keep a thorough history of the code. Ideally, a representative version can be identified. This benefits the receiving party by reducing costs and streamlining discovery.
Thank you. Now, Judge Du from China, the floor is yours. Judge Du, the floor is yours.
Hello. Can you hear my voice?
Yes, we can hear you. But we can hear you, but we can't see you. Your video is off. So perhaps we will move on to a different panelist and come back to you. Then how about we listen from Professor Oli about the German system. Thank you.
Okay, let me echo what Mr. Petrie said earlier. This is a procedural matter. It's not a matter of substantive law. And perhaps I have the disadvantage here of being a representative of the ivory tower and not being a practitioner myself, so that I don't really, am not terribly familiar with issues of evidence. Generally, the general rules of German civil procedure apply. There is no principle of discovery in German law that distinguishes German law as a civil law jurisdiction from common law jurisdictions, but there is a claim to inspection under copyright law. So if the claimant doesn't know what exactly the defendant's program looks like, the claimant can bring such a claim for inspection, and this claim for inspection will allow him to look at the computer program, to operate the computer program, and to look at the source code of the computer program, and that enables him to get hold of this of the program. Unfortunately, that is all I can say about these issues of evidence. Thank you.
Thank you. And Judge Mead from the UK, the floor is yours.
Yes, thank you very much. In common with some of the other speakers, I can confirm that for the United Kingdom, this is indeed a procedural matter and not a substantive requirement of bringing a copyright claim. We do have a number of different procedures available to obtain a copy of the defendant's source code. There is a general obligation in UK law which is applied flexibly for a defendant to provide documentary disclosure of their source code at a later point in the proceedings. But in the case of defendants who are behaving suspiciously, then there are peremptory procedures available early in the proceedings to obtain a copy of the source code by compulsion if the defendant can't be trusted. And in extreme cases, this can even include an application to the court in the absence of the defendant to get an order that they should provide the code. So there are a range of possibilities which are probably too detailed to go into, but this is a matter of procedure and not substance for the UK.
Thank you. The differences between civil law and the common law on the discovery procedure was elaborated, and it seems that there are procedural differences among the countries. Judge Du's video is still not on, so how about we just move on to the next question? So common question 3-1 and 3-2 will be covered now.
So in relation to determining the similarity, substantive similarity of programs, do you consider the quantitative similarity in the determination of substantive similarity, or is there any other method that is preferred in your countries? First, we asked Judge Mead from UK.
Yes, thank you. We touched on this already in addressing one of the earlier questions, but it's very clear for the UK and I think for Europe generally that this is not a task in the judicial fact-finding process that's done by providing a numerical answer resulting from a calculation. It's a qualitative assessment which focuses on the material that's been copied.
I think we have some, technical glitches. Yes, Judge Du, question will be directed to you later on. Judge Mead, can you continue on, please?
Yes, I was saying it's not a question of a calculation coming to a numerical answer, but a qualitative assessment of the nature of what's been taken. And as I said earlier, this can result in infringement being found even if what's been taken is only a small amount of the copyright work, if what has been taken is protectable in its own right, and that involves an assessment of whether it is the expression of the creative process of the party who created the copyright work. So in short, it's not a quantitative assessment for us.
Thank you very much for that answer. So we'd like to pass the floor to Mr. Patry from the United States. Can you explain about the institutions in the United States?
My answer is
I'm sorry, can you check if your microphone is on? We can't hear you. We can't hear you, Mr. Patry? I think there is connection issues. I'm sorry. Mr. Patry, we are not able to hear you. Can you?
Yes, my microphone is on. Can you hear me now?
Yes, we are able to hear you now.
Okay, so my answer is the same as Mr. Justice Mead's. I would only add that these principles were enunciated with remarkable clarity back in the 1700s by the early UK judges. And we've done nothing to improve on them. In some ways, we've done a lot to take away the genius of their answers on these questions. In particular, the abstraction filtration comparison test, which Judge Schroeder talked about. And it's true that that's a dominant approach in the United States. It derives, however, from a treatise writer, and I think it is an inordinately complex, incredibly unhelpful, and leads to only one thing, which is the hiring of experts. And those experts, of course, will have different viewpoints depending upon who's hired them. I think the only complicating factor for software is this. As I mentioned earlier, the definition of software has a functional requirement. It has to be a set of statements or instructions in order to bring about a certain result. So the conflict is really not what standard you apply to find infringement, but how you find infringement for a particular type of subject matter that has a functional requirement and really functional DNA. This also has issues, of course, with the general approach of not protecting ideas, systems, methods of operation. So whether software is a bad fit for copyright or a good one, it at least has difficulties in determining infringement of what you consider expression. Thank you.
Thank you very much for that answer. So with regards to the U.S. system, Judge Schroeder will provide an answer through his video message.
Generally, courts in their substantial similar analysis make the comparison between source codes. There's not, however, a bright line test or a magic number that determines whether copyright infringement has occurred. Even when there was a large overlap, the accused computer program's use of the other program may qualify as fair use. With respect to fair use, the amount and substantiality of the portion used in relation to the copyrighted work as a whole is a consideration when courts determine whether there was fair use. The district court has discretion to decide to what extent, if any, expert testimony may be used to ascertain substantial similarity, or whether a defendant copied any part of the plaintiff's work. Computer Associates International versus Italia, Inc., a case from the Second Circuit, tells us, quote, "To this end, the two works are to be compared in their entirety, and in making such comparison, resort may properly be made to expert analysis." The standard for copyright infringement is substantial similarity, not just similarity. Thus, a calculation of similarity of programs has an effect, but it needs to be substantial in order to reach infringement. One needs to keep in mind that the fact finder may have to consider literal and non-literal copying. Even if there may not be literal similarities between programs, the similarity analysis is not limited to just literal similarities. Copyright protection extends to non-literal copying as well, so even paraphrasing does not preclude an infringer. In the computer software space, programs can be written with the same purpose and intent. Thus, two programs from different authors having independent creation may appear similar. Thus, analyzing the similarity of programs is challenging. Copyright case law has provided some examples and methods to determine whether there is a substantial similarity between programs. The Althea or abstraction filtration comparison test. A widely used test is the Althea or abstraction filtration comparison test. Generally, infringement is shown by substantial similarity of protectable expression, not just the overall similarity between the works. Thus, it is necessary to eliminate the unprotected portions from the program. That case dealt with the situation where, upon learning that 30% of a program had been copied from a competitor, Althea had a team remove that code and recode the functionality. Thus, the new version contained none of the competitor's code. The question was whether the new version was still infringing, despite not having any of the competitor's code. The abstraction filtration comparison test was then born to see whether there was substantial similarity. With respect to abstraction, the first step is to separate the ideas from the author's expression and eliminate from the substantial similarity analysis those portions of a work that are not eligible for copyright protection. The analysis starts with the code and goes backward through the different levels of abstraction, ending at a general statement of the program's idea. For example, the levels of abstraction may be: number 1, main purpose; number 2, the program's architecture; number 3, the modules; 4, the data structures and algorithms; 5, the source code; and 6, the object code. With respect to filtration, at each level of abstraction, the program is then filtered using copyright doctrines that would deny protection, such as the merger or scenes affaire. There's comparison. Finally, what is left of the protectable work is compared to the allegedly infringing work to determine whether the defendant copied any aspect of the remaining protected expression. Also for consideration is the relative importance of the copied portions with respect to the plaintiff's work. Structure Sequence Organization Analysis, or SSO. Another test that courts may use is the Structure Sequence and Organization Analysis for determining similarity, or SSO. As mentioned before, copyright protection can be extended beyond a computer program's literal code to reach the program's structure, sequence, and organization. In the Whelan Associates case, the literal elements of the program had not been copied, but the court held that the structure of the program was its unique expression rather than the unprotectable idea of efficient dental lab organization. That case arose in the Third Circuit and was decided by that court in 1986. The SSO analysis has shown up in many subsequent cases, including throughout the Google versus Oracle litigation around the Android module programming.
Yes, thank you very much for that detailed explanation. Next, Professor Oli from Germany.
Yes, thank you very much. As I mentioned earlier, the EU directive and also German law implementing the directive distinguish between the reproduction right and the adaptation right. So whenever parts have been copied in an identical form, the principles apply that we touched upon earlier, that Mr. Justice Mead talked about and that I also referred to. But even when there is non-literal copying, when the parts are not identical but only similar, there may be infringement because the adaptation right may apply. Now, this, of course, forces the courts to determine whether there is still an adaptation, whether there is still substantial similarity, or whether there is not. The courts have decided that a mere comparison of the binary code is insufficient in this respect. Similarity can only be determined by a comparison of the source codes. And there is no really very clear formula or very clear approach to this issue in German law. Courts attach particular importance to similarities that cannot be explained by common usage or by coincidence. One example would be a program error, for instance, which you also find in the defendant's version and which cannot be explained other than by copying. Other examples would be individual programming styles or a particular arrangement of sub-programs, an unconventional choice of variable names, and so on. So specific features that cannot be explained by reference to common usage and that you find in both the claimant's and the defendant's program. Thank you.
Thank you very much for that answer. Next, from Judge Son from Korea, can you explain about the Korean situation? Thank you very much. In the case of Korea, the objective and quantitative similarity between computer programs is relied on in Korea. The precedents state that the evaluation of substantive similarity is not only based on quantitative evaluation of a similarity. However, in practice, it is noted that there is a close relationship between quantitative similarity and substantial similarity. More specific, similarity calculation methods, classification of similarity based on expression methods, classification of similarity based on calculation methods, can be differentiated into different classifications. Decisions are reached on a case-by-case basis. Thank you very much for that explanation. Judge 2 from China, the internet connection, I think, is suffering from some technical problems. As soon as this problem is resolved, we will hear from Judge 2. Now we'll move on to the next question.
Common question 4, 4-1 and 4-2 will be covered now, and we will look at what a striking similarity and how it works as a criteria. So let's hear from Professor Oli first.
Thank you. So the general approach adapted by German courts is set out in Section 23 of the German Copyright Act, which is the test of a sufficient distance, whether the defendant has kept a sufficient distance from the claimant's work. And quite often a formula, a test which is applied in German law, is the test of whether the individual traits of the claimant's work have faded away in the defendant's work. Let me give you an example from general copyright law, namely the example of a sequel. A celebrated German case concerned a sequel written to Boris Pasternak's well-known novel, Dr. Zhivago, and the sequel was called Lara's Daughter, and it drew on some characters from Dr. Zhivago and also some traits of the story. The court inquired whether these traits and whether the characters were still individual, and as the court found that both the characters and the traits were individual, that they could be distinguished from the general idea of a doctor in times of revolution, the court held this to be copyright infringement, although it was just a sequel and non-literary copying. Now, if we try to apply this test of sufficient distance to computer programs, we encounter a problem because, as Mr. Petrie said before, computer programs are technical subject matter. They are not really, as the Court of Justice sometimes says with relation to general works, they are not really stamped with the author's personal personal touch, but they are created to achieve a certain result. And so this idea of individuality fading away is not terribly helpful when looking at computer programs. So the general test is applicable in theory, but I don't find it really helpful with respect to computer programs. Thank you.
Thank you for your explanation. And now, Judge Mead, the floor is yours.
So this is a rule of evidence developed by the judges in the UK and not part of our statute. And I've always thought of this as a common sense principle rather than something where hard and fast rules are required. But nonetheless, there is case law setting out the proper approach for the court. And the principle which was decided by our highest court, the House of Lords, in the 1970s, is that if there has been evidence that the defendant has had access to the plaintiff's work and there's a sufficient degree of similarity, then the defendant has to prove that they did not copy. And so the onus of proof shifts to the defendant. And as to how much similarity is required before that principle starts to apply, the answer is that it has to be a striking general similarity, which means that banal similarities which could have arisen simply from the fact that the two copyright works perform the same overall function aren't adequate. But there's no statutory definition, so it has to be applied with common sense. In the right case, it's not necessary to prove access at all, because it's entirely possible that the similarities are so great that the only possible explanation is copying, and one can infer that there must have been access, even though the plaintiff is unable to prove specifically how that took place. So the short answer is this is not a statutory requirement, but a rule of evidence, and that a combination of access and striking similarity puts the onus on the defendant to prove that they didn't copy.
Thank you for your answer. We will now hear from Mr. Patry.
Yes, so following up Mr. Justice Mead's comments, in the United States, this is a rule of evidence too, and it works to place on one party or the other who has the burden of showing that something occurred. Whether the plaintiff has the burden of showing that the defendant infringed, or if the burden shifts, whether the defendant has that burden. As we consider striking similarity in the United States, which may be different in the UK, I don't like the idea that you never have to prove access. You should always have to prove access because of the availability of independent creation. It may be that most people would think there's no way those two works, are so close without copying, and I understand that as a common sense issue. But as a doctrinal issue, since independent creation is a defense, to me, the plaintiff always has to prove access, whether it's circumstantial, inferential, or something. Thank you.
Thank you. And we will hear from Judge Schroeder through the video.
Access can be inferred when there is a striking similarity between the works. This was established by the Second Circuit in Arnstein versus Porter, where even though there was no access, the similarities between the works was, quote, so striking as to preclude the possibility that the plaintiff and defendant independently arrived at the same result, end quote. That's a Second Circuit case from 1946. In other words, this occurs where the works are so similar that it is practically impossible that they could have been independently created. Courts may consider many factors when looking for a striking similarity. Number one, they may consider the uniqueness or the complexity of the similar portions. Number two, if the plaintiff's work has a unique or unexpended component that is also in the defendant's work. Number three, whether the same mistakes appear in both works. 4, whether the plaintiff placed identifying mistakes in his or her work, and those same mistakes also appear in the defendant's work. Or 5, the defendant's obvious attempts to create dissimilarity. The similarity may be less than verbatim, but there is no striking similarity even where two identical works warrant an inference of access or copying to the extent that, albeit copyrightable, they are commonplace or functional. Striking similarity is the analysis that's used to determine whether copying has occurred, which can then infer access. This is not to be confused with the substantial similarity analysis, which is used to determine whether the copying reaches the level of actionable infringement. Substantial similarity looks at the overall work, whether by expressions of ordinary observers or dissections made by experts. So even if there is a finding of literal copying, there are several other factors in the substantial similarity analysis that would prevent a finding of infringement. Another difference between the standards is the type of proof that is required. Although expert testimony is optional in the substantial similarity analysis, expert testimony is required to establish striking similarity, absent the situation where there was considerable and blatant copying. To prove copyright infringement, the plaintiff needs to show, first, that the defendant had access to the plaintiff's work, and second, that there is a substantial similarity between the plaintiff's work and the defendant's work. These are still two separate elements. Although there may be some overlap in the analysis, satisfying the second element of substantial similarity does not necessarily create a finding of the first element of access.
설명 감사합니다.
Thank you for your explanation. Moving on, Judge Lu will give us her answers on common questions 2, 3, and 4. So the floor is yours, Judge Du.
네, 두 판사님.
Judge Du, I think you are on mute. Please turn on your microphone. We can't hear you.
예.
The plaintiff has the burden of proof. He can confirm the content of the confirm the contents of the software being infringed through notorified evidence. He can also apply for evidence preservation. China's copyright law stipulates that copyright owners may apply to the court for the preservation of evidence before filing a lawsuit in case if the evidence may be lost or difficult to obtain later. If he doesn't take both of the above two methods and directly file a lawsuit, the plaintiff may lose the lawsuit when the software provided by the defendant in the lawsuit. It's when the plaintiff found the defendant's target program, and the target program is the same or basically the same as the plaintiff's program, defendants are obliged to provide the source program of their software as match for their non-infringement defense. Furthermore, the source program provided should be compared into the target program that the plaintiff has taken evidence of. If it cannot be confined into the target claim, it can be proved that the source program was not used for infringing, and the plaintiffs are liable for adverse consequence. Thanks.
공통질문 3번에 대해서
So with regards to common question 3, can you also answer question number 3? Common question 3. Judge Du, can you answer common question number 3?
연결이 안.
Can you hear me? Judge Du,
공통질문 3번과
an answer to common question 3 and 4. Can you provide an answer to these questions?
In China, it is usually determined whether the two programs constitute substantial similarity by comparing the two source programs. However, when the defendant refused to provide the source program, the two target programs need to be compared in order to make a judgment. The above comparisons are carried out by professional accreditation bodies. The coder shall make a comprehensive judgment on the basis of the appraisal and the circumstances of the case. Thanks.
공통질문 4번 의거서
Now, could you please answer common question 4 on access?
The criteria for striking similarity should apply in the same or essentially the same case, while the criteria of substantial similarity apply in the case where the two are or not identical. In part 1, in case 1, the similarity between the two software is up to 69% in the binary target code. Therefore, the court determined that Super's software violated the copyright of brother company. And the case 2, according to the appraisal opinion, the court held that the infringing software was highly similar to the involved software. In my opinion, it's about question 421 or 422. In my opinion, it should be applied with caution. If the two source program constitute substantial similarity, it may be presumed that it has access to the plaintiff's software. 2, if the two target program constitute substantial similarity, they cannot be used as a criterion for judging content. 3, when the two target programs constitute substantial similarity, it can be used as criterion for judging content if the defendant failed to give reasonable expression for some similarity between the two target programs, such as the common defense, the same hash value, and so on. In case 1, the court found the following things of the two software are the same. In case 2, both programs have the English brand name and both information time. Thanks.
네, 설명 감사합니다.
Thank you very much for that answer.
한국의 송판사님 간단히 제도 설명해 주시기 바랍니다.
Now the floor goes to the Korean panel Judge Son on the issue of access. In one of the Supreme Court decisions, it is shown that access looks at a possibility of access and if the similarity is acknowledged, then access is established. And if it is so strikingly similar that there is no possibility without access and copying, then access can be inferred. That is my short answer. Thank you. Thank you for your explanation. Now we will move on to question 5.
So, with regards to open source material, how do you treat the so-called open source material in terms of copyright infringement of a program? So, we'd like to invite Judge Du from China for your answer on this question.
Okay, thanks. If the defense
Yes, we are able to hear you well.
If the defendant use an open source program or a simple combination of open source programs, it does not constitute an infringement of the plaintiff's software copyright. If it recombines the programs and adds his original content to form a new work, it can be the object of copyright protection. However, if the open source program he uses is accompanied by a license and such stupid the source of the new work modified by the open source program, it should combine with the license agreement. For example, the GPL license has related strict restriction on user. According to the license, if the user modifies or devises the source code of the open source software attached with the GPL license, the user must also release the modified code and devised code as open source software GPL license. In this case, the defendant should follow the GPL agreement to open the source code to the public free of charge, but the defendant refused. The authorization obtained by the defendant through the agreement has been automatically terminated due to the achievement of the dissolution of the conditions. The defendant constituted infringement due to the loss of the source of rights. About question 521, my opinion is if the defendant claims that what he uses is open source code, the defendant is obliged to give evidence. The appellate agency may also conduct identification if the defendant applies. Thanks.
설명 감사합니다.
Thank you very much for your answer. Next, we would like to invite Professor Oli from Germany.
Thank you. I think in this scenario, the general rules on reproductions and adaptations will apply. Open source software is not treated differently. So if the defendant takes a part of open source software, which is protected by copyright law, and uses it in his own program, all depends on whether the defendant observes the license, the GPL license. That is, in particular, whether the defendant himself makes his own software available under GPL terms. If he does so, he's justified by the license. If he doesn't do so, this will amount to a copyright infringement. On the other hand, it's quite possible that the defendant acquires his own copyright in the adapted program. Once again, that would follow general principles of copyright law. Thank you.
네, 설명 감사합니다.
Thank you very much for that explanation.
손 판사님, 한국 취급에 대해서 설명.
Now the floor goes to Judge Son on the Korean system. So in Korea, the often open source software infringement was not found in any precedent, but if the computer program of the defendant infringes the plaintiff's program, in order to decide on such issues, we are considering open source when we are doing appraisal of the similarity, excluding open source, or looking at the level of similarity of the open source, or in the process of development, even if open source was used, the value as a trade secret is not automatically denied. That was what the precedents showed. Thank you. And we will hear from lawyer Patry from the United States.
Yes, as with special ruling, there are no special rules in the United States. If by open source we mean copyrighted material that is made available according to a license, you either follow the license or you don't. If you do, you're fine. If you don't, you're not. Thank you.
네, 간단한 설명 감사합니다.
Thank you for your very brief and concise answer. Well, we are really in a rush now, given the allotted time. We will listen to Judge Schroeder in the video.
Open source software is software available to the public for use, but open source does not necessarily mean that there are no restrictions to that use. This is not to be confused with software that is, quote, in the public domain. Open source software does tend to have a license. For instance, in Jacobson versus Katzer, the Court of Appeals for the Federal Circuit had to consider the ability of a copyright holder to control future distribution and modification of their work when they had provided the work for free for public use. In that case, Jacobson provided its code for free to the public under an open source public license. Katzer had used Jacobson's code without putting up copyright notices that referred back to Jacobson in violation of the open source public license. The Federal Circuit held that the copyright holder was allowed to limit and enforce copyright conditions in that case. According to the previously mentioned case, Jacobson versus Katzer, a copyright holder who engages in licensing his or her open source material or computer software has the right to control the modification and distribution of that copyrightable open source material. Courts may consider whether there was infringement based on compliance with the modification and distribution terms of the license.
네, 설명 감사합니다. 오픈 소스에 대한 설명.
Thank you for your answer. Explanations on open source and the degree of similarity of computer programs were discussed under this question. Now we will move on to the third topic, the calculation of damages caused by infringement of copyright in programs. So we will now move on to common question number 1. How does your country calculate damages due to infringement of copyright in programs, and the reasonable compensation and a method of its calculation is what I would like to ask our panelists. If each module form a package program that is composed of multiple modules, and depending on the scope that is necessary for business, there can be purchase of different scopes of the programs, and it is a very rare case that the whole package program is subject to a purchase. And if there is an unauthorized copying of the whole package program, then how does your country calculate damages according to these differences? Do you calculate for the piece or the whole package of the program? So first we will listen to Judge Schroeder in his video.
In this instance, because the whole package was copied without authorization, the damages calculation would consider the price of the whole package program. Granted, if most licenses would not purchase the whole package program, the damages may be how much a willing buyer would have reasonably been required to pay in that hypothetical negotiation.
Thank you very much for the explanation. And now we would like to invite Mr. Patrick from the United States for further explanation.
Yes, so there are no special rules for damages for software. It's the same as for every subject matter. The United States is extraordinarily generous in the remedies it gives copyright owners. A successful copyright owner, that is one who's proved infringement, can get its actual damages, in other words, losses, the income it would have made but for the infringement, and but for is an important qualification there. You can also get the defendant's profits, that is the money that the defendant made from the infringement. You can even get both, so long as there's not double counting, so long as you don't count the same sale twice. The third type of money damages you can get are statutory damages, which means simply that. They're damages that are set out in the statute. It is $750 as a minimum, and you can go up to considerably more, $100,000 if it's willful infringement. As for the package part of it, it just depends. If you copy the whole thing, then you get whatever the damages are for the whole. If you copied only part of it, well, then you'll get damages for what part. But there are no special rules. It's the same as for everything. Thank you.
Thank you very much for that explanation. And next, from UK, Judge Mead, your answer, please.
Thank you. I think from the sound of it, we have a very similar position to that which has just been explained for the United States. In the UK, a successful plaintiff in a copyright case can choose between taking the infringer's profit or getting damages. And if the plaintiff chooses damages, then there are several different ways of doing it. Damages are compensatory in the UK. We don't have exemplary or punitive damages. But if the plaintiff sells the copyright product and the defendant's infringement causes the plaintiff to lose a sale, then the plaintiff's damages are assessed by the profit that it would have made on that sale. And I think coming to the answer to the specific question about the whole programme, this would be a question of fact in the UK about what it was that the Defendants Act had caused the plaintiff to not be able to sell. And if the sale of one module had prevented the plaintiff from selling the whole programme, then the plaintiff could get damages for the whole programme. I think it's just also worth mentioning that if a plaintiff can't prove that he lost an actual concrete sale, then for that particular act of infringement, he's entitled to a notional reasonable royalty instead for those sales. So a plaintiff can get a mixture of lost profit sales for those customers where he can prove that he would have made the sale and a notional reasonable royalty for other customers. Thank you.
Thank you very much for that explanation. Next, with regards to the Korean situation, we will hear from Judge Son. So let me be brief and summarize the situation in Korea. In the case of Korea, with regards to commercial programs, when they are copied in an unauthorized manner, the permanent licenses are normally sold and bought. That's the situation in Korea, and so this kind of case can be more of a problem in Korea. on. So if you look into this in more detail, unauthorized copying from the defendant's company, which employee did this? There are cases in which employees are identified and illegal reproduction case can be brought forward, filed, and so it can be claimed that the entire package sale related laws should be claimed. However, the consideration for the permanent license, how should it be calculated? Well, that should be left for the determination of the judges. And another aspect is who among the employees of the defendant company engage in illegal download. Without going into that issue, if somebody in the defendant's company, you made use of the software knowing that it was illegally installed, this is the subject matter of many of the cases in Korea. So here, among the models, which model was practiced, that would be the focus in these kind of cases. So that will be my answer. Thank you very much for the answer provided. Next, from China, Judge Du, your answer, please. Please limit your answer to 2 minutes. Thank you very much.
Yes. According to China's copyright law, the infringer should pay compensation on the basis of the actual loss suffered by the right holder or the infringer's illegal income. If the loss and the income are difficult to calculate, compensation can be made with reference to the royalties of the right. If the circumstances are serious, compensation may be made not less than 1 time and not more than 5 times the amount determined following the above-mentioned method. About the package program, my opinion is the tort committed by the defendant was an illegal copy of the entire program package. So the compensation for damages should be calculated based on the value of the entire program package. However, if the external license fee of the entire package is very different from the defendant's infringement profits, and the plaintiff uses this as the basis for calculating its losses from the perspective of the balance of interests, the infringer's profit should be more considered when determining the amount of compensation. Thanks.
Thank you very much for that answer. And now, lastly, from Professor Oli from Germany, we'll hear your answer.
Thank you. In Germany, as in many of the other jurisdictions that we have heard about, there are no specific rules for computer software. So the general principles on damages in copyright law apply. In Germany, damages are compensatory. This means there are no punitive damages, and the courts are actually quite strict about this. There is a discussion among legal authors whether in appropriate cases there should be a double license fee, for instance, should be available. And indeed, the European Court of Justice has held that the member states are free to award overcompensatory damages in cases of copyright infringement, for instance, twice a notional license fee, but German courts don't do that. In Germany, damages are only compensatory and the claimant is not going to get anything more. There is no principle of double damages. So the general rules apply, and under the general rules of calculating damages, the claimant can choose between 1, damages based on the claimant's actual loss, 2, the amount of a hypothetical license fee, or 3, the disgorgement of the defendant's profits. In the particular package scenario, I think everything would depend on the facts. It would depend on what reasonable parties would agree as a license fee. If in that particular area of the market only the entire package is licensed, then probably the reasonable license fee would be calculated on the basis of the license for the entire package. Whereas if reasonable parties split up the package, and if it is, for instance, usual in this area that you can only take a license for parts of the package, this will be taken into account by the courts when calculating damages. Thank you.
감사합니다. Thank you very much for that answer. So,
after unauthorized copying of a program has been revealed, if an infringer had purchased without agreement with the plaintiff as many genuine programs, the products for which a permanent license has been obtained, as the number of infringed programs is this factored in calculating the damages corresponding to the past infringement in your country. First, we will hear from Judge Park. So, due to the fact that there are many permanent licenses, I think it is becoming an issue in many lower court decisions. From the standpoint of fairness, such a fact is being factored into. This is the aim, and they are deliberating on methods to do so. Thank you. And Judge Mead, can we hear from you?
Yes, so the principle in the UK is that a plaintiff can't recover twice. So assuming that the infringing copies don't remain in circulation and the defendant simply uses the legitimate copies, then the payment of the fee, the payment of profit that would have been made on those, the license fee, should fully compensate the plaintiff and they can't recover further. It could be different if the infringing copies remain in circulation, but I don't think that's the thrust of this question.
Thank you for your explanation. And Judge Du, please limit your answer to 1 minute. Thank you.
If the person regularly copies software and then makes the copied software available for permanent use by purchasing a serious number from others, he should bear the tort liability for his illegal copying activities in the past. As for the subsequent purchase of serious numbers, a distinction needs to be made. If the serial number is purchased for commercial use and the right holder restricts the usage and quantity of the serial number, if the infringer should be responsible for his subsequent actions. If the right holder does not, the principle of exhaustion of rights shall be applied to the right holder. Thanks.
네, 설명 감사합니다. 독일 올리 교수님 간단히 설명 부탁드립니다.
Thank you. In Germany, there is no possibility of double recovery either. So if the defendant takes out the licenses that cover exactly the uses that he's been making, there will be no damages. But of course, this all depends on the scenario. So if the defendant started infringing in 2019, and now he takes a license which covers the uses starting in 2021, then he will still be liable for the damages concerning the uses in 2019 and 2020. But if the license covers exactly his uses, then this will exclude a claim for damages.
네, 설명 감사합니다.
Thank you for your explanation. So, about calculation of damages For the infringement of computer programs, I think we have finished our discussion on that topic, and now we will move on to topic 4 on exhaustion of rights and fair use. When it comes to programs that are distributed online, is the principle of rights exhaustion applied? Please explain about your country's institution. Professor Oli, you have 2 minutes or 1 minute.
Thank you. So there is some interesting case law, there are some interesting judgments handed down by the European Court of Justice in this respect. In the case of UseSoft and Oracle, the Court of Justice decided that there is a principle of online exhaustion, so that with respect to computer programs, exhaustion even applies if the copy of the computer program is sold online, and even in cases in which the files have not actually been transferred, but in cases in which the seller only sells the product key, thereby allowing the buyer to actually download the program. This was a surprising case, and many in the copyright community think it's wrong. The Court of Justice said that held that the Computer Programs Directive was a lex specialis, that is, the general principles of copyright law did not apply in this respect, that the directive related to the sale of copies, and a sale of a copy could also be an online sale of a copy, and finally, economically speaking, online transactions and the good old sales of data carriers were economically equivalent. However, recently the Court of Justice took a different view with regard to other works, in particular with regard to audio books in the case of Tom Cabinet. In this case, the Court of Justice held that there is no exhaustion when you sell a copy of an audio book online. And the reasoning in that case was more in line with traditional copyright principles. Only the distribution right is subject to exhaustion, and what goes on in these cases of online sales is not a distribution of a tangible copy. Also, Article 3, Paragraph 3 of the InfoSoc Directive clearly states that the right of communication to the public is not subject to exhaustion. So there is a difference here between computer programs and other works, which causes all sorts of programs, particularly in complex works that we discussed earlier. If there is, for instance, a computer game which both contains a program and other types of works, it's very difficult to say whether exhaustion applies or whether it doesn't apply. Many critics in the legal literature think that the oral case was wrongly decided, and I agree with these critics. Thank you.
Thank you for your answer. And now we will listen to Judge Schroeder through the video.
Whether the first sale doctrine applies depends on whether there was a sale or a license. A license in this context works as a loan in that there is no ownership transfer like a loan. In other words, the licensee still must abide by the restrictions set by the copyright owner. Without issue, a copyright owner that sells a copy of his or her copyrighted work grants the new owner the right to transfer or resell that copy without the copyright owner's permission, and the first sale doctrine applies. However, if the copyright holder merely licensed the program, the first sale doctrine does not apply. The disputes generally concern whether a sale was made or whether a license was granted. One case that dealt with the first sale doctrine was Adobe Systems versus Christensen, where the Ninth Circuit found that the defendant's unauthorized sales of physical copies of Adobe's programs were protected by the first sale doctrine.
Also, thank you very much for that explanation.
The floor is yours, Lawyer Patry.
Yes, if I could explain Judge Schroeder's explanation, it's this, that the first sale doctrine applies, of course, if there's a sale. The question of whether there's a sale or not isn't an easy question to answer in the United States for this reason. There is no federal copyright law definition of what a sale is. Instead, that's determined by state law. So the state law in Alabama may be different from the state law here in Connecticut, but generally the courts have taken a rather common law view, which is if it looks like a duck, walks like a duck, and quacks like a duck, it's a duck. If it looks like a sale and acts like a sale, it's a sale, and the first sale doctrine applies. If it looks like a license and acts like a license, it's a license, and therefore first sale doesn't apply. On Professor Oli's point, we do have a specific exhaustion provision for computer programs that are embodied in video games. Thank you.
네, 설명 감사합니다.
Thank you for your explanation. Now, Judge Du, the floor is yours. Please make your answer within 2 minutes.
Thank you.
감사합니다.
My opinion is copyright law and software stipulates that the publishers or producer of a software copy cannot prove that he has been legally authorized, or the issuer or lessor of the software copy cannot prove the copy has a legitimate source. They shall bear legal responsibility. The above laws and regulations clarified the applicable conditions of the principle of exhaustion of rights in software copyright infringement cases. After the copies of computer software are legally disputed, the copy's owner can transfer and dispute it again. The copyright owner's right to distribute has been exhausted. In this case, Mr. Liu bought two lace-making machines containing software from Daju Company. Then he transferred them to Jiatai Company. Jiatai Company installed the software in the laser-making machine on its self-produced machine with the software dog of Daju Company. So the court held that the principle of exhaustion of rights applied to the software copies sold by Daju Company. Thank you.
네, 설명 감사합니다. 이어서 한국
Thank you. And now we will listen from our Korean panel. Please make it very concise. Thank you. In our case, if we look at the Article 20 of Copyright Act, the exhaustion principle can be applied, but according to the provision, it is only applicable to tangible products as well. Well, there are talks of legislation to make changes, but under the current law, digitally downloaded software which is sold online, then it is very difficult to apply the exhaustion principle. The Seoul Central District Court also ruled recently along the same lines. Please look at the reference book for details of the case. Thank you. Thank you for your explanation. And now we will hear from Judge Mead. Please limit yourself to 2 minutes to answer this question. Thank you.
Thank you. I can be very short, actually, because this is an area where the UK law is still set by the case law of the European Court of Justice until perhaps we diverge in due course following Brexit. But for the moment, the crucial case law is the case law of the European Court of Justice, and Professor Oli has covered that already. And so I don't have anything to add. We're very closely aligned with the Germans for the moment and the rest of Europe.
네, 설명 감사합니다.
Thank you for your explanation.
그러면 다음은 미국 패널에 대한 개별 질문입니다.
And now I will pose individual questions for the U.S. panelists. So, in the case where Google used Oracle's Java, the cause of action was an unauthorized use by Google of that Java. the Java SCIP actually being used by Google in that way was ruled as fair use by the U.S. Federal Supreme Court. So please explain on that case. Thank you. First, we will hear from Judge Schroeder in his video.
이 부분 영상이 준비 안 된 것 같습니다. 그러면 미국 패트리 변호사님의 설명을 듣겠습니다.
Okay, so me, not Judge Schroeder, yes? Okay, so I've worked at Google for 15 years, so you should take that into account. For 10 of those years, I worked on the Oracle case, so I know a little bit about it. The thing to understand about the Oracle case is the very strange posture of it, which is this. There are three issues, as there always is: copyrightability, infringement, and fair use. Copyrightability was decided by the trial judge. He decided that the particular material was not copyrightable. The Court of Appeals for the Federal Circuit reversed that and said that it was. On the question of infringement, that went to the jury, but the jury was told, assume that this is copyrightable. If it's copyrightable, was there infringement? The jury said, yes, since we have to assume it's copyrightable, there was infringement. But then the jury had to decide fair use. And the jury found there was fair use, and the only answer was yes. Right? We have two types of jury verdicts. You can answer specific questions, or you can just simply say yes or no. In this case, the jury was asked to say yes or no. Was it in fair use or not? And the jury said, yes, it was fair use. That was appealed to the Court of Appeals for the Federal Circuit. The Federal Circuit, for reasons of its own, said, no, this was not fair use. That was appealed along with the copyrightability question to the Supreme Court. Our Supreme Court did not answer the copyrightability question, but they did say it was fair use on the particular record that was there. So this is a case where the procedural posture of the case has everything to do probably with the outcome of it. I'd be happy to answer more, but I'm out of time on that. So my only caution is that you really have to understand the procedural posture of the case to understand what's going on.
네, 감사합니다.
Thank you.
지금까지 제4 세션에
So this brings us to the end of our discussion in session 4. As you have all heard, session 4 was dealt with how copyright infringement suits play out in different countries and how some sticking points are addressed by these different countries. We heard about various cases and judicial practices. Due to time constraints, each panelist weren't able to sufficiently cover all of their detailed responses, but still today's discussion was very fruitful. If some of the explanations were insufficient during the session, then they are all included in the reference book. So that will serve as a great reference. And now let's close the discussion for today. Thank you. Especially Lawyer Patrick, thank you for staying up all night to join the discussion. Thank you.
감사합니다. 이것으로 네 번째 세션을 모두 마치겠습니다.
Thank you. So that brings us to the end of session 4. Thank you all panelists and presiding judge Sarvam Sheikh for being a great moderator. Thank you. 2021 IIPCC's first day agenda has all been covered despite your busy schedules. Thank you for taking part in this conference, and thank you for all of the online participants for staying attentive throughout the whole conference. I hope today was a very meaningful day to all of our participants. We will now discuss service invention and have a mock arbitration trial on the compensation tomorrow at 10 a.m. Thank you.
예, 안내 말씀 좀 드리겠습니다.
So a word of announcement. Because for those of you who would like to attend the training session that we are providing for the lawyers and patent lawyers, and for those of you who are heading toward Payton KTX station in 5 minutes' time, in front of the hotel, we are providing a bus shuttle that will head toward the station. And those of you who are participating in tonight's dinner,